During the Vacant position ತಗೊಳಕ್ಕೆ.
Adjournments, page wise. Page 1, still number 1 and 2. Page 2, still number 3 to 9.
Serial number 3. Serial number 3 appear for the petitioner. Today they have sent an index with only the index by email, my lord. The documents are not there, saying that there is a representation by the union and also notice of term. I will collect those documents. You last may kindly have it next week, my lord.
30th.
Much obliged.
There was 3 alwa.
Oh, sir. Sir, ಅದರಲ್ಲಿ ಬರೀ ಇಂಡೆಕ್ಸ್ ಬಂದಿದೆ, ನಮಗೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಕು ಸರ್, ದಯವಿಟ್ಟು.
ಆಯ್ತು ಕೊಡೋಣ.
Please, sir.
30th March. Page 3, still number 10 to 16. Page 4, still number 17 to 24.
ಏನು ಪ್ರೆಸ್ ಮಾಡ್ತಾ ಇದ್ರು
Date
given response list
4.
ಒಂದ್ಸರಿ ನೋಡೋಣ ತಂದಾಗ ಏನಾಗಿದೆ.
Page 6, still number 25 to 29.
Serial number 27.
Response list
30th.
Serial number 27, your lordship.
54. 27.
Serial number 27. And I am seeking for 2 weeks time to file my statement of objection. I have not yet received the parawise from the respondent. I am appearing for respondent number 1 to 5.
He is not there.
Hanmantappa B. Harvik order.
Whether they have sought any interim order?
No interim order is sought, your lordship.
as requested by response counsel. List date and ಯಾಕಂದ್ರೆ ಅವ್ರು ಬಂದ್ ಮಾಡ್ತಾರೆ
4.
Obliged.
Page 7, cell number 30 to 36.
and 31. Requested by response counsel 2009 is finally
31, no, 29.
29
So 2017.
36
ಅದು 6-4.
as requested by 36 as requested by special counsel placement 6.
Page
Yes. Anand, he was there. 34, sorry. Both submit that there is chance of settlement and seek time. List down. 10 days become
11-4.
11. Chalo. Right, chalo.
Page 8, cell number 37. Roberts, cell number 1.
ಅಲ್ಲ ಅಶ್ವತ್ಥಪ್ಪ ಅವರೇ, ಇದರಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇದ್ರಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ. ಪಿಟಿಷನ್ ನೀವು ಈ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇಲ್ಲ ಇದ್ದಿದ್ರೆ ಹೇಗೆ ಹೇಳ್ತಾ ಇದ್ರ. ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಅಡ್ರೆಸ್ ಫಾರ್ ದ ಸರ್ವಿಸ್ ಆಫ್ ಸಮನ್ಸ್ ಈಸ್ ಸೋ ಅಂಡ್ ಸೋ 4-5 ಸರಿ ಇದು ಅವ್ರ ಹೆಸರಲ್ಲಿ ಲಿಸ್ಟ್ ಆಗಿದೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಬಂದ್ ಹೇಳ್ತಾರಲ್ವಾ ಅವ್ರದೇ ಆಗಿದ್ರೆ. ಏನು ದಿಸ್ ಇಸ್ ನಾಟ್ ಫೇರ್ನೆಸ್ ಅಲ್ಲ ಅದು. ನಿಮ್ದಲ್ಲ ನಾವ್ ಹೇಳ್ತಿರೋದು, ಇಲ್ಲಿವರೆಗೂ ನಡೆದಿರೋದು.
I don't want to disclose anything what will happen early in a previous background. That is why I always request to the court saying that this is a really heinous than this crime which is done.
This action was filed. Name of an advocate who has disability to appear before this. Other advocate by name M. Krishnegowda then files a memo for withdrawal saying that he had filed the petition and by typographical error anta ಹೇಳ್ತಾರೆ. By typographical error, the name of the advocate who has the disability kept in the petition. The records show that the petition was listed before this for several times. The name of the advocate was a disability, but he did not come forward. He did not come forward. He did not. But no, he reported that petition is filed by some other advocate in the name of the advocate having disability. In the petition, in the first paragraph of the petition, the name of the advocate for service is clearly shown. Even the registry had not raised, even the registry. One advocate cannot file the petition on behalf of another advocate as he is agent. That was the case, even registry would have raised the objections. It appears later the words word into inverted comma for not complete advocate for the petitioner is interpolated. in the first page, first paragraph, the name of the advocate, address for service, even in the memo of appearance, the enrollment number, address of the advocate who has the disability issue, email ಕೂಡ ತೋರಿಸ್ತಾರೆ. ಬೇಡ ಬೇಡ ಇದು ಕೆಳಗಡೆ ಹೇಳೋದ್ರ ಕೆಳಗೆ it appears prima facie something is amiss in the matter. Therefore, Registrar Judicial shall hold an inquiry into the matter. Now, Muntaga, the next paragraph. Now, Shri Ashwathappa, K. Ashwathappa, hello, jail superintendent, ಅದಕ್ಕೆ ಸೈನ್ ಆಗಿರೋದಿತ್ತಲ್ಲವೇ. Shri D. Ashwathappa, Karnataka Council, has filed Wakalat for the petitioner. It is attested by the Assistant Superintendent of Central Prison, Bangalore. The circumstances, the disability of the matter ceases. ಏನು ಮಾಡ್ತೀರಿ ಇದರಲ್ಲಿ? You are pressing this matter or other matter? There are two. You are going to argue in this matter.
Yeah, in the second one.
Second one. So this even now you are ಇದರಲ್ಲಿ ನಿಮ್ದು withdrawal memo ಇರಲಿಲ್ಲ, ಬರೀ ವಕಾಲತ್ ಅಷ್ಟೇ ಇತ್ತು. ಅದಕ್ಕೆ he submits this memo for withdrawal of this petition. Regarding the memo, petition dismissed as withdrawn. Let the Registrar Judicial hold an inquiry. ಯಾರನ್ನೋದನ್ನ ಸೇರಿಸಿದ್ದಾರೆ ಅದರಲ್ಲಿ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಹಾಗೆ ಯಾರಾದ್ರೂ ಒಬ್ಬರೇ ಅಡ್ವೊಕೇಟ್
I have also undergone a lot of your lordship directed me. That is why I keep on coming and saying some other way. But so that will not materialize. But even then,
where is ನೋಡಿ, ಒಬ್ರು ಪಾರ್ಟಿಗೆ ಇನ್ನೊಬ್ರು ಏಜೆಂಟ್ ಆಗಿ ಅಪಿಯರ್ ಆಗ್ಬೋದು, ಒಬ್ರು ಅಡ್ವೊಕೇಟ್ಗೆ ಇನ್ನೊಬ್ರು ಅಡ್ವೊಕೇಟ್ ಏಜೆಂಟ್ ಆಗಿ ಅಪಿಯರ್ ಆಗಕ್ ಆಗೋದಿಲ್ಲ.
we are for a justice for litigants.
ಸರಿ, ನೆಕ್ಸ್ಟ್ ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ. ಅದು ಮೊದಲು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಓವರ್ ಮೇಡಮ್. Allowing counsel for the petition submits that petition 2020. Counsel for the petitioner ಅಂತ ಹೇಳಿ criminal petition number 4241 of 2020 is disposed of as not pressed in view of the memo of the counsel who subsequently. Therefore, office objection does not survive and disposed of accordingly. ಆಯ್ತು, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹೋಯ್ತು. ಇನ್ನೇನೇನು ಆಫೀಸ್ ಇವ್ರಿಗೇನು SPP ಅವ್ರು ತಗೊಂಡಿದ್ರ ಸರ್ವ್ ಆಗಿದೆಯಾ? SPP ಅವ್ರ ಆಫೀಸ್ ಇವರ ಪ್ರೆಸೆಂಟ್ ಅಲ್ಲ, ನೀವು ತಗೊಳ್ತೀರಾ? ಯಾರು ತಗೊಳ್ತಾರೆ ನೋಟಿಸ್ ಅಲ್ಲಿ? ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ನೀವು ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ ಕಾಪಿ? ಅಡ್ವಾನ್ಸ್ ಕಾಪಿ ಸರ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ರು. ಆಯ್ತು, ಬಂದು ಕರೆಸ್ತೀನಿ. ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತೀವಿ, ಇಲ್ಲಾಂದ್ರೆ ಇನ್ನೊಂದು ದಿವಸ ಅಲ್ಲ, ಅವ್ರಿಗೆ ಕೇಳ್ಬೇಕಲ್ಲ ಅವರು.
I appear for the respondent in this case, my lord. Lord, in this case, I have filed a memo reporting the death of R1A.
Statement of objection.
I complained office objection within a week, my lord.
Office objection.
Office
So
objection.
whether Respond number 1 is survived by the other respondents or
Not other respondents, my lord. There are other legal aids, my lord.
then you have to bring them on record.
Yes, my lord. The appellant has to bring them on record, my lord. I am for the respondent. I only filed the memo regarding the death.
Yes. Yes, you have to bring the LRs of respond number 1A on record. Request, 10 days time is granted to do the report. You can comply with 10 days time.
Much obliged.
ಅವ್ರು ಇಲ್ವಲ್ಲ ಇದಾರ ಅವ್ರು ಅಶ್ವಥಪ್ಪ ಅವ್ರು ಇದಾರ ಆಯ್ತು ಅವ್ರಿಗೆ ಅವ್ರು ಬಂದಿಲ್ಲ ಆಯ್ತು ಅವ್ರು ಇಲ್ಲ ಅವ್ರು ಇದ್ದಾಗ ನೀವು ಬರ್ಲಿಲ್ಲ ನೋಡೋಣ ನಿಮ್ಮ ಅವ್ರ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಮಾಡೋದು ಬೇಡ ಇಲ್ಲೇ ಎಲ್ಲರೂ ಇದ್ರೆ ಕರ್ಕೊಂಡು ಬನ್ನಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ 2:30 tomorrow we will not sit. ಸರಿ ಅಲ್ರಿ ಅವ್ರಿಗೆ ಒಂದು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ನೀವು ಅದು ಮೊದಲೇ ಎಷ್ಟು ಕಾಂಟ್ರವರ್ಸಿ ಆಗಿದೆ ಅದರಲ್ಲಿ ಪಾಸ್ ಅವರ್ ಆಗಿದಿಲ್ಲ ಅಂದ್ರೆ ಕಮ್ಮಿ 2:30 ಮತ್ತೆ ನಿಮ್ ಕೊಲಿಗೆ ಹೇಳಿದ್ರು ಅವ್ರ ಸರ್ವಿಸ್ ಆಗಿದೆ ಅಂತ ಈಗ ನೀವು ಹೇಳ್ತಾ ಇದ್ರಿ ಯಾವ್ದಕ್ಕೂ ರೆಡಿ ಇರೋದಿಲ್ಲಲ್ಲ ಅವ್ರ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ನಾವು ಅಡ್ಜಸ್ಟ್ ಮಾಡೋದಿಲ್ಲ ಈಗ ಅದೇ ಈಗ ಯು ಆರ್ ಇಂಟರಪ್ಟಿಂಗ್ ಅವರ್ ಲಿಸ್ಟ್ ಆಯ್ತು ಬೇಕಾದ್ರೆ ಅವ್ರು ನೀವು ಕೇಳಿ ಅವಾಗ ಬಂದಾಗ ಎಸ್ your part you have filed this early hearing in 2002 2009 matters are pending. As requested this one 7-4 this is a matter of 2014 matters from 2002 are still pending. Therefore, list for final hearing on 11-4 IA number 1 of 2022 will be disposed of accordingly.
Number 6.
I appear for the petitioner, my lord, petitioner's counsel. Lord, this is a matter where a medical representative has been terminated without an inquiry. With a stigma.
This is only for posting 2006.
Your lordship may post it any date after.
Ready, your lordship. Any date may be granted.
It's a short point, my lord, which is involved. Your lordship will consider it.
It's on 18-4.
18-4, my lord, will be the other. ಸ್ವಲ್ಪ earlier ಹಾಕಿದ್ರೆ ಒಳ್ಳೆದಿತ್ತು.
You have 2002, 2009, 2012 matters.
I bow to your lordship, but ಇದು ಸ್ವಲ್ಪ ಬೇಗ ಮುಗಿಸ್ಬಿಡ್ಬಹುದು ಅಂತ ಅದಕ್ಕೆ.
ಅಲ್ಲ ಏನದಕ್ಕೆ ಅಂತ ಸ್ಪೆಷಲ್ ಸ್ಟೇಟಸ್ ಇದಕ್ಕೆ
ಸ್ಪೆಷಲ್ ಸ್ಟೇಟಸ್ ಟರ್ಮಿನೇಟ್ ಆಗಿ ಸುಮಾರು ದಿವಸ ಆಯ್ತು ಅದಕ್ಕೋಸ್ಕರ
ಕೇಸಸ್ ಹಾಗೆ ಇರುತ್ತೆ
ಅದ ಟ್ರೈಬ್ಯುನಲ್ ಇಂದ ಬಂದ ಮ್ಯಾಟರ್ ಹಾಗೆ
12-4
as your lordship pleases. I appear for the respondent. In this case, my lord, there is a direction to pay 17B wages. They have not been paying it, my lord, for the last 2 years.
Is that correct?
Last 2 years, they have not paid.
The response submits that the wages some order was passed here.
Yes.
Order was passed.
Yes, order was passed. They paid it, my lord, for some time. Then, my lord, for last 2 years, they completely stopped.
That response 2 to 7, huh?
So the petition has to be dismissed.
That the petitioner has not complied the order of this court for payment of wages under section 17B of the Industrial Disputes Act. The proceed for the petitioner seeks time to Take instruction. It's a final chance. List on for final hearing. For final hearing, is when you have filed. When have you filed? Okay, 2020 has been mundindu. This is filed in 2020. Thereafter, if you have paid, you submit the proof of that. For final hearing, list on. I think date for the hearing is 13/4, 18/4.
18/4.
IA1 of 2022 disposed of accordingly.
Number 8. Vintage Copperton.
Appearing for petitioner in this case, Your Honor. Your Lordship, the matter was been dismissed on 14/7/2021, Your Lordship, for non-compliance.
14/7/2021.
ಹೌದು ಸ್ವಾಮಿ.
ಎಲ್ಲಿ ರೇಣುಕಾ ಅವರು?
ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ. So I have complied office
These IA copies are served on.
Yes, Your Lordship. Yes, Your Lordship. Both the IAs have served and the petition also served on respondent, Your Lordship.
ಈಗ ಇಬ್ಬರಿದ್ದಾರೆ, BL ಸಂಜೀವ್ and HR ಅಂತ.
I have furnished a copy also, Your Lordship, on serving on respondent.
Third, considering the reasons assigned, explain the delay and the lapses. The delay of days in delay ಬರುತ್ತಾ ಇದು ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಆಗಿದ್ರೆ there was some exemption.
Yes, Your Lordship, but still I have filed, Your Lordship.
Okay. 2 of 2021 is condoned. Order dated
14/7/2021, Your Lordship.
14/7/2021, dismissing the petition is hereby recalled. The matter is restored to the file. File number 1 and 2 of 2021.
Inquiry is pending, Your Lordship. Any short date may be given, Your Lordship. Interim prayer ಇದೆ ಸ್ವಾಮಿ.
Please on.
May I make one request in this matter? Mr. BL Sanjeev's name may be deleted in this matter. Madam is appearing. Renuka Madam is appearing.
Beginning number. Since Srimati HR Renuka has appeared for the respondent, registry shall show only her name in the causes for the respondent henceforth. All right.
Much obliged.
Number 9. Yes, Nirmala.
And for the petitioner, they have filed an application for 17B. Last time only have made a submission that we will take him into service and he has to submit his latest driving license and fitness, my lord, that he can go and meet the corporation concerned division. They will tell him that what documents he has to bring. We are ready to take him for the service, my lord, subject to the result of the writ petition.
What do you say?
Last time ಅವರು ಒಪ್ಕೊಂಡಿದ್ದು ಸಮಯ ಆಮೇಲೆ ನಾವು
ನೀವು ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ವಾ ಹೋಗಿ? Counsel for the petitioner on instruction submits that petition is ready to reinstate respondent in compliance with the order of the tribunal subject to the result of this petition. Counsel for respondent submits that without prejudice his rights to claim mentioned in IA1, he is ready to join to report about reinstatement.
ಅದೇ ಸಮಯ ಸರ್ವಿಸ್ ತಗೊಂಡಿರ್ತೀವಿ, ಕರೆಂಟ್ ವೇಜಸ್ ಪೇ ಕೊಟ್ಬಿಟ್ಟು subject to the writ petition result, we will take it.
Wait, let him submit. Yes, whether he has gone and reported. Order. Who has to write that letter? Department. He says he has not issues. Why the court order is there? Why do you want a requisition? You can go and report. We'll fix a date. Ask him to go and report.
ಅದರಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬೇಕಾಗತ್ತೆ ಸಮಯ, ಯಾಕಂದ್ರೆ ಡೈರೆಕ್ಷನ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ ಇಸ್ ದೇರ್ ಅನ್ನೋದು ಇಂಪಾರ್ಟೆಂಟ್. If lordship gives a direction on the order sheet, That order sheet.
To report about reinstatement ಅಂತ ಮಾಡಿದೀವಿ ಅದು ಆರ್ಡರ್ ಅಲ್ವಾ?
ಆಯ್ತು, ಅದ್ರದ್ದು ಕಾಪಿ ತಗೊಂಡು ನಾವು ಕಳ್ಸಿಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ. ಅವ್ರಿಗೂ ತಗೊಂಡು ಹೋಗಕ್ಕೆ ಹೇಳಿ ಸ್ವಾಮಿ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. Let him also take the certified copy of that order, and then I will also send a mail.
ಏನೀಗ ಅದು ಇದು ಇಲ್ದೇನೆ ತಗೊಳ್ಳೋದಿಲ್ಲ, ರಿಪೋರ್ಟ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇಲ್ದೇನೆ ತಗೊಳಕ್ ನಮಗೆ ಬರೋದಿಲ್ಲ, ಪವರ್ ಇಲ್ಲ. ಯಾಕಂದ್ರೆ we have filed a writ petition.
ಆರ್ಡರ್ ಇದೆ, it was your submission, it was your concession. To report about reinstatement ಅಂತ ಇಲ್ಲಿ ನಾವು ಬರ್ದಿದೀವಿ.
ಆ ಫೈಲ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, ಕಾಪಿ is needed. I'll apply copy and let him.
ಅದನ್ನ ನಾವೇ ನಿಮ್ ಕೈಗೆ ತಂದು ಕೊಡ್ಬೇಕಾ?
ನಾವು ಅಪ್ಲೈ ಮಾಡ್ತೀವಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವೊಂದು
every day the orders are being uploaded. This order is passed on 8/3/2022.
I'll take care of that.
Today
ಸ್ವಾಮಿ ಅವ್ರು ಮಾಡ್ತೀನಿ ಅಂದ್ರು ಮಾಡಿಲ್ಲ. ತಾವು ಅವ್ರಿಗೆ ಟೈಮ್ ಕೊಟ್ರಿ ಹೋಗಿ ರಿಪೋರ್ಟ್ ಮಾಡಿ.
ಆಯ್ತು, ಹಾಗಾದ್ರೆ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ ನಾವು.
ನಾವು ರಿಪೋರ್ಟ್ ಮಾಡಕ್ ಹೇಳಿದೀವಿ, ಅವ್ರು ಬಂದಿಲ್ಲ. ಅವರು ಇದು ತಗೊಂಡ್ಬರ್ಬೇಕು, ಫಿಟ್ನೆಸ್ ಸರ್ಟಿಫಿಕೇಟ್, ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಎಲ್ಲ ತಗೋ. ಯಾಕಂದ್ರೆ ಆಫ್ಟರ್ 8 years now he is before this court. ಅದಕ್ಕೋಸ್ಕರ
respondent submits that he was not permitted, respondent was not permitted to report to duty on that the order copy was not there. Order was passed on 8/3/2022. Lord counsel for the petitioner should have directed the petitioner properly. Directed, instructed the petitioner. The respondent shall appear before the petitioner with his driving license and
ಫಿಟ್ನೆಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಬೇಕಾಯ್ತು. ಯಾಕಂದ್ರೆ 8 years ಆದ್ಮೇಲೆ ಅವ್ರು ಇನ್ನೂ ಡ್ರೈವಿಂಗ್ ಮಾಡ್ತಾ ಇದಾರೋ ಇಲ್ವೋ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಅದು ಎಸ್ಪೆಷಲಿ ಹೆವಿ ವೆಹಿಕಲ್ ಬಸ್ ತಮಗೂ ಗೊತ್ತು, ಪ್ಯಾಸೆಂಜರ್ಸ್. ಅದಕ್ಕೆ he has to take his fitness certificate and driving license latest, whether it is there renewed or not.
ನೀವೇ ಕಳಿಸಿ ಡಾಕ್ಟರ್ ಹತ್ರ ಅವ್ರನ್ನ ಫಿಟ್ನೆಸ್ ಗೆ. Why should he produce the fitness certificate?
ನಮ್ದೇ ಹಾಸ್ಪಿಟಲ್ ಇದೆ, ಕಾರ್ಪೊರೇಷನ್ ಹಾಸ್ಪಿಟಲ್ ಹೋಗಿ he has to get.
ಅಲ್ಲಿ ಕಳಿಸಿ ನೀವೇನೆ. ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಮಾತ್ರ ತಗೊಂಡೋಗಿ ಅಪಿಯರ್ ಆಗ್ಲಿ ಅವರು.
ಆಗ್ಲಿ, ಅಲ್ಲಿ ಹೋಗ್ಲಿ ಸಮಯ ಹೇಳ್ತಾರೆ.
Driving license
on for the petition on this ರಿಟ್ ಪಿಟಿಷನ್ ಕಾಪಿನೇ ಕೊಟ್ಟಿಲ್ವಾ ನೀವು? ಇದು ಯಾವ ಇಯರ್? 2000
ಕೊಟ್ಟಿದ್ದೀನಿ.
ನೀವು 2021 ಈಗ ಹೇಳ್ತಾ ಇದಾರೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ನೋಡಿ 2021ರಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನು ನೀವು ಹೇಳಿಲ್ಲ, ಇಲ್ಲೇನು ನಾವು ರೆಕಾರ್ಡ್ ಮಾಡಿಲ್ಲ ಅದನ್ನ. ಐ ಹ್ಯಾವ್ ಅಪಿಯರ್ಡ್ even before that, appeared in person, submits that matter may be listed on 8/3/2022. ಅಂದ್ರೆ ಒಂದು ಹೇಳಿ ಆಯ್ತು, ಅವ್ರ ಹತ್ರ ಹೇಳಿ ಒಂದು ಕಾಪಿ ಇಸ್ಕೊಳ್ಳಿ. ಫರ್ನಿಶಿಂಗ್ ಮೈ ಕಾಪಿ, ಒಂದು ಕಾಪಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
ಆಯ್ತು ಆಯ್ತು.
ಇಂಥದ್ದೆಲ್ಲ ಎಷ್ಟು ಕಷ್ಟದ್ರಿ, ಅವ್ರಿಗೊಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಒಂದು ಕಾಪಿ ತಗೋಬಹುದು ನೀವು. ಈಗ ಏನ್ ಮಾಡೋದು, ನಾವು ಕನ್ವಿನ್ಸ್ ಪ್ರೊವೈಡ್ ಮಾಡ್ಬೇಕಾ ನಿಮ್ಗೆ? ಈ ತರ ಸಿಲ್ಲಿ
Respondent shall appear before the petitioner with his driving license on
date next week 30/3/2022. The petitioner shall subject to the driving license being in order, the petitioner shall reinstate him forthwith on his appearance. List on date 5/4.
Number 10.
Is that court order is passed? Accepts notice for respondent 1. He submits that copies are sworn and registration show is there. You appear for whom? Serial number 9 plan. Yes. Oh, this is land acquisition. No, yes. You have whether you have filed statement of objection if any to this. File ಮಾಡಕ್ಕಿದೆ ಇಲ್ವಾ? Is it covered by any other judgment? He has produced one more Supreme Court judgment. Is it arising out of same notification? Same notification ಆದ್ರೆ ರಿವ್ಯೂ ಬರುತ್ತೆ, ಬೇರೆ ಯಾವ್ದೋ ಕೇಸ್ ಆದ್ರೆ ಹೇಗೆ ಬರುತ್ತೆ? ಅವ್ರ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅಲ್ಲ, ಇದ್ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ, ಯಾವ್ದು ನಾಗೋಜಿರಾವ್ ವರ್ಸಸ್ ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್ ಒಂದು ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲಿ ಕಾಪಿ? Is it whether that case was with regard to the same notification? Is it a notification of that? ಅವ್ರಿಗೆ ಕೊಡಿ ಕಾಪಿ. 24th of January. ಇಲ್ಲೇ ಯಾವ್ದೋ ಕೆಲವೊಂದು ಇದೆ, ಬಟ್ ದಟ್ ಇಸ್ ನಾಟ್ ಆನ್ 24th January. ಕರೆಕ್ಟ್ ಕೊಟ್ಟಿದೆ. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ ಅವ್ರಿಗೆ? ಕಾಪೀಸ್ ಕೊಡಿ ಅವ್ರಿಗೆ. ನೋಡಿ, ನೀವು ಇಫ್ ಯು ವಾಂಟ್ ಟು ಅಪೋಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋದಿದ್ರೆ ಹಾಕಿ, ಇಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಹಿಯರಿಂಗ್. Standard AC 6 time. Take instruction. Pattern. PV Prakash Angadi, you are for R2. You are the last time or 8th idru. Correct. You barbekalla. At least in between you should collect the records. As report. 6 times to take instructions and to find the counter. This on 2 ವಾರ ಬಿಟ್ಟು 5-4. This RP is filed in 2017.
Could I appear for Ms. Rajaram, Milord? Now, so the central government and state government both have been made parties. Now, I do not know whether they have filed objections or they intend filing objections.
You intend to file objection. Last time you
Last time I was not served a copy of the petition. Thereafter they served a copy of the
government application interim. They were implemented on an application. Where is the review petition?
On 29/11/2021, they have been implemented.
Yes, sir. No, he is ready. Central Government Standing Council is ಅಲ್ಲ, ನೀವು ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗೋದು ಇದರಲ್ಲಿ? ನಿಮ್ಮ ಹೆಸರು 10 ASC. AGA for R6 to 9, ASC for R10, AGA for R11 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ASC Right now, copies are served on you. If you want to say anything in the matter, you can file a statement. Learned ASC, takes time for counter. File a statement. File a statement. List on date 6/4. 6/4 and
But in the meantime, let there be an interim stay, my lords. Otherwise, they will enforce that order against me.
See, he is saying the really affected party is R1 to 5. He is pressing for hearing actually. What is the error? Is it on the ground of error apparent on the face of record?
Yes, my lords. Yes, my lords.
Is the order passed? Writ of mandamus. Appellate authority not to insist statutory deposit pertaining to respondents. When writ petition stands dismissed, reserving liberty to the petitioner to comply. Section 7(7) Payment of Gratuity Act. What is? Yes, you have filed the appeal now here. What is the amount determined? What is the amount determined?
Amount determined.
There are around 6 employees who are all retired who have not been paid gratuity. As per 7/7, whatever the controlling authority has passed an order, may not after considering what is the amount of gratuity to be paid. That is mandatorily be deposited before.
Hearing. Appears his ground is that in a charitable institution.
Kindly see, my lords, that page I have.
6/4.
Much obliged.
Interim order was to reinstate him. Interim order in a reinstate madam. Four 2019 ತಗೊಂಡಿದ್ದಾರೆ. Now how is his medical condition? So you will permit him to report to duty? Okay. You. This was after filing this petition only. With this ulcerative colitis ಅಂತ ಇತ್ತು ಆ ಕೇಸ್ ತಾನೆ ಭಂಡಾರಿ ಅವರು. ನಿಮಗೆ ಅದು ಏನು ಅಂತ ಗೊತ್ತಿದೆ ಆ ಡಿಸೀಸ್? ಅವ್ರನ್ನ ಇಲ್ಲಿಂದ ಮೆಡಿಕಲ್ ಬೋರ್ಡಿಗೆ ಕಳ್ಸೋಣ. ಆ ಡಿಸೀಸ್ ಏನು? ಕ್ರಾನಿಕ್ ಡಿಸೀಸ್. ಏನ್ ಮಾಡ್ತಾರೆ ಅದಕ್ಕೆ? ಬರೀ ಒಂದು ಕೊಲೋನೋಸ್ಕೋಪಿ ಮಾಡ್ತಾರೆ, ಮಾಡಿದ್ರೆ ಅಷ್ಟೇ. ಆಯ್ತು, ಈಗ ಅವ್ರಿಗೆ ಕಳ್ಸೋಣ. ಅವ್ರೀಗ ಅವ್ರ ಎಂಗ್ಸೈಟಿಯಲ್ಲಿ ಏನಪ್ಪ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಿತ್ತು ನಿಮ್ಗೆ? ಏನಾಗ್ತಿತ್ತು ನಿಮ್ ಸಮಸ್ಯೆ? ಏನು ಆರೋಗ್ಯ ಸಮಸ್ಯೆ ಏನಿತ್ತು ನಿಮ್ಗೆ? ಅಲ್ಸರ್ ಇತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ ನೋಡಿ. ಆಯ್ತು, ಬ್ಯಾಕ್ ಬೇಸಿಸ್ ಕೊಡ್ಬೇಡಿ, ನಿಮ್ಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ಎರಡೂನು. ಈಗ ನೀವು ಹೋಗಿನೇ ಒಂದ್ ಸರ್ಟಿಫಿಕೇಟ್ ಗವರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಅದನ್ನೆಲ್ಲ ತಗೋಬೇಕಂದ್ರೆ ಎಷ್ಟು ಕಷ್ಟ ಇದೆ. ನಾಟ್ ಓನ್ಲಿ ಗವರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್, even in the private hospitals, they are not giving this. Some of the private hospitals ಅವ್ರು ಇದು ಕೊಡೋದಿಲ್ಲ. ಈ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿರ್ತಾರಲ್ಲ ಅವ್ರ ಹತ್ರನೇ ಅಂತಂದ್ರೆ ಅದು ತಗೋಬೇಕು ಅಂತಂದ್ರೆ ಮತ್ತೆ they have to pay for that. Some of the hospitals. ಆಯ್ತು, ಈಗ ಬ್ಯಾಕ್ ವೈಸಸ್ ಕೊಡ್ಬೇಡಿ, ರೀಇನ್ಸ್ಟೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನೀವು ಇಷ್ಟು ಭಂಡಾರಿ ಬರೀ ಇದನ್ನ ನೋಡಕ್ ಹೋಗ್ಬೇಡಿ, ಸ್ವಲ್ಪ ಹ್ಯುಮ್ಯಾನಿಟೇರಿಯನ್, ಬರೀ ಲಾ ನೋಡ್ಬೇಡಿ, ಲಾ ಜೊತೆಗೆ ಒಂಚೂರು ಬೇರೆದನ್ನು ನೋಡ್ಕೊಳ್ಳಿ. ಆಯ್ತು, ಆರ್ಗ್ಯೂ ಮಾಡುವಾಗ ನೀವು ಮಾಡಿ. ಈಗ ಟ್ರೈಲ್ ಆಯ್ತು, ನೀವು ಇಫ್ ಎಟ್ ಆಲ್ ಹಿ ಡಸ್ ದಟ್ ಅಗೇನ್ ಯು ಕ್ಯಾನ್ ರಿಮೂವ್ ಹಿಮ್ ಫ್ರಮ್ ಸರ್ವಿಸ್. ನಾವು ನಿಮ್ಮ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಓದಿದ್ದೀವಿ. Party is directed to reinstate the first party with continuity of services and all other consequential benefits without back wages.
So back wages, the back wages is not the punishment. It's not the punishment. So at least the 5 increments cut ಮಾಡಿ.
ನಿಮಗೆ ಇಷ್ಟು ವರ್ಷ ನೀವು ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಳಕ್ ಹೋಗೇ ಇಲ್ವಲ್ಲ? ಅವರೆಲ್ಲ ನಿಮ್ಮಂತ ಇಲ್ಲಿ ಹಾಕಿದಾರ, ಇದ್ರಲ್ಲಿ ಈ ಕೇಸಲ್ಲಿ ಹಾಕಿದಾರ ಸರ್. ಒಂದು ಯು ಹ್ಯಾವ್ ಟು ಬಿ ವೆರಿ ಪ್ರಾಕ್ಟಿಕಲ್. ನಿಮ್ಮಷ್ಟು ಕಾನ್ಫಿಡೆಂಟ್ ಇರೋ ಲಾಯರ್ ಅನ್ನು ಅವ್ರಿಗೆ ಎಂಗೇಜ್ ಮಾಡ್ಕೊಳಕ್ ಆಗೋದಿಲ್ಲ. ನಿಮ್ಗಿಂತ ಅಂದ್ರೆ ಬರೋರು ಸುಬ್ಬಾರಾವ್ ಅವರು, ಶ್ರೀನಿವಾಸ್ ಅವರು, ಯಾರೋ ಒಂದ್ 4 ಜನ ಬರ್ತಾರೆ. ಶೇಖರ್ ಅವರು, ಬಟ್ ಏನ್ ಮಾಡೋದು, ಬಟ್ ಹಿ ಇಸ್ ನಾಟ್ ಅಸಿಸ್ಟೆಡ್ ಬೈ ದಟ್ ಕೈಂಡ್ ಆಫ್ ಲಾಯರ್. ಅದು ಕಂಡೀಷನ್ ತುಂಬಾ ಕ್ರಿಟಿಕಲ್. ದಟ್ ಇಸ್ ಅ ವೆರಿ ಕ್ರಾನಿಕ್ ಡಿಸೀಸ್. ಅದರಲ್ಲಿ ಅವ್ರು ಹೇಳ್ತಾರೆ, ಈಗ ಪಾಪ ಅವ್ರಿಗೆ ಅದರಲ್ಲಿ ಅಲೋಪತಿಯಲ್ಲಂತೂ ಅದಕ್ಕೆ ಟ್ರೀಟ್ಮೆಂಟೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಆ ಮೆಡಿಸಿನ್ಗೆ ದಿಸ್ ಕೈಂಡ್ ಆಫ್ ಡಿಸೀಸ್ ದೇ ಕೀಪ್ ಬ್ಲೀಡಿಂಗ್. ಅಲ್ಲ, ಅದಕ್ಕೆ ಮಾಡಿ ತಗೊಳ್ಳಿ. ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಆಯ್ತು, ಒಂದ್ ಯಾವ್ದೋ 2 ಇನ್ಕ್ರಿಮೆಂಟ್ ಏನೋ ಕಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. 2009 ಇಂದ ಇಲ್ಲ ಏನ್ ಮಾಡ್ತಿದ್ದೆ ಅಲ್ಲ. ಆಯ್ತು, ಇನ್ಕ್ರಿಮೆಂಟ್ಸ್ ಕಟ್ ಮಾಡ್ಕೊಂಡು ಇಫ್ ಈಸ್ ಫಿಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಸಬ್ಜೆಕ್ಟ್ ಟು ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಹಿಸ್ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಅಂಡ್ ಡ್ರೈವಿಂಗ್ ಟೆಸ್ಟ್, ಏನು ಬೆನಿಫಿಟ್ ಕೊಡಬೇಡಿ ಅಷ್ಟೇ. ಯಾಕಂದ್ರೆ ಇನ್ನೊಂದ್ರೆ ನಾವ್ ಹೇಳಿದಾಯ್ತು, ಈಗ ಮೆಡಿಕಲ್ ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ, ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಮಾಡೋದು. ಬಟ್ ಸಮ್ ಟೈಮ್ಸ್ ಇಟ್ ಸೋ ಹ್ಯಾಪನ್ಸ್ ಅವ್ರಿಗೆ ಅದು ಏನು ಲೀಗಲ್ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಗೊತ್ತಿರೋದಿಲ್ಲ, ಏನು ಗೊತ್ತಿರೋದಿಲ್ಲ. ಹಿಂದೊಂದು ಫ್ಯಾಮಿಲಿ ಇರುತ್ತೆ. ಅದೇ ಏನ್ ಮಾಡ್ತಿದ್ವಿ, ಎಲ್ಲೋ ಒಂದು ಹೋಗಿರ್ತಾರೆ, ಓಲಾಗಿಲ್ಲ, ಎಲ್ಲೋ ಕ್ಯಾಬಲ್ಲಿ ಡ್ರೈವ್ ಮಾಡೋದಕ್ಕೆ. ಯಾಕೆ ಇಷ್ಟು ವರ್ಷ ತಿರುಗಿ ಡ್ಯೂಟಿಗೆ ಹಾಜರಾಗ್ಲಿಲ್ಲ ನೀವು? ಮತ್ತೆ ಈಗ ಕೆಲಸ ಮಾಡಕ್ ಹೇಗಾಗತ್ತೆ? ಈಗ ಬ್ಯಾಕ್ ಪೇನ್ ಇದ್ರೆ ಈಗ ಕೆಲಸ ಮಾಡ್ತೀರಿ? ನಿಮ್ಗೆ ಅದೆಲ್ಲ ಸಂಬಳ, ಕಂಟಿನ್ಯೂಟಿ ಆಫ್ ಸರ್ವಿಸ್ ಎಲ್ಲ ಕೊಡಕ್ ಆಗೋದಿಲ್ಲ. ಈಗ ಫ್ರೆಶ್ ಆಗಿನೇ ಹೋಗಿ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೋಬೇಕು. ಒಳ್ಳೇದೆ. ನೀವು ಸಪೋರ್ಟಿಂಗ್ ಮೆಡಿಕಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಈಗಾದ್ರೂ ಕೊಡ್ತೀರೇನ್ರಿ? ನೀವು ಹಾಗೆ ಇದ್ದೀರಾ. ಈಗಾದ್ರೂ ಏನಾದ್ರೂ ಅವ್ರ ಕೊಲೋನೋಸ್ಕೋಪಿ ಟೆಸ್ಟ್ ರಿಪೋರ್ಟ್ ಏನಾದ್ರೂ ಕೊಡ್ತೀರಾ? Agreeable for that, he has produced so many Supreme Court judgments. The clinic.
An absent employee cannot be granted leave on the basis of example.
ಅದು ಕರೆಕ್ಟ್. ಮೋಟರ್ ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸು ಅದೆಲ್ಲ ಆದ್ರೆ ನಾವು ಇನ್ಸಿಸ್ಟೇ ಮಾಡ್ತೀವಿ. ಹ್ಯಾವಿಂಗ್ ರಿಗಾರ್ಡ್ ಟು ದ social background of the parties, sometimes ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ಅಂದ್ರೆ ಒಂದು ಏನೋ ಜಸ್ಟಿಸ್ ಆಗುವಂಥದ್ದು ಪ್ರೊವೈಡೆಡ್. ಅದಕ್ಕೆ ನಾವ್ ಹೇಳಿದ್ವಿ ಈಗಾದ್ರೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಾ ಅದು ಆ ಡಿಸೀಸ್ ಇದ್ರೆ ಅವ್ರಿಗೆಲ್ಲ ಏನೋ ಕೊಲೋನೋಸ್ಕೋಪಿ ಎಲ್ಲ ಮಾಡಿರ್ತಾರೆ ಅಂತದ್ ಏನಾರ ರಿಪೋರ್ಟ್ ಇದೆ? ಏನ್ ನೀವ್ ಅಲ್ಲ ಅಂದ್ರೆ ಈಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ ನಿಮ್ಗೆ ಅಗೇನ್ಸ್ಟ್ ಇದಾವೆ ಅಲ್ಲಿ. ಇಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿತ್ತ ರೀಇನ್ಸ್ಟೇಟ್ ಅಲ್ಲ ಅಲ್ಲಿ ಇಲ್ಲಿ ಸ್ಟೇ ಇತ್ತ ಅಲ್ಲ ಸ್ಟೇ ಕೊಡ್ಬೇಕಾದ್ರೆ ಎಂಟ್ರಿ ಮಾಡ ಸಬ್ಜೆಕ್ಟ್ ಟು ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತ ಆಗಿತ್ತು. ದಟ್ ವಾಸ್ ಇನ್ 2018 ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡೋ ಸಬ್ಜೆಕ್ಟ್ ಟು ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತ. ಮತ್ತೆ ಯಾಕೆ ಹೋಗಿಲ್ಲ ಅವರು? ಇಲ್ಲಿ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದು ಹೇಳ್ಬೋದಿತ್ತಲ್ಲ. ಈಗ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಮಾಡಿದ್ವಿ, ಅವ್ರು ರಿಪೋರ್ಟ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋದಿಲ್ಲ ಅಂದ್ರೆ ಕೋರ್ಟ್ ಮುಂದೆ ಹೇಳಿದ್ರೆ in another matter we directed to appear on a particular date and to report that ಮಾಡ್ತಿದ್ವಿ. ಅದ್ರ ಬದಲು ನೀವೇ ಅಪಿಯರ್ ಆಗಿಲ್ಲ, ನನ್ ಅಪಿಯರ್ಸ್. ಅದಾದ್ಮೇಲೆ ನನ್ ಅಪಿಯರ್ಸ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡ್ ನನ್ನರ್ ಕೌನ್ಸಿಲ್. ಯು ಹ್ಯಾವ್ ನಾಟ್ ಅಪಿಯರ್ಡ್ ಸೆವರಲ್ ಟೈಮ್ಸ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್. ಮ್ಯಾಟರ್ ಕಾಲ್ಡ್ ಟ್ವೈಸ್, ನನ್ ಅಪಿಯರ್ಸ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್. ಇದನ್ನೆಲ್ಲ ನೋಡಿನೇ ನಾವು ಸ್ವಲ್ಪ ನೋಡಿ, ನನ್ ಅಪಿಯರ್ಸ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಷ್ಟು ಸಾರಿ ಕೋರ್ಟ್ ಮುಂದೆ ಅಪಿಯರ್ ಆಗದೇನೆ ಈಗ ನೀವು ಅದಕ್ಕಾದ್ರೆ ಐ ಆಮ್ ನಾಟ್ ಎಗ್ರಿಬಲ್ ಫಾರ್ ದಿಸ್ ದ್ಯಾಟ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ನಾನು ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪಿಟಿಷನ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ ಆಫ್ಟರ್ ದ ಎಂಟ್ರಿ ಮಾಡೋ ರೆಸ್ಪಾಂಡ್ ವಾಸ್ ಕಾಲ್ಡ್ ಅಪಾನ್ ಟು ರಿಪೋರ್ಟ್ ಟು ಡ್ಯೂಟಿ ಬಟ್ ಹಿ ಹ್ಯಾಸ್ ನಾಟ್ ಟರ್ನ್ಡ್ ಅಪ್. ಅವ್ರು ಕೊಡ್ತಾ ಇದ್ದಾರೆ, ಇಲ್ಲಿ ನಿಮ್ ಸಿಗ್ನೇಚರ್ ಇರೋದಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹಿಯರ್ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀವಿ. ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಗಳನ್ನ ಅಪ್ಲೈ ಮಾಡ್ಕೊಂಡು ನೋಡಿದಿರಿ ತಾನೇ? ಜಡ್ಜ್ಮೆಂಟ್ ಅವ್ರು ಕೊಟ್ಟಿರೋದನ್ನ ಓದಿದೀರಾ ಲಾಸ್ಟ್ ಟೈಮ್? ನಾವು ಪಾರ್ಟ್ಲಿ ಡಿಕ್ಟೇಟ್ ಮಾಡಿಟ್ಟಿದ್ವಿ ಅಂತ ಅನ್ಸುತ್ತೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಇಫ್ ಎನಿ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಬರ್ಲಿಲ್ಲ ನಾವು. ಕೇಳಿ, ಯುವರ್ ಕ್ಲೈಂಟ್ ವಿಲ್ ಬಿ ಬೆನಿಫಿಟೆಡ್ ಬೈ ದಟ್. ಆಯ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ. ಸರಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಆಯ್ತು ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ. ಹೂ ಶುಡ್ ಪ್ರಿವೇಲ್ ಗುಡ್ ಸೆನ್ಸಸ್ ಓವರ್ ದೆಮ್. ಎಸ್ ಆಯ್ತು, ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ, ನೀವು ಬರ್ಲಿಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್. ಅಟ್ ದ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆನ್ಸ್ ಕೌನ್ಸಿಲ್ ಲಿಸ್ಟ್ ಅನ್ನೋದಕ್ಕಿಂತ ಮೊದಲು ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದಾಗ ಅವಾಗ್ಲೇ ನಾವು ಫ್ಯಾಕ್ಟ್ಸ್ ಮರ್ತೋಗುತ್ತೆ ಅಂತ ಮಾಡಿಟ್ಕೊಂಡಿದ್ವಿ. Counsel for response submits that despite respondent reporting to duty, no work was allotted to him. He seeks time to submit the proof for reporting the duty. ಈಗ ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ಪ್ರೂಫ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಟೈಮ್ ತಗೊಂಡ್ರಿ. ವೇರ್ ಇಸ್ ದ ಪ್ರೂಫ್? Last time you took adjournment saying that you will produce the proof of he reporting to duty. ಅಲ್ಲ ರೀ, ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಮಾಡೋದಕ್ಕೆ ಬಂದಿದ್ದೀನಿ ಅಂತ ಏನಾರು ಬರೆಸ್ಕೊಂಡ್ ಬಂದಿದ್ದೀರಾ ಅವ್ರ ಹತ್ರ? ಹಾಗಂತ ಕೋರ್ಟ್ ಮುಂದೆ 2018 ಆರ್ಡರ್ ಆಗಿದೆ. ನೀವು ಒಂದ್ಸಾರಿ ಆದ್ರೂ ಅಪಿಯರ್ ಆಗಿ ನಾವು ಹೋಗಿದ್ವಿ, ಅವ್ರ ಪರ್ಮಿಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಕೋರ್ಟ್ ಮುಂದೆ ಏನಾದ್ರು ಅಪ್ಲಿಕೇಶನ್ ಮೆಮೋನ ಏನಾದ್ರು ಫೈಲ್ ಮಾಡಿದೀರಾ? 2018 to 2022. ಎಸ್ ಆಯ್ತು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. You had argued, you had said citations ಕೊಟ್ಟಿದ್ರಲ್ಲ. ಸೈಟೇಷನ್ಗೆ ಕೊಡೋದಿಲ್ಲ ಟೈಮ್. ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಇದೇ ಕೇಸ್ ಅಲ್ಲ, ಭಂಡಾರಿ ಅವರ್ ಕೋರ್ಟ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ 2006 ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಇನ್ನೊಂದು ಸಿಂಗಲ್ ಜಡ್ಜ್ಮೆಂಟ್. ಬಿಕಾಸ್ ವಿ ಹ್ಯಾವ್ ಕ್ಲೋಸ್ಲಿ ಸೀನ್ ಸಚ್ ಎ ಪೇಷಂಟ್. ನಮ್ಗೆ ಗೊತ್ತಿದೆ ಅದು ಏನಿರುತ್ತೆ ಅಂತ. ಹಾಗಿದ್ರೆ ಅದಕ್ಕೆ ಏನಾದ್ರೂ ಒಂದು ಹೆಲ್ಪ್ ಮಾಡಂತ. ಈಗ ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ವಿತ್ ಸರ್ವಿಸ್ ಬೆನಿಫಿಟ್ಸ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಆಯ್ತು, ನೀವು ಇದನ್ನ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿ you submit it along with the memo. Counsel for the petitioner submits memo with a copy of one document. Yeah, what is that? Your notice, copy of the notice to respondent to report to the duty. Said document, said notice, the notice dated the said notice is served on -- 2018 on the respondent. Response counsel does not produce any proof to show that the respondent reported to the duty after the interim order of this court dated 25/4/2018. Okay. ಆಯ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. His only contention was that you have not produced any clinical examination reports and doctor is not examined. Therefore, the tribunal committed error in relying on that judgment, on that document. Past history was not a part of the charge sheet. Now the regulation 25 another that comes only in the at the time of considering the quantum of punishment. Regulation number 25 judgment, but regulation number 20 court officer or KSRTC regulation. What is your name? ನೀವು ಇಬ್ರು ಅವರು ಒಬ್ರು
ಇದಲ್ಲ ಮೇಡಮ್ ಕಾಂಡಕ್ಟ್ ಅಂಡ್ ಡಿಸಿಪ್ಲಿನ್.
that period ನಾವು ಹಾಗೆ ಮಾಡೋದು ಅನ್ಕೊಳ್ಳಿ. previous service benefits ಅದೇ PF and other pension and other things ಅಷ್ಟು ಮಾಡ್ಕೊಡ್ರಿ. it will be benefited. Otherwise if you go on merit, continuity of service during this period of absence will not get. ಮೊದಲು ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಮಾಡಿದ್ದಾರೆ? 2008 ಅಂದ್ರೆ ಒಂದೇ ವರ್ಷ. 2008 ಇಲ್ಲಿ ನಿಮ್ಮ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಅದು ಬಂದಿಲ್ಲ. ಅಲ್ಲ ಜೈನ್ ಆಗಿತ್ತಲ್ರಿ ನಿಮ್ಮ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ. sometimes that is also possible. ಯಾಕಂದ್ರೆ page 30 service particulars. Yes, 16/7/2008 as a probationary. He wants us to ಅಲ್ಲ ಅದನ್ನೇ ನಾವು ಮಾಡಿದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ. ಆನ್ ಮೆರಿಟ್ಸ್ ಅನೇ ಅದನ್ನ ಮಾಡ್ಕೊಳಕ್ ಆಗುತ್ತೆ. ಬಿಕಾಸ್ he wants us to pass in order. ಪಾಸ್ ಆರ್ಡರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅದನ್ನ ಕೊಟ್ರ ಸರ್. ಎರಡೇ ಗ್ರೌಂಡ್ಸ್. ಒಂದು ಅದು ಎಲ್ಲಿದೆ ಪೇಜ್ ನಂಬರ್? ಹೌದು ಅದೇ ಆಮೇಲೆ ಹಿಂದೆ ಒಂದು ಫ್ಯಾಮಿಲಿ ಇರುತ್ತೆ. ಈ ಕ್ಲಾಸ್ ಅವ್ರಿಗೆ ಏನು ಹ್ಯಾಬಿಟ್ಸ್ ಹ್ಯಾಬಿಟ್ಸ್ ಅದು ಇದು ಗೊತ್ತಿಲ್ಲ. ಓನ್ಲಿ ಲುಕಿಂಗ್ ಎಟ್ ದ ಫ್ಯಾಮಿಲಿ ಬಿಹೈಂಡ್ ದೆಮ್ ಸ್ವಲ್ಪ ತೋರಿಸ್ಬೇಕು. He gets a minimal amount, even if that protection is without prejudice to the provisions of. And 25 circumstances to be taken into consideration for imposition of penalties. Without prejudice to the provisions. Correct. This period shall be liable to one or more of the penalties specified in regulation number 18 according to the gravity of the misconduct or misbehavior. And 18 is, sorry, regulation 18 is it prescribes punishments, major punishments provide ಮಾಡುತ್ತೆ. Regulation 18 are 18 it contains both minor and major penalties. 2014 amended up to inquiry ಆಗಿರೋದು ಯಾವಾಗ ಇದು? Before that 2009 2014 final order itself is filed passed in 2014 22/3/2014. This amendment is on 19/11/2014. Nature of penalties, Roman number, withholding of disposition, recovery provisions, reduction to lower stage, suspension of the period of not exceeding 60 days. Yes. Yes. ನೀವು ಕೊಟ್ಟಿದ್ದೀರಾ ನೋಡಿದೀವಿ ನಾವು ಪ್ರೀವಿಯಸ್ ನಿಮ್ಗೆ ಕೇಸಿಗೆ ಕೇಳ್ತಾ ಇಲ್ರಿ ಅವರು ನೀವೇ ಗುಬ್ಬಿ ಆಗಕ್ ಹೋಗ್ಬೇಕು ನೋಡಿ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ರಘುನಾಥ ಪೇಜ್ ನಂಬರ್ 18 14 yes
the fact that the responding conductor had when he was subjected to the discipline for the starting question, whether or not he was informed before speaking about his past history immediately, as held by this court in the case of KSRTC versus A. Ramana, and also in the case of E. The KSRTC. So the past history of the respondent could also be taken into consideration by consideration of the punishment.
Not this one, ಇನ್ನೊಂದು ಯಾವ್ದಾದ್ರು ಸ್ಟ್ಯಾಚ್ಯುಟರಿ ಪವರ್ ಇದೆ ಅಂತ ಹೇಳಿ ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಯಾವ್ದ್ರೆಲ್ಲ ಇದೆ ಇಸ್ ಎ ರೆಗ್ಯುಲೇಷನ್ ಕರೆಕ್ಟ್ ದಟ್ ಹ್ಯಾಸ್ ಅ ಸ್ಟ್ಯಾಚ್ಯುಟರಿ ಫೋರ್ಸ್ ಸೊ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಅಂತ ಇದೆ ಎಸ್ ನನ್ನ ಪ್ಲೀಸ್ ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನು ಆರ್ಗ್ಯುಮೆಂಟೇ ಇಲ್ವಾ ನಿಮ್ದು
ಮೆಡಿಕಲ್
ಸಬ್ಮಿಷನ್ ಅವ್ರದ್ದು ಸಬ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ವಲ್ಲ the respondent admittedly the respondent was appointed as a driver cum conductor the petitioner organization in on 16/7/2008. He also admitted his absence from duty. From 5/12/2009 to 10/12/2000. Charge ಅಲ್ಲಿ ಇರೋದು 5/12/2009 to 10/12/2009. Only that period. ಬರೀ 5 days absence ಬಗ್ಗೆನೇ ಎನ್ಕ್ವೈರಿ ಆಗಿರೋದು. Page number charge sheet. ಮತ್ತೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಡಿ, just because you have already 5/12/2009 till the issuance of charge sheet on 27/7/2001, 27/3/2011. For that is for more than 1 year 3 months. 1 year 3 months. He had not applied for any leave for the said period of absence. His only explanation during the inquiry as well as before the Industrial Tribunal was that he was unwell. He was prevented from attending to the duty due to his medical condition. To substantiate, therefore, the burden was on him to substantiate the said ground. Through the same fact, he relied on Exhibit W1, the medical certificate, and W2, the medical prescriptions. The petitioner disputed the genuineness of ನಿಮಗೆ ಸಂಬಂಧಿಸಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ ಕೇಳಿದ್ರಿ, ಇಟ್ಸ್ ನಾಟ್ ಕನೆಕ್ಟೆಡ್ ಟು ಯು ಅಂತ ಹೇಳಿ. ದಿಸ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ನೀವು W1ಗೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇದ್ರಲ್ಲಂತೂ ಏನು ಕೇಳೇ ಇಲ್ಲ ನೀವು ಇಂಡಸ್ಟ್ರಿಯಲ್ ಟ್ರಿಬ್ಯುನಲ್ ಮುಂದೆ ಅದ್ರ ಬಗ್ಗೆ ಅಬೌಟ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್. ಬರೀ ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ಮುಂದೆ ದಿಸ್ ಇಸ್ ನಾಟ್ ಕನೆಕ್ಟೆಡ್ ಟು ಯು ಅಂತ ಕೇಳಿದ್ದೀನಿ. ಯಾವುದು ಜಸ್ಟಿಸ್ ಸಾಲ್ಡಾನ್ ಅವ್ರ ಜಡ್ಜ್ಮೆಂಟ್ citations. Unless ಅದರಲ್ಲಿ ಒಂದು ಕ್ವಾಲಿಫೈಡ್ ಇದೆ, unless there are inherent basic defects, infirmities and illegalities. Even in cases when it does not, if on the face of it, it does not inspire the confidence ಅಂತ ಇದೆ. ಏನಿದೆ ಅದರಲ್ಲಿ?
Petitioner disputed the genuineness
in the cross examination of the respondent before the industrial tribunal or before the inquiry officer. The genuineness of the said document was not disputed. It was only said during the domestic inquiry, it was only suggested to the workman that exhibit W1 does not relate to the petitioner, sorry, to the respondent. In S.A. Fernandez's case, relied on by the legal counsel for the petitioner. It was held that the court is not obliged to treat the medical certificate as a sacrosanct document. If provided the same such document, provided such document on the face of it does not inspire confidence. Nothing was elicited in the cross-examination of the respondent to impeach exhibit W1 for the genuineness of the same. Therefore, the said judgment cannot be justifiably applied to the facts of the present case. However, the fact remains that even after this court passing order, even after this court passing interim order dated 25/4/2018, the respondent has not reported to the duty. An attempt was made to submit before this court that the petitioner did not permit him to report to the duty. In response to that, the counsel for the petitioner copy submitted the office order date, copy of the office order dated 4/4/2019. Requiring the respondent to report to duty. The said document bears the signature of the respondent. It shows that it was served on him on 22/7/2019. In the 31. There's his signature. There's his signature. Though the respondent did not produce any material to substantiate his contention that he reported to duty, but the petitioner did not submit to permit him to work. The records show that records show the Honorable Supreme Court in in Ashappa's case referred to Supra held that for running buses, service of conductor is imperative, and no employer running a fleet of buses can allow an employee to remain absent for a long time. In this case also, since the year 2009, the petition respondent has not, since 2009, till the issuance of the charge sheet, 27/3/2011, the respondent did not report to the duty. Only during the inquiry also he had not reported to duty. ನೀವು ಮಾಡೋ ಪರ್ಮಿಟ್ ಮಾಡೋದಿಲ್ಲ ಅನ್ಸುತ್ತೆ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ತಾರ ಅವ್ರಿಗೂ ಅವಶ್ಯಕತೆ ಇರುತ್ತೆ ರಿಸಲ್ಟ್ ಆಫ್ even thereafter he has not reported to duty. Even after the interim order of this court, court of order ಎಲ್ಲಿದೆ ಅದಕ್ಕೆ ಮೆಟೀರಿಯಲ್ ನಿಮ್ ಪ್ಲೀಡಿಂಗ್ ಅಲ್ಲಿ ಮೆಟೀರಿಯಲ್ ಇರ್ಬೇಕಲ್ರಿ ನಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದ್ವಿ ಈ ತರ ಕೌಂಟರ್ ಅಲ್ಲಿ ಹೇಳಿದೀನಿ ಅಂತ ಇದೆ ಎಲ್ಲಿದೆ ತೋರಿಸಿ ಅಂತ ಕೌಂಟರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ಎಲ್ಲೋ ಒಂದು ಇದರಲ್ಲಿ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಒಂದ್ ಕಡೆ ರೆಫರೆನ್ಸ್ ಬಂದಿದೆ ಅದ್ರ ಹಾಗಿದ್ರೆ ಎಲ್ಲಿದೆ ತೋರಿಸಿ ಅಂತ ಕೇಳಿದ್ವಿ ನಾವು ಇಂಡಸ್ಟ್ರಿಯಲ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ however the record show that the respondent had the poor assistance even before this court. Considering he'll permit fresh ಅಂತಾನೆ ಮಾಡ್ಕೊ ಅಥವಾ ಅದು ಏನಂದ್ರೆ his period of absence will not get any benefit. If he wants to report, let him report to the duty. Otherwise, under the circumstances, the tribunal committed error in setting aside the dismissal order in toto, and in total in dismissal order and granting dismissal order its entire and ordering for reinstatement with all service benefits except back wages. In the considered opinion of this court, the tribunal should have considered the period of absence of the respondent as break in service. And ordered for reinstatement without service benefits for the said period. Service benefits for the break said period. Illondre ಹೇಳಿಲ್ಲ history note. We'll properly edit that. ಅದು history past history ಬಗ್ಗೆ ಒಂದು ಬರಲಿಲ್ಲ ಒಂದು sentence ಬರ್ಕೊಳ್ಳಿ. Records show that the previously also the respondent was in the habit of respondent had absented himself from duty. Page number ಎಷ್ಟು ತೋರಿಸಿದ್ರಲ್ಲ ಅವರು his history sheet
page 30.
Easy. Respondent had absented history sheet of the respondent shows that after joining service in a service ಸೇರಿದ್ದ ಯಾವಾಗ ಇದು service on 16/7/2008 till the charge sheet was issued on 5/12/2009. During the interim period, he absented himself to to duty. ಇದು 5 times ಅಂದ್ರೆ ಇದು ಲಾಸ್ಟ್ ಚಾರ್ಜ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದು ಸೇರ್ಕೊಳ್ಳುತ್ತೆ ಅದರಲ್ಲಿ. 5 times. 5 times. As per regulation 25 of conduct and regulations 1971, KSRTC conduct and discipline regulations 1971, in considering the punishment, considering the quantum of punishment, the past conduct of the employee has to be taken into consideration. ಇಲ್ಲಿ ಮಧ್ಯದಲ್ಲಿ ಎಲ್ಲ ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳ್ತೀನಿ ಅನ್ಸುತ್ತೆ. Impugned order. Impugned order of granting service benefits. These benefits is contrary to the aforesaid judgment of the Supreme Court and the material on record. Because the petition is partly allowed, the impugned order of reinstatement duty is hereby confirmed. Award is at page number. Impugned order of reinstatement duty is hereby confirmed. Impugned order setting aside the reinstatement duty. The impugned order is modified as follows. The order of termination dated 22/3/2014. Termination ಅಲ್ಲ, dismissal ಅಲ್ವಾ ಅದು ಆರ್ಡರ್. ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಟರ್ಮಿನೇಷನ್ ಅಂತ ಬರೆದಿದ್ದಾರೆ ಅವರು. The impugned order of dismissal of the impugned order of dismissal dated 22/3/2014 passed by the petitioner against the respondent is hereby set aside. The respondent is the petitioner is directed to respond. Directed to reinstate the respondent. Subject to. ಮತ್ತೆ ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಡಿಸ್ಪ್ಯೂಟ್ ಆಗ್ಬಾರ್ದ, ಹೋಗಿ ನೀವು ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೋಬೇಕಾದ್ರೆ ಎಲ್ಲ ಕೊಟ್ಟು subject to the respondent reporting to the duty with the valid driving license and fitness certificate. The respondent is entitled to continuity of service. Respondent is not entitled to back wages. First, back wages during the period of absence. Back wages from the date of his absence till he reports to the duty. From the date of his absence, that 2009 till he reports to duty, he will not be entitled from the date of his absence. ಅದು ಡೇಟೇ ಹೇಳ್ಬಿಡಿ ಕರೆಕ್ಟ್ ಆಗಿ ಯಾವ್ದಿದೆ ಅದನ್ನೇ ಹೇಳ್ಬಿಡಿ. ಅದು ಚಾರ್ಜ್ ನಲ್ಲಿ ಇದೆ ಅಲ್ಲ, ಅದೇ 5/12/2009 ಏನೋ 5/12 ಅಲ್ಲ, ಫ್ರಮ್ 5/12/2009 till he reporting to the duty by virtue of this order. He is not entitled to any service benefits for the said break-in service period. Continuity is also service benefit alva. respondent is not entitled to continuity of service and consequential service benefits during this break-in service period. During the said break-in service period. ನೋಡಿ ಇದೊಂದ್ಸರಿ ಚಾನ್ಸ್ ತಗೊಳ್ಳಿಲ್ಲ ಅಂತಂದ್ರೆ ಅವರು ಯು ಶುಡ್ ಅಸಿಸ್ಟ್. ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬಂದು ಕೋರ್ಟಿಗೆ ಬಂದು ಹೇಳ್ಬೇಕು ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ. ಈಗ ಅವ್ರೊಂದು ಪ್ರಪೋಸಲ್ ಕೊಟ್ರು, ಅದ್ರ ಮೇಲೆ ಒಂದು ಮೆಮೋ, ಜಾಯಿಂಟ್ ಮೆಮೋ ಹಾಕಿನೂ ಮುಗಿಸ್ಕೋಬಹುದಿತ್ತು ನೀವು.
I appeal for the petitioner in this case, madam.
ನಿಮ್ದಲ್ಲ, ಇದು HR ರೇಣುಕಾ ಅವ್ರದ್ದು. 13, serial number 13.
I'm sorry.
Yes.
Just one day clarification.
Oh, this is 5 unit luggage. ಅಲ್ಲ 5 units luggage ಇದ್ದು. All bags. Yes.
ಈಗ ಕೆಜಿ ಫಸ್ಟ್ ಒನ್ ಈಗ 20 into 5 20 ಅಂದ್ರೆ ನಾನು ಹೇಳಿದ್ದೆ 20 ಕೆಜಿ 100 ಕೆಜಿ 100 ಕೆಜಿ ನೆಕ್ಸ್ಟ್ ಬಂದು 20 into 40 ಕೆಜಿ 145 ಇದು 240 ಕೆಜಿ
ಈಗ ಈ ಝೋನ್ ಹಾಕಿ
ಯೂನಿಟ್ ಕೆಡಿಸ್ಕೊಳ್ಳಿ ಯೂನಿಟ್ ಬಂದು 5 ಫಸ್ಟ್ ಒನ್ ಅಲ್ಲಿ 5 ಇದೆ 20 into 5 ಅಂತ 5 ಯೂನಿಟ್ ಫಸ್ಟ್ ಒನ್ ಅಲ್ಲಿ 5 ಯೂನಿಟ್ ಸೆಕೆಂಡ್ ಒನ್ ಅಲ್ಲಿ 2 ಯೂನಿಟ್ ಲೋಡ್ ಆಯ್ತು ಥರ್ಡ್ ಒನ್ ಅಲ್ಲಿ 5 ಆಯ್ತು 12 ಯೂನಿಟ್ 12 ಯೂನಿಟ್ now you see now your option see a ticket now he shows a ticket of 30 units 100 units
ticket is at page number
ticket is not used for it correct
M11 M10 is the ticket Dandada Rashid M10 M11 is the ticket ಅದೇ ಎರಡು 4338 4339
ಸೊ 30 ಯೂನಿಟ್ 100 ಯೂನಿಟ್ ಲಗೇಜ್ ಬಸ್ ಅಲ್ಲಿ ಇರೋದು ಇವನ್ ಲಾಸ್ಟ್ ಮೇ ನಾಟ್ ಬಿಲೀವ್ ಯು ನಾನು 5 ಯೂನಿಟ್ 100 ಯೂನಿಟ್ ಅವನಿಗೆ ಇನ್ನ 2595 if you divide by 13 1 unit ಗೆ 86 the checking official showed me how it is 1 unit ಗೆ 86 ನಾವು ಚಾರ್ಜ್ ಮಾಡಿದ್ದು 86 into 5 432 ನಾವು ಚಾರ್ಜ್ ಮಾಡಿದ್ದು ಹಿಂಗೆ so what he should have had indicated what he should have given me is 1032 rupees 100 unit ಗೆ 86 ರೂಪಾಯಿ ಅಂತ ಕೊಟ್ಟೆ 1032 ರೂಪಾಯಿ ಹಿಂಗೆ ಅದೇ ಮಾಡಿರೋದು 1032 ಸೊ 1032 ರೂಪಾಯಿ ಟಿಕೆಟ್ ಕೊಡಬೇಕು ಲಗೇಜ್ ಟಿಕೆಟ್ ಅವನು ಒಂದು ಟಿಕೆಟ್ ತೋರಿಸ್ತಾನೆ 2595 ನೋ ಪ್ಯಾಸೆಂಜರ್ ರೆಕಾರ್ಡ್ ಪೇ 1,500 ಜಾಸ್ತಿ ಯಾರು ಕೊಡೋದು ಲಗೇಜ್ 10 ರೂಪಾಯಿ ನಾನು ಯೋಚನೆ ಮಾಡ್ತೀನಿ ಅವನು 10 ರೂಪಾಯಿ ಜಾಸ್ತಿ ಕೇಳಿದ್ರೆ ಯೋಚನೆ ಮಾಡ್ತೀನಿ 1500 ಸೊ comes up with a false. Now your lordship may kindly see his.
ಹಾಗೆ ಮಾಡಿದ್ರು ತಪ್ಪು ಅಂತ.
Now your lordship may kindly see his reply. He replied.
No, even if he does that. So what was in the first was only 12 bags.
According to, I'm requesting the lordship to take by this 100 bag. 100 ಕೊಡಿಚಿನ 240 kg. 100 ಯೂನಿಟ್ ಬಗ್ಗೆ ಹೋಗಲ್ಲ kg ಬಗ್ಗೆ ಬೇಡ. 100 ಕೊಡಿಚಿನ 100 ಯೂನಿಟ್.
12 ಯೂನಿಟ್ ಗಾದ್ರೂ 2595 ಆಗೋದಿಲ್ಲ.
1032 ಆಗುತ್ತೆ. ಈಗ ನಾವು ಅದೇನು ಗೊತ್ತಾಗುತ್ತೆ ಅಂದ್ರೆ ಆ 2595 ಅಂತ ಇದೆ. ಆ 2595 ನ 30ರಲ್ಲಿ ಡಿವೈಡ್ ಮಾಡಿದ್ರೆ 2595 ಡಿವೈಡೆಡ್ ಬೈ 30 86 ರೂಪೀಸ್ ಆಗುತ್ತೆ. 1 ಯೂನಿಟ್ಗೆ ನಾವು ಕೊಡ್ಬೇಕು ಅವ್ರು ತಗೋಬೇಕಾಗಿರೋದು 86 ಯೂನಿಟ್. ಬಟ್ 1 ಯೂನಿಟ್ಸ್ಗೆ 1032. However, he comes up with this false claim. So therefore, even if my case is not 5 units, now I am getting luggage but now under the million, but under the million, ticket. He shows a ticket without some other passenger who has gone down without in the previous stop because now Mumbai in the Mysore ಬಂದಿದೆ ಬಸ್ 4 ಜನಕ್ಕೆ ಬಸ್ ಫುಲ್ ಇದೆ ಎಲ್ಲ ಇಟ್ಕೊಳ್ತಾರೆ ಎಲ್ಲೆಲ್ಲಿ ಸ್ಟಾಪ್ ಬರುತ್ತೆ ಅಲ್ಲಿ ಇಟ್ಕೊಳ್ತಾರೆ ಮೈಸೂರು ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಇಟ್ಕೊಳ್ತಾರೆ ಚೆಕಿಂಗ್ ಮಾಡಿದಾಗ ಒಂದು ಪ್ಯಾಸೆಂಜರ್ ಇದ್ದಾನೆ ಅವಾಗ ಯಾರ ಪ್ಯಾಸೆಂಜರ್ ಅಂತ ಹಿಂದೆ ತಗೊಂಡ್ಬರ್ತಾರೆ 3 ಟಿಕೆಟ್ ತಗೊಂಡ್ಬರ್ತಾರೆ 3 ಲಗೇಜ್ ಯೂನಿಟ್ ತಗೊಂಡ್ಬರ್ತಾರೆ 3 ಅವನೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು W6 W7 ನಂತರ ಡಾಕ್ಯುಮೆಂಟ್ ವರ್ಕ್ಮೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ W6 is all workment document W5 W6 W7 ಕೊಡ್ಬಿಟ್ಟು this will equal the passenger who was traveling with this 1 bag. So ಅವನು ಹೇಳಿದ ಕರೆಕ್ಟ್ ಆಗಿ ಮ್ಯಾಚ್ ಆಗುತ್ತೆ 1 bag 100 ಕೊಡಿಚಿನ 100 ಯೂನಿಟ್ 100 ಕೊಡಿಚಿಂದ 100 ಯೂನಿಟ್ ಹೋಗಲ್ಲ ಅಂತ ಬಿಕಾಸ್ 1 ಯೂನಿಟ್ಗೆ ಒಂದೊಂದರಲ್ಲಿ 200 kg ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ ಜಾಸ್ತಿ ಭಾರ ಇರಲ್ಲ ಬಟ್ ಕ್ವಾಂಟಿಟಿ ಜಾಸ್ತಿ ಇರುತ್ತೆ ಭಾರ ಇರಲ್ಲ ಅವಾಗ what I'm trying to say is that he is not come to the court with the true statement. He takes the shutter in respect of a ticket issued for 30 units. Again, inquiry charge sheet
ಅಂದ್ರೆ you mean to say that this 174 ಯೂನಿಟ್ ಇವ್ರು ಏನ್ ಮಾಡಿರ್ತಾರೆ ಆ ಬ್ಯಾಗ್ಸ್ ಹಿಂದೆ ಇಳಿದು ಹೋಗ್ಬಿಟ್ಟಿರ್ತಾರೆ.
ಈಗ 30 ಯೂನಿಟ್ ಟಿಕೆಟ್ ಇದೆ ಅದು ನನ್ನ ಮೇಲೆ ಹಾಕ್ಬಿಟ್ರು ನಾನು ಒಂದೇ ವರ್ಕ್ ಮಾಡಿರೋದು ನಾನು ಲಗೇಜ್ ವೇ ಮಾಡಿಸ್ಬೇಕಾಯ್ತು ಚೆಕಿಂಗ್ ಆಫೀಸರ್ ಸೈಡ್ ಎಸ್ಟಡಿ ಪ್ಲೀಸ್ ಟೇಕ್ ದಿಸ್ ಓನ್ ನಾನು 3 kg ಅಂತ ಹೇಳಿದ್ದೀನಿ 240 ಅಂತಾನೆ ತಗೊಂಡೆ ಅವನ ಪ್ರಕಾರ 240 ಎಷ್ಟು ಟಿಕೆಟ್ ಕೊಡಬೇಕು 1032 ರೂಪಾಯಿ ಇಲ್ಲಿ ಇವನು 2000 ಇವಾಗ ನಾವು ಪೇಜ್ 17 ಇದೆ ನಾವು ಪೇಜ್ 17 ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ 17 ರಿಪ್ಲೈ ನಾನು ಪೇಪರ್ ನಾನು page 17 ಚಪ್ಪಲಿಗಳಿಗೆ ನಾನು ಸಂಸ್ಥೆಯ ಉತ್ತಮ ಆದಾಯದ ದೃಷ್ಟಿಯಲ್ಲಿ ಅವುಗಳ ವಾಸ್ತವಿಕ ರೂಪಕ್ಕಿಂತ ಅತ್ಯಧಿಕ ತೂಕ ವ್ಯಾಪ್ತಿಯ 30 ಯೂನಿಟ್ ಯಾರು ಕೊಡ್ತಾರೆ 30 ಯೂನಿಟ್ 12 ಯೂನಿಟ್ ಟೋಟಲ್ ಲಗೇಜ್ 12 ಯೂನಿಟ್ಗೆ which passenger will pay 2595 no passenger will pay ನಾವೇನೆ 10 ರೂಪಾಯಿ ಜಾಸ್ತಿ ಕೇಳಿದ್ರೆ ಕ್ವಶ್ಚನ್ ಕೇಳ್ತಿದ್ರೆ ನಿಮಗೆ ಹೇಗೆ 10 ರೂಪಾಯಿ 30 ರೂಪಾಯಿ ಇರೋ ಕಡೆ 40 ಕೇಳ್ತಾರೆ ಅದನ್ನು 500 rupees ಜಾಸ್ತಿ ಬರುತ್ತೆ and that is again my lord he cannot if he has done that my lord he cannot do that to the passenger ಅವನದವರೇ ಆಗುತ್ತೆ 1500 ಜಾಸ್ತಿ ನಾನು ಆ ತರ ಎಲ್ಲ ಮಾಡು ಅಂತ ಹೇಳಿದ್ದೆ ಯಾವ ಕಡೆ ಟಿಕೆಟ್ ಇಶ್ಯೂ ಮಾಡಿ ಪ್ಯಾಸೆಂಜರ್ ಬರ್ತಾರೆ now my lord is trying to take
but what is the explanation of your people for not weighing the luggage?
what he said my lord is that he did not weigh ಮಾಡಬೇಕು ಮಾಡಿಲ್ಲ
but then how do you get over that? ಅಲ್ಲ ನಮಗೀಗ ಅಷ್ಟೇ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ಬರೀ 12 ಬ್ಯಾಗ್ಸ್ ಅಷ್ಟೇ ಇತ್ತು ಲಗೇಜ್ ಅಂತಿಲ್ಲ ಅಲ್ಲ ಅಷ್ಟೇ ಇತ್ತು ಅಂತ ಅವ್ರ ಕೇಸು ಅಲ್ವಲ್ಲ ಅದನ್ನ 12 ಗಮನಿಸಿ
ಅವನೇನ್ ಹೇಳೋದು ನಾನೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೇನೆ 12 ಕೋಟಿ ಚಿನ್ನ ಇತ್ತು.
ಅಲ್ಲ ಬಟ್ ನಿಮ್ ಚಾರ್ಜ್ ಆಗಿರ್ಲಿಲ್ವಲ್ಲ, ನೀವು ಎಕ್ಸ್ಪ್ಲೈಟೆಡ್ ದ ಪ್ಯಾಸೆಂಜರ್ ಅನ್ನೋ ಚಾರ್ಜ್ ಇಲ್ವಲ್ಲ.
ನಾನು 12 ಕೋಟಿ ಚಿನ್ನ ಅಂತ ಹೇಳಿದ್ದು. ಮೇಡಮ್ ನಾನೇನ್ ಹೇಳಿದ್ದೀನಿ 5 ಯೂನಿಟ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು 12 ಕೋಟಿ ಚಿನ್ನ ಅಂತ. ITC
ಆರ್ಟಿಕಲ್ಸ್ ಆಫ್ ಚಾರ್ಜ್, ಆರ್ಟಿಕಲ್ ಆಫ್ ಚಾರ್ಜ್
5 ಯೂನಿಟ್ ಲಗೇಜ್ 12 ಚೀಲಗಳಲ್ಲಿ ತುಂಬಿದ ಚಪ್ಪಲಿಗಳು. 12 ಚೀಲ is not enough. What comes to my rescue is 12 gunny bags.
ಲಗೇಜ್
12 gunny bag ಅಂತ. ಇವಾಗ ನಾವು ಯೂನಿಟ್ ಬಿಟ್ಬಿಡಿ 12 gunny bag.
ಅಲ್ಲ ಕರೆಕ್ಟ್. ಈಗ ನೀವ್ ಹೇಳೋದು ಎಸ್ ಚಾರ್ಜ್ ಎಕ್ಸಸ್ ಅವ್ರು ಹೇಳೋ ತಗೊಂಡ್ರೆ ಹೆಚ್ಚಾಗುತ್ತೆ. ಆದ್ರೆ ಅದು ಬೇರೆದು ಅನ್ನೋದಕ್ಕೆ ಎಲ್ಲಿ ಮೆಟೀರಿಯಲ್ ಇದೆ? See, now we are saying a hypothesis that was those passengers might have alighted before Mysore.
ಈಗ ನಾನು 1 ಕೋಟಿ ಚಿನ್ನ 2 ಕೋಟಿ ಚಿನ್ನ ಅಂತ ಕರೆಕ್ಟ್. ನಾನು 5 ಯೂನಿಟ್ ಅಂತ ಹೇಳಿ ಬ್ರಾಕೆಟ್ 12 ಕೋಟಿ ಚಿನ್ನ ಅಂತ ಹೇಳಿದ್ರು. ಸೊ ಇವಾಗ ನಾವು ಪೇಜ್ 17 ಅವನ ರಿಪ್ಲೈ ಬಂದಾಗ ಅವನು 12 ಕೋಟಿ ಚಿನ್ನ ಅಂತ ಹೇಳ್ತಾರೆ. he is not disputing 100 ಕೋಟಿ ಚಿನ್ನಕ್ಕೆ ಲಗೇಜ್ ಟಿಕೆಟ್. ನಾನು 100 ಕೋಟಿ ಚಿನ್ನಕ್ಕೆ ಲಗೇಜ್ ಟಿಕೆಟ್ 1022 rupees. ಈಗ he says I have collected 2559. That is not the ticket.
ಅವ್ರ ಪ್ರಕಾರ ಇದ್ದ ಒಂದೇ ಒಂದು ಲಗೇಜ್ ಬಾಕ್ತಿಗೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಯು ರೆಡ್ ಓನ್ಲಿ ಪಾರ್ಟ್ ಆಫ್ ದಟ್. ಹೀಸ್ ಡಿಫೆನ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಬಸ್ ಬಂದಾಗ ನನ್ನ ಲಗೇಜ್ ವಿಧಿಸಿರುವಿಕೆಯ ವಿಷಯವನ್ನು ಪ್ರಸ್ತಾಪಿಸಿ ಅವರದೇ ಹೇಳಿಕೆಗೆ ವಿರುದ್ಧವಾಗಿ ಇದ್ದ ಒಂದೇ ಒಂದು ಲಗೇಜ್ ಬಾಕ್ತಿಗೆ 2ನೇ ದರಕ್ಕೆ ಒಳಪಡಿಸಿಟ್ಟು ಪಾರ್ಟಿಯವರು ತೋರಿಸಿದ ಬಿಲ್ಲುಗಳನ್ನು ಪರಿಗಣಿಸದೆ ಸಂಪೂರ್ಣವಾಗಿ ಅಸತ್ಯ ಹಾಗೂ ಇಲ್ಲದ ಆಪಾದನೆಯನ್ನು ನನಗೆ ನೀಡಿಬಿಟ್ಟರು. ಫಸ್ಟ್ ವರ್ಷನ್ ಯಾವ್ದಾಗಿದೆ? M80 ಡಿಫೆನ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ವಾ? ಅದೇ ಡಿಫೆನ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಒಂದೇ ಒಂದು ಇದಿತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. ಒಂದೇ ಒಂದು ಲಗೇಜ್ ಬ್ಯಾಗ್ ಇತ್ತು, ಅದಕ್ಕೆ ಅಷ್ಟು ಚಾರ್ಜ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಮುಂಬೈಯಿಂದ ಬಂದ 12 ಗೋಣಿ ಚೀಲದಲ್ಲಿ ತುಂಬಿದ್ದ ಚಪ್ಪಲಿಗಳಿಗೆ ನಾನು 30 ಯೂನಿಟ್ ಚಾರ್ಜ್ ಮಾಡಿದ್ದೆ. ಆದ್ರೆ ಆ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ನಲ್ಲಿ ದೇ ವೇಡ್ ಓನ್ಲಿ 1 ಲಗೇಜ್, ಬೇಡಲ್ಲ ಒಂದೇ ಲಗೇಜ್ಗೆ ಸೆಕೆಂಡ್. ನೀವು ಒಂದು ಇನ್ಕ್ಯೂರಬಲ್ ಡಿಫೆಕ್ಟ್ ಮಾಡಿದೀರಾ ಇದರಲ್ಲಿ. ಅಲ್ಲ ಅವನ ಪ್ರಕಾರ ಒಂದೇ ಬ್ಯಾಗ್ ಇತ್ತು ಅವಾಗ. ನೀವು 12 ಬ್ಯಾಗು ಮುಂಬೈಯಿಂದ ಬಂದಿತ್ತು. ಮುಂಬೈಯಿಂದ ಬಂದಿದ್ದಕ್ಕೆ 2 ಚಾರ್ಜ್ ಆಯ್ತು. ಆದ್ರೆ ನೀವು ಬಸ್ ಸ್ಟ್ಯಾಂಡಿಗೆ ಬಂದ್ಮೇಲೆ ಒಂದೇ ಒಂದು ಲಗೇಜ್ ಅನ್ನ ವೇ ಮಾಡಿಲ್ಲ, ಒಂದೇ ಒಂದು ಲಗೇಜ್ಗೆ ಬಿಲ್ ಹಾಕಿದ್ರಿ ಪೆನಾಲ್ಟಿ. ಚಪ್ಪಲಿಗಳಿಗೆ
ಬೇರೆ ಯಾವುದೂ ಇರಲಿಲ್ಲ. ಒಂದೇ ಲಗೇಜ್ 30, 12 ಬ್ಯಾಗ್ಗೆ 30
ಮುಂದೆ ಓದಿ. ನೀವು ಅಷ್ಟೇ ಓದಿ ಅಲ್ಲಿಗೆ ಯಾಕೆ ನಿಲ್ಲಿಸ್ತೀರಿ?
ಮುಂಬೈಯಲ್ಲಿ ಬಂದ 12 ಚಪ್ಪಲಿಗಳಿಗೆ ಅವುಗಳ ವಾಸ್ತವಿಕ
ಆಯ್ತು ಸರಿ, ಅದನ್ನ ಓದಿ. ಹೇಳ್ತಾರೆ, ನಾನ್ ಬೇಕಂದ್ರೆ ಅಲ್ಲೇ ತುಗಿಸಿ ಖಚಿತಪಡಿಸ್ಕೊಳಕ್ ಕೇಳ್ಕೊಂಡೆ. ಲಗೇಜ್ ಪಾರ್ಟಿಯವರು ಅವ್ರ ಬಿಲ್ ತೋರಿಸಿ ಮೊದಲೇ ನಿರ್ವಾಹಕ ಅಧಿಕ ವಿಧಿಸಿದ್ದಾನೆ ಎಂದು ಆಕ್ಷೇಪಿಸಿದ್ರು. ಆದ್ರೆ ತನಿಖಾಧಿಕಾರಿಯವರು ಆ ಪಾರ್ಟಿಯವರಿಗೆ ದಬ್ಬಾಳಿಕೆಯೊಂದಿಗೆ ಪೊಲೀಸ್ ಬೆದರಿಕೆ ಹಾಕಿ ಅನಿಸಿದಷ್ಟು ದಂಡವನ್ನು ವಿಧಿಸಿ ಸದರಿ ನನ್ನ ಲಗೇಜ್ ದರ ವಿಧಿಸಿರುವಿಕೆಯ ವಿಷಯವನ್ನು ಪ್ರಸ್ತಾಪಿಸದೆ ಅವರದೇ ಹೇಳಿಕೆಗೆ ವಿರುದ್ಧವಾಗಿ ಇದ್ದ ಒಂದೇ ಒಂದು ಲಗೇಜ್ ಬಾಕ್ಟಿಗೆ ಎರಡನೇ ದರಕ್ಕೆ ಒಳಪಡಿಸಿರೋದು ಸೆಕೆಂಡ್ ಟೈಮ್ ಅಲ್ಲ ಕರೆ ಅಲ್ಲ ಅಲ್ಲಿ ಬಂದಾಗ ಒಂದೇ ಇತ್ತು ಅಂತ ಹೇಳೋದು ಅವನು ಬಸ್ ಸ್ಟ್ಯಾಂಡಿಗೆ ಬಂದಾಗ ಒಂದೇ ಇತ್ತು. We have to go by the legal evidence. ಅದು ನೀವೇನಾದ್ರೂ ನಿಮ್ಮ ಅಫಿಷಿಯಲ್ಸ್ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ರೆ ಇದನ್ನ ಮಾಡೋದ್ರಲ್ಲಿ what was the difficulty for them to wait? ಅಥವಾ ಕಂಡಕ್ಟ್ ಬಸ್ ಡ್ರೈವರ್ ದಿವಸ ಕಂಡಕ್ಟರ್ ಅಲ್ವಾ, ಡ್ರೈವರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿಲ್ಲ ನಿಮಗೆ. We cannot ಇಲ್ಲಿ appreciation re-appreciation scope is very limited. ಅವ್ರ ಪ್ರಕಾರ ಅಷ್ಟಿತ್ತು ಅದು. ಕರೆಕ್ಟ್, ನೀವ್ ಹೇಳೋದ್ ನಮಗ್ ಅರ್ಥ ಆಯ್ತು. ಅವ್ನು ಎಕ್ಸ್ಪ್ಲಾಯ್ಟ್ ಮಾಡಿದ್ರು ನಿಮ್ಮ ಚಾರ್ಜ್ ನೀನ್ ಹೆಚ್ಚು ಚಾರ್ಜ್ ಮಾಡಿದ್ಯಾ, ಪ್ಯಾಸೆಂಜರ್ಸ್ ಎಕ್ಸ್ಪ್ಲಾಯ್ಟ್ ಮಾಡಿದ್ಯಾ ಅಂತ ಮಿಸ್ಕಾಂಡಕ್ಟ್ ಗೆ ಚಾರ್ಜ್ ಇರ್ಲಿಲ್ಲ. ಡಿಫಿಕಲ್ಟ್ ಅಲ್ವಾ ಈ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ನಾವು ಇದನ್ನ ಇಷ್ಟು ಮೈನ್ಯೂಟ್ ಆಗಿ ಈ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ನಾವು ಅದನ್ನ ಹಾಗೆ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೂ ಆಗೋದಿಲ್ಲ. ದ ಬೇಸಿಕ್ ಎರರ್ ಇನ್ ಯುವರ್ ಅಫಿಷಿಯಲ್ಸ್ ವೇ ಆಫ್ ಕಂಡಕ್ಟಿಂಗ್ ದಿಸ್. ಅಲ್ಲ ಫಸ್ಟ್ ನೀವು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು. ಅವ್ನು ನೀನ್ ಹೇಳ್ತಾನೆ ಅಲ್ಲ ಚಾರ್ಜ್ ನೀವು when you bring the charge you have to prove the charge. There was one bag, it was weighing so much and charge payable was this much, but he had not charged for that. According to he had not weighed and charged that at all. ನಿಮ್ ಚಾರ್ಜ್ ಪ್ರಕಾರ ಅವ್ರ ಚಾರ್ಜೇ ಮಾಡಿರ್ಲಿಲ್ಲ. he was transporting it to free of charge ನಿಮ್ ಚಾರ್ಜ್ ಪ್ರಕಾರ. So you have to show that
he doesn't say
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದು ಒಟ್ಟು 30 ಯೂನಿಟ್ ಅಲ್ಲಿಂದ ಸಪ್ಲೈ ಆಗಿತ್ತು ಟಿಕೆಟ್ ಪ್ರಕಾರ. ನಿಮ್ಮ he relies on your document only, exhibit M10 ಸರಿ M11 ನಲ್ಲಿ ಮುಂದೆ ನೀವು ಇನ್ನೊಂದು ಟಿಕೆಟ್ ತಗೊಳ್ತೀರಿ. he had taken 4338 ಅದೇ ಚೆಕ್ ಮಾಡಿದ್ಮೇಲೆ ನೀವು ಮತ್ತೊಂದು ಇಶ್ಯೂ ಮಾಡಿದ್ರಿ. ಸೊ burden was on you to show that you checked it, there was a luggage and it was weighing so much. There was one luggage. ಅವನ್ ಚಾರ್ಜ್ ಮಾಡಿದ್ಬಿಟ್ಟು ಇನ್ನೊಂದು ಲಗೇಜ್ ಇತ್ತು ಅಂತ ಹೇಳಿ. So what is the material for that? You have, first thing you have not weighed the luggage at all. Secondly, you have not recorded the statement of at least the driver. What is wrong in that tribunal holding that even if that is your statement is held to be correct, but that should be probabilized by legal evidence. ಅದನ್ನ ಅವ್ರು 4338 ಅಲ್ಲೇ ಕೊಟ್ಟಿರೋ ಟಿಕೆಟ್ಗೆ ಅದನ್ನ ಚಾರ್ಜ್ ಮಾಡಿದ್ದು ಅಂತ ಹೇಳಿ ಅದಷ್ಟೇ ಇರೋದು, ಅದಷ್ಟೇ ಇತ್ತು, ನಾನು ಅಷ್ಟು ಚಾರ್ಜ್ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. ನೀವ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. ಅಲ್ಲ ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಈಗ ಬಿಡಿ, ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನ ಹೇಗೆ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದೀರಾ ಒಬ್ರಿಗೊಬ್ರು. ಪ್ರಶಾಂತ್ ಈಸ್ ಆಫೀಸರ್. ನಾನು ಎರಡನೇ ಪಕ್ಷ.
Must be a show of today's ಸಂಸ್ಥೆಯ ಮಾಲೀಕರು ಆಡಳಿತ ಮಂಡಳಿ
ಇಲ್ಲ ಡಿಪೋಸಿಷನ್ ಅಲ್ಲಿ ಏನು ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ ನೀವು ಆಗ್ಲಿ ಅವರಾಗ್ಲಿ
page 50
Yes.
is the evidence. ನಾನು ಪ್ರಾಮಾಣಿಕವಾಗಿ ಹೇಳಿದ್ದೇನೆ ನಾನು ದಿನಾಂಕ 16 ಗ್ರಾಮಾಂತರ 2ನೇ ನಾನು ಕಾರ್ಯಾಚರಣೆ ಮಾಡುವಾಗ ದಿವಾಕರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದೆ ನಮ್ಮ ವಾಹನಗಳು ಚೈತ್ಯಾಧಿಕಾರಿಗಳು ವಸತಿ ಪ್ರಾಣದಲ್ಲಿ ತನಿಖೆ ಮಾಡ್ತಾರೆ ತನಿಖೆ ಸಮಯದಲ್ಲಿ ವಾಹನದಲ್ಲಿ 4 ಪ್ರಯಾಣಿಕರು ನಂತರ ವಾಹನದಲ್ಲಿ ಲಗೇಜ್ ಅನ್ನು ತನಿಖೆ ಮಾಡಿದಾಗ ಮುಂಬೈಯಿಂದ ಮೈಸೂರಿಗೆ ಸಾಗಿಸುತ್ತಿದ್ದ 5 ಯೂನಿಟ್ ಲಗೇಜ್ ಬ್ರಾಕೆಟ್ 17 ಚೀಲಗಳಲ್ಲಿ ತುಂಬಿದ ಚೀಲಗಳನ್ನು ಒಟ್ಟು 435 ಪಡೆಯದೆ ಅಧಿಕೃತ ಲಗೇಜ್ ಟಿಕೆಟ್ ಅನ್ನು ನೀಡುವಲ್ಲಿ ವಿಫಲರಾಗಿದ್ದಾರೆ ಎಂದು ನಾನು ಪ್ರಾಮಾಣಿಕವಾಗಿ ಹೇಳಿದ್ದೇನೆ. ವಿವಾದದ ವಸ್ತುಸ್ಥಿತಿಯನ್ನು ನಾನು ಪ್ರಾಮಾಣಿಕವಾಗಿ ಹೇಳುವುದೇನೆಂದರೆ 5/2013ರಲ್ಲಿ ಆರೋಪ ಪಟ್ಟಿಗೆ 11/2013 ನಾನು 18/9/2013 ಎರಡನೇ ಘಟಕದ ಅನುಸೂಚಿ ಕಾರ್ಯಾಚರಣೆ ಮಾಡುವಾಗ ವಾಹನ ಸಂಖ್ಯೆ F5003 ಸಡಕಾತ್ಮಕ ನಿರ್ವಾಹಕರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ್ದು ಸರಕಾರದವರಿಗೆ ನನ್ನ ಪಾಲಿನ ಕರ್ತವ್ಯವನ್ನು ಸಮರ್ಪಕವಾಗಿ ನಿರ್ವಹಿಸುತ್ತಾ ಮುಂದುವರಿಯುವುದು ಮುಂಬೈಯಲ್ಲಿ 12 ನಿಮಿಷದಲ್ಲಿ ತುಂಬಿದ ಚಪ್ಪಲಿಗಳಿಗೆ ನಾನು ಸಂಸ್ಥೆಯ ಉತ್ತಮ ಆದಾಯದ ದೃಷ್ಟಿಯಲ್ಲಿ ಅವುಗಳ ವಾಸ್ತವ ತೂಕಕ್ಕಿಂತ ಅತ್ಯಧಿಕ ತೂಕ ವ್ಯಾಪ್ತಿಯ 30 ಯೂನಿಟ್ಗಳ ದರ ವಿಧಿಸಿ ಟಿಕೆಟ್ ನಂಬರ್ 16 ವಿತರಿಸಿದಂತೆ ದಿನಾಂಕ 19/9/2013 ಮೈಸೂರು ಬಸ್ ನಿಲ್ದಾಣದಲ್ಲಿ ತನಿಖಾಧಿಕಾರಿಗಳು ಆಗಮಿಸಿ ತನಿಖೆ ನಡೆಸಿ stated in ITC is cross-examination. The cross-examination at paragraph number 4. Cross-examination examination in chief. Mysore Shoka footwear paragraph 4 page 56.
Yes.
Mysore Shoka footwear ಸಂಸ್ಥೆಯ ಮಾಲೀಕರು ಆಡಳಿತ ಮಂಡಳಿಗಳು ನನ್ನ ಮೇಲೆ ಆರೋಪಿಸಿದ ದಿನದಂದು ಚಪ್ಪಲಿಗಳನ್ನು ಚೀಲಗಳನ್ನು ಮುಂಬೈಯಿಂದ ಮೈಸೂರಿಗೆ ತಂದಿರುವ ಬಗ್ಗೆ 3 ಡೆಲಿವರಿ ಚಾನಲ್ಗಳನ್ನು ಹಾಜರುಪಡಿಸಲಾಗಿದೆ. ವಿಚಾರಣೆ 12 ಏನಲ್ಲಿ 2000
You are reading chief examination or cross examination? ಅಂದ್ರೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆದ್ಮೇಲೆ ಮತ್ತೊಂದು ಸರಿ ನಿಮ್ಮ ಇದನ್ನ ಓದ್ತಾ ಇದ್ದೀರಾ? Yes. One ನಿಮಿಷ. ಇದೆ. Yes.
ಮೈಸೂರಿನ ಶೋಭಾ ಫುಟ್ವೇರ್ ಸಂಸ್ಥೆಯ ಮಾಲೀಕರು ಆಡಳಿತ ಮಂಡಳಿಯು ನನ್ನ ಮೇಲೆ ಆರೋಪಿಸಿದ ಚಪ್ಪಲಿಗಳನ್ನು ಮುಂಬೈಯಿಂದ ಮೈಸೂರಿಗೆ ತಂದಿರುವ ಬಗ್ಗೆ 3 ಡೆಲಿವರಿ ಚಾನಲ್ಗಳನ್ನು ಹಾಜರುಪಡಿಸಲಾಗಿದೆ. ಅಷ್ಟು comprises the entire luggage. ನಿಶಾನೆ M12 ಏನಲ್ಲಿ 2595 30 ಯೂನಿಟ್ಗಳು ಸಂಬಂಧಿಸಿದಂತೆ ಸಂಸ್ಥೆಯ ಪರವಾಗಿ ನಾನು ಅಂದರೆ ಲಗೇಜ್ ಅನ್ನು ಸಾಗಣೆ ಮಾಡುವುದರ ಬಗ್ಗೆ ವಿಧಿಸಿ ಪ್ರಯಾಣಿಕರಿಂದ ಸಂಸ್ಥೆಯ ಪರವಾಗಿ ಪಡೆದ ಟಿಕೆಟ್ ನಮೂನೆ ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಚಪ್ಪಲಿಯ ಬ್ಯಾಗ್ಗಳನ್ನು ಸಾಗಣೆ ಮಾಡುತ್ತಿದ್ದ ಪ್ರಯಾಣಿಕರಿಂದ ನಾನು 1 ಯೂನಿಟ್ ಅಂದರೆ 8 ಕಿಲೋನಂತೆ ಲೆಕ್ಕಾಚಾರ ಮಾಡಿ 2595 ಲಗೇಜ್ ಚಾರ್ಜ್ ಅನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದೇನೆ. ಲಗೇಜ್ ಚಾರ್ಜ್ಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯೂನಿಟ್ಗಳನ್ನು ನಾವು ಇಡಿಎಂಗೆ ಸ್ವಯಂಚಾಲಿತವಾಗಿ ಆ 30 ಯೂನಿಟ್ಗಳಿಗೆ ಎಷ್ಟು ರೂಪಾಯಿ ಲಗೇಜ್ ಎಂದು ಪ್ರಿಂಟ್ ಔಟ್ ಬರುತ್ತೆ.
So instead of 20 kg, he made it 8 kg.
1 unit 8 kg.
Nim cross examination.
ನಾನು ವಿಚಾರ ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಾಜರುಪಡಿಸಿರುವ ವಿಚಾರ W1 ಹಾಜರುಪಡಿಸಿರುವ ಸಂಪೂರ್ಣ ನಾನು ವಿಚಾರಣಾಧಿಕಾರಿಯ ಮುಂದೆ W5 ದಾಖಲೆಯನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ. ವಿಚಾರಣೆ ಮುಂದೆ ನಾನು W5 ದಾಖಲೆಯನ್ನು ಸಹ ನಾನು ಹಾಜರುಪಡಿಸಿಲ್ಲ. W5 ದಾಖಲೆಯು ಅನುಕೂಲವಾಗುವ ಉದ್ದೇಶದಿಂದ ಆ ದಾಖಲೆಯಲ್ಲಿ ಉಲ್ಲೇಖಿಸಿದ ಮಾಹಿತಿಗಳನ್ನು W5 ದಾಖಲೆಯನ್ನು ಸೃಷ್ಟಿಸಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ. He improves the evidence. He said, I improve people and we do have a teaching and W5, W4, W6. This is how he does it. Everywhere he improves his case.
ಅಲ್ಲ ಫಸ್ಟ್ ನೀವು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಯು ಆರ್ ನಾಟ್ ಗೆಟಿಂಗ್ ದಟ್ ಪಾಯಿಂಟ್. ಚಾರ್ಜ್ ನೀವು ತಂದ ಮೇಲೆ ಯು ಹ್ಯಾವ್ ಟು ಪ್ರೂವ್ ದ ಚಾರ್ಜ್.
The luggage ticket is issued. The report of the
ಅದಕ್ಕೇನು ಏನಾದ್ರೂ ಪ್ರಿಸಂಪ್ಟಿವ್ ವ್ಯಾಲ್ಯೂ ಇದೆಯಾ? ನೀವು ಕೊಟ್ಟ ತಕ್ಷಣ ಅದನ್ನ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ.
they only have placed reliance on the judgment. That in fact the judgment which I am placing reliance on not the resources of the management cannot be doubted because the present in that case the hospital even statement of the ticketless passenger was also not recorded. That is not in the present case, we will figure out briefly the necessary facts. The Haryana Roadways is a state transport undertaking, and the respondent for us is a member of the government staff to conduct his job is to collect fares from passengers and issue tickets. Probably because conductors were collecting fares but not issuing tickets, the system of balance square was in operation. In the Haryana state, for the purpose of checking the proper collection of fares by conductors, the respondent before us while on duty on the strip from Bajara to Kodupar was the conductor whose vehicle was overtaken by the flying squad. The squad staff the bus and its inspector discovered that 4 passengers had alighted at Kamini Kade without tickets and 11 passengers traveling in the bus had also did not have tickets, although they claimed to have paid the fares. The report followed a charge sheet ensured a domestic inquiry was made, established, and simple termination of services effected. The respondent hesitated to give to a reflection that the order of calculation for the nullity, and he was therefore be given declaration of continuance in service. The trial court on the evidence was taken with this plea and appellate court also affirmed it. The High Court dismissed the second appeal. The state has come for a special leave in this circuit. The ground on which the court has declared the termination plan is that none of the 11 passengers have been examined at the domestic inquiry. Secondly, it has been mentioned that there is a departmental instruction that checking inspector should record the statement of passengers, which was not done in the case. The explanation of the state as both by the record is that inspector of the flying squad who had said that they had paid the fares, but they declined to give such written statement. Third ground which way the court was perhaps the co-conductor in the bus had supported this evidence the guiltlessness of the respondent. In a domestic inquiry, strict and sophisticated use of evidence under the Indian Evidence Act may not apply. All materials which are logically probative for a prudent mind not are permissible. There is no allergy to hearsay evidence provided it has reasonable basis and credibility. It is true that departmental authorities and administrative tribunals must be carefully evaluate such materials and should not be swallow what is strictly speaking not relevant under the Indian Evidence Act. For this proposition, it is not necessary to cite decisions or textbooks, although we have been taken from case law and other authorities by the council on both sides. The essence of a judicial approach is objective. Exclusion of extraneous materials or considerations and observance of rules of natural justice. Of course, fair play is the basis of equality or arbitrariness or surrender or independence of the judgment initiate the conclusion stage. Such finding even though of a domestic tribunal cannot be prepared. However, the courts could have misdirected themselves perhaps in insisting that passengers who had come in and gone should be placed and brought before the tribunal with a valid finding to be recorded. The residual rule to which the counsel for the responding effort based on the one certain passages from American jurisprudence does not go to the extent, nor does the passage from Hansberry insist on such rigid requirement. The simple point is there was some evidence, was there some evidence, and or was there no evidence? Not in the sense of technical rules governing the regular court proceedings, but in a fair common sense way as well of understanding the
So there, the inspector of flying squad.
The order is invalid on that. The evidence of the checking official is considered as evidence, some evidence. Here is a case where the checking official is examined and he comes before the court, inquiry officer, and produces the penalty receipt. It shows that penalty.
See, when some luggage is loaded in the bus at the starting point, how do you collect the charges for that? Whether any weighing system is there or
It will be. And it is certified by the transportation.
there.
In the court.
And why you did not do that exercise here again?
Because we not, he says he comes with the plea that there are 30 units. Now,
We ಅದನ್ನೇ ಹೇಳ್ತೀರಾ ನೀವು ಪುನಃ. See, we understand. I think if any irregularity, there should be some curable irregularity. He says bus came, there was luggage, this man had not charged. I saw this and charged him. That way, all right, if the checking was somewhere in between stations. Where is where the person who has paid this penalty has come before us?
that is not required. That's what that's what the
No, first thing we should satisfy. We should satisfy that this was weighed. Anyway, yes. What is the other? So you say that we should believe him. Tribunal should have believed him.
If he had the ticket of 30, that show that ticket that person was given 30 units. Ticket there was no impediment for him to show the ticket.
Have we initiated any disciplinary inquiry against this flying squad officer? He has not done his duty properly. He did not weigh his luggage.
Because he was available and I asked him not and he explained to me yesterday. This is how it is. But the fact remains we got that.
ಅದೇನೋ ಹೇಳ್ತಾರಲ್ಲ ಏನು ಮಗುನು ಚುಟೋದು ತೊಟ್ಲನು ತಗೋದು ಅಂತ ಹೇಳಿ ಹಾಗೆ ಮಾಡಿದ್ದಾರೆ ನಿಮ್ಮ ಆಫೀಸರ್. He has not worked. He has not worked.
He has not worked for this period, but therefore we not this. In fact,
But, if
there is no misconduct not registered against him after the reinstatement.
there was no misconduct registered after this.
He's been working and in India.
He was ಅದು ಬೇರೆ ಹೇಳಿದ್ರಲ್ಲ ನೀವು. He was out of service for how many years or date of dismissal was
18/3/2015.
Final order 18/3/2005 ಅಂತ ಬರ್ಕೊಂಡಿದ್ದೀವಿ. ಇಲ್ಲ ಈ ಚಾರ್ಜ್ ಶೀಟ್ ಇಶ್ಯೂ ಆಗಿದೆ ಅವಾಗ. ಸೊ ಫೈನಲ್ ಆರ್ಡರ್ ಆಗೋವರೆಗೂ ಇದೆ ಸರ್. So he had not suspended him.
That would not come to the packages in the from the date of dismissal 18/6/2015.
21/2/2017 is the order of award. June 2018. So after filing this writ petition,
Day of activity of service and 50% packages for state.
A2/2018. Activity of service that was paid.
Not up to this period.
Date of reinstatement, please read. So it is subsequent to. So for about 3 years, he was out of service. He was out of service.
I'm not because of this context not after the reinstatement. That there is no case registered. ನಾಲ್ಕು ವರ್ಷದಿಂದ ಒಂದು ಕೇಸ್ ಇಲ್ಲ.
ಆಯ್ತು, ಹಿಂದೇನಾದ್ರೂ ಏನೋ ಲಘು ಶಿಕ್ಷೆಗಳು ಅಂತ ಇದೆ. ಏನಾದ್ರೂ ಈ ತರ ಮಿಸ್ಅಪ್ರಾಪ್ರಿಯೇಷನ್, ಕರಪ್ಷನ್ ಅದ್ರದ್ದು ಏನಾದ್ರು ಚಾರ್ಜಸ್ ಇತ್ತ ಅವ್ರ ಮೇಲೆ ಮೊದಲು? ಒಂದ್ಸರಿ ಇದ್ರ ರೆಕಾರ್ಡ್ ನೋಡ್ಬೇಕಾಗುತ್ತೆ, ಒಂದ್ಸರಿ ನಿಮ್ ರಿಟ್ಪಿಷನ್ ನೋಡ್ಬೇಕಾಗುತ್ತೆ. ಅಲ್ಲ 31 ಕೇಸ್ ಏನದು? ನಾನು ಇಷ್ಟ ರೆಡ್ ಮಾರ್ಕ್ ಅಂದ್ರೆ ಏನದು? ರೆಡ್ ಮಾರ್ಕ್ ಅಂದ್ರೆ ಏನದು? Fail to collect 5 unit luggage. ಇದರಲ್ಲಿ ನಾನ್ ಇಶ್ಯೂನ್ಸ್, ನಾನ್ ಕಲೆಕ್ಷನ್. ಇಲ್ಲ, ಅಲ್ಲಿ ಕೆಳಗಡೆನೆ ಬರ್ದಿದ್ದಾರೆ ರೆಡ್ ಮಾರ್ಕ್ ಅಲ್ಲಿ, ನಾನ್ ಇಶ್ಯೂನ್ಸ್, ನಾನ್ ಕಲೆಕ್ಷನ್. ಆ ಕೇಸ್ಗಳಲ್ಲೂ ಕಲೆಕ್ಟ್ ಮಾಡಿ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ ಅಂತ ಇಲ್ಲ, ನಾನ್ ಇಶ್ಯೂ, ನಾನ್ ಕಲೆಕ್ಷನ್. ಅಲ್ಲ, ನಿಮ್ ಲಾಸ್ ಆಗೋದು ಬೇರೆ, ಕರಪ್ಟ್ ಪ್ರಾಕ್ಟೀಸ್ ಏನಾದ್ರು ಅಡಾಪ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರ?
Cannot issue ticket and not collected the fare. Dismissal is the appropriate punishment. 3 judges general. Even courts feed to this day that now. Kanisham Sharma, RSRTC, Kanisham by 3 judges. Where it says a conductor's duty is to issue ticket. Only the a conductor's duty is to issue ticket and collect fare. If he doesn't collect the fare, or if he collects the fare and gives it to himself, the loss is cost to him. His job is only to issue ticket and account for the same. If he has not done it, it has been held that the dismissal is appropriate.
So you are about back cases only now.
Because of your also asked me to find out what is his conduct now. So therefore, probably when I started the case, I was challenging the entire thing.
Then there is some basic defect in that. He has not weighed that luggage. Bus stand alli idkondo luggage weigh madilla antandre adu it creates doubt.
Nothing the basic cannot view that at this stage. I mean, like next to second case, CH-8 versus entitlement. In that case also, all proposition is that passenger need not be examined.
Yes, ಏನು ಹೇಳ್ತೀರಾ ನೀವು ಬ್ಯಾಕ್ ವೇಜಸ್ ಬಗ್ಗೆ? Setting up. Yes. Page 10 ಅಂತ ಎಲ್ಲಿದೆ? ಪೇಜ್ 10 ಅಂತ. Yes.
The finding should not be disturbed by the subsequent.
Yes.
Last time, the legislature just seems to have your question of time, so away not excessively in jurisdiction over the awards marked by the tribunal decided over the future officer. The findings of the audit is constituted for the purpose and which ordinarily should be considered to have been final. Cannot be based on for some mere reason of having been based on materials or evidence not sufficient or credible to the opinion of the report or those findings. At any rate, as long as they are based upon some material which are relevant for the purpose of or even on the ground that there is a view which can be reasonably and possibly be taken. The judgment was not only justified, but when verified in its principle of the order of the municipal being taken to the findings of the industrial tribunal as well as the order of the municipal and the judgment of the judgment, we are of the view that industrial tribunal had overwhelming material which constituted ample and sufficient basis for recording its findings as it did, and the manner of consideration undertaken, the objectivity of approach adopted, and the reasonableness of finding recorded seem to be unacceptable. The only course, therefore, open to the judge was to find out the satisfaction or otherwise of the relevant criteria laid down by this honorable court before sustaining the claim of the canteen personnel. So, the Supreme Court has held that in this present case, the tribunal had the materials before it and it is appreciated in the right perspective. So, there is no perversity in the finding of the labor.
Yes, what is that other judgment which I read?
And second judgment
Which one? Collection. Yes.
1998.
Yes. Yes.
Here, the punishment should be proportionate to the gravity of the misconduct. That is what it has been held by the Supreme Court. At page 71.
Correct. See, if at all if we hold that this non-payment, non-issuance of ticket or non-collection, then that is grave holding.
In this case, tragedy is your lordship. Here I have given excess revenue to the corporation. Still, they have made me the offense.
That is also wrong. That is also wrong. But anyway, you were not charged for that. You were not charged for that. Judgment unnecessary. See, this judgment seems to be unnecessary. Yakantandre charge prove agidre, then that is a serious misconduct. Charge prove agilla antandre you are entitled for reinstatement. Or the back basis ಬಗ್ಗೆ ಅಷ್ಟೇ ಅದಕ್ಕೆ.
And once charges are not yet proved, I'm deemed to be in the circle.
But you are not. You are in appeal. You are in fiction. There is the award. 50% back basis. Andre because you have not worked on that. No. Correct. You have not challenged that. Unless you challenge, how can you seek that? First party is entitled to 50% of back wages. 50% is awarded. You have not challenged the.
They have denied 50% because I did not work for the. Kindly see the.
Correct. Labor court award says first party is entitled to 50% of the back wages from the date of his dismissal.
The first party, by placing the cogent materials, has established that he is entitled for an order of reinstatement. The first party has not worked for all these days from the date of dismissal. He is entitled for 50% back wages as this court.
Correct.
And 50% already denied because I did not work for the relevant period.
ಅವರು ಹೇಳೋದಕ್ಕೆ ಸಬ್ಮಿಷನ್ ಬೇಕಾ ಇದೆ.
Give
50%.
That is only because charges said not closed And labor code has already denied because I did not know the regular rate. And further denial of 50% by this honorable court is not auditable as held by the Supreme Court because the award is based on the material total labor code.
Agreed by Good award and 2017 in tried in past by the court myself. The employer has preferred this fiction. The respondent was working in the petition establishment as a welcome conductor 1910-2013. The petitioner subjected the respondent to domestic inquiry for discipline, domestic inquiry on the ground that on 1910-2013, when the respondent was it was 1910 or 1909. ಇದರಲ್ಲಿ 1910 ಅಂತ ಬರ್ಕೊಂಡಿದ್ದೀರಿ. ಸಿನಾಪ್ಸಿಸ್ ನೋಡಿದ್ವಿ 1910 ಅಂತ ಇದೆ, ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ 1909 ಅಂತ ಇದೆ. ನಿಮ್ಮ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ತಪ್ಪಾಗಿ ಬಂದಿದೆ. ಶೀಟ್ ಇಸ್ annexure A ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ 1909-2013 on the charge that on 1909-2013 when he was on duty in route number 103 or 104 in the bus number F5003 from Mumbai to Mysore. The flying squad intercepted the bus in Mysore bus stop. Checked further alleged that the respondent cannot charge 5 units of luggage into bracket 12 bags of footwear, now amounting to rupees 435. Opponent had not charged rupees 435 for 5 units of luggage into bracket 12 bags of footwear from the passenger. Thereby he has committed the misconduct. Next. The respondent denied the charge sheet. The charge sheet is annexure A. For the charge sheet, the respondent issued the reply as per annexure B, stating that he had weighed all the luggage and charged that despite the passengers showing the tables and tickets, the flying squad issued another ticket billing, second time billing the same luggage. He further alleged that the officials of the respondent, petitioner, under coercion, collected the charges from the passenger and issued him the memo. The inquiry officer on conducting the inquiry under the report annexure C, ಆರೋಪಗಳನ್ನು ಸುಳ್ಳೆಂದು ನಿರೂಪಿಸಲು ಆಗಿರುವುದಿಲ್ಲ ಅಂತ. Held the charge is proved on the ground that the respondent has failed to disprove the charge and his defense statement is only afterthought. Accepting the said inquiry report, the petitioner issued the punishment order, annexure, paper. Annexure D, dismissing, dated 18/6/2015, dismissing the respondent from service. The respondent challenged the said award before Labor Court Mysore, challenging the dispute, raising the dispute. Under Section 10 into bracket 4A of Industrial Disputes Act, in IID number 25/2015, the Industrial Tribunal held that the inquiry conducted against the petitioner as a respondent was fair so far as the merits of the inquiry. The tribunal held that the inquiry officer has failed to, inquiry officer and the petitioner have failed to consider the relevant material and the findings of the inquiry are perverse. The tribunal accepted the defense of the respondent that there were only 12 bags weighing 30 units in purpose, and respondent had collected the charges for the same had collected the required charges for the same as per the management's own document exhibit M11, M10. M11. M11, not M10. M11. The tribunal by the award issued, set aside the order of dismissal, directed the petitioner to reinstate the respondent with 50% back wages, continuity of service, and all consequential benefits. Petitioner challenge the said award. Submissions of Srimati so and so, learned counsel for the petitioner. Exhibit W. W5 to W7, they're all concocted documents. The respondent went on improving his case. The tribunal do not have reassessed the evidence. The petitioner had no duty to chase the passenger who was fined and examine him. The tribunal, in reversing the order of the disciplinary authority, has exceeded its jurisdiction. In support of her submission, she relies upon the following judgments. State of Haryana versus Ratan Singh, year 1977, Supreme Court 1512. Karnataka State Road Transport Corporation, Central Offices Bangalore and Another versus Satyanarayana, 2003 to KLJ 125. The Northwest Karnataka Road Transport Corporation, Hubli and Another versus SS Polish. ಎಲ್ಲ ಒಂದೇ ಪಾಯಿಂಟ್ ಮೇಲೆ ರಿಲೇ ಆಗ್ತಿರೋದು. ಬರೀ ಹೇಳಿಲ್ಲ ನಾವು ಹಾಗಾದ್ರೆ ಎಷ್ಟು ಸರಿ ಪನಿಷ್ಮೆಂಟ್ ಆಗಿತ್ತು ಅವ್ರಿಗೆ? ಅಲ್ಲ ಅವ್ರ ಸಬ್ಮಿಷನ್ ಎಲ್ಲ ತಗೊಂಡು ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೇಳಿದ ಅಲ್ಲ ಅದಕ್ಕೆ ಒಂದು ಯಾವ್ದಾದ್ರ ಮೇಲೆ ಇದೆ ಅದು ಎವಿಡೆನ್ಸ್ ಬಗ್ಗೆ. ಹೌ ದ ಎವಿಡೆನ್ಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಅಪ್ರಿಶಿಯೇಟೆಡ್. State of Ratan Singh, ಅದೇನೆ. There cannot be the minute appreciation of the evidence. ಇದು ಮತ್ತೆ ಅದೇ ಸತ್ಯನಾರಾಯಣ ಕೇಸ್ ಸೇಮ್ ಅಲ್ವಾ? ಮತ್ತೆ ಯಾಕೆ why do you multiply the judgments? Passengers need not be examined already. Read a press.
Page 8, paragraph 7.
Already? No, you are relying on this judgment for on what point? ಇದ್ರಲ್ಲೂ ಸೇಮ್ ಅಲ್ಲ ಇದ್ರಲ್ಲೂ ಅದೇ ಇದೆ ಅಲ್ಲ ಫಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವ್ದಿದು ಸತ್ಯನಾರಾಯಣ ಯಾವ್ದು ಒಂದು ಲೇಟೆಸ್ಟ್ ಇದೆ ಅದನ್ನ ಒಂದು ಕೊಟ್ರೆ ಸಾಕಾಗುತ್ತಲ್ವ. ಲೇಟೆಸ್ಟ್ ವಾಸ್ 2000 ಅಲ್ಲ 2003 ಲೇಟೆಸ್ಟ್ ದಿಸ್ ಸತ್ಯನಾರಾಯಣ. This Raghunatha, this is for antecedents.
Yes. You can consider validity.
Having regard to the antecedents of the respondent, the petitioner had correctly imposed the punishment of dismissal. One sentence or judgments all highlighted. Submissions of Shri so and so yes that were considered for the respondent. The whole basis of the inquiry itself was not established. Petitioner's own witness said that they had arrived at the units of fire without weighing the ticket. Petitioner's own document exhibit M10 showed that the respondent had weighed the entire luggage and charged for that. The disciplinary authority had placed the burden of disproving the charge, which is unknown to the jurisprudence. Considering all such facts, the tribunal rightly reversed the findings of the inquiry officer, reverse the inquiry report and the order of dismissal. The scope of interference with such order in direct jurisdiction is there is no scope to interfere with such findings by this court in direct jurisdiction. In support of her submission, he relies on the following judgments. Anil Kumar versus the presiding officer and others. AR 1985 Supreme Court 1121. Indian Overseas Bank versus IOB Staff Canteen Workers Union and another. Then a report ಆಗಿಲ್ವಾ judgment? The sum and substance of the judgment laid on both sides on the industrial dispute jurisprudence is that the inquiry officer shall not be lightly interfered in the by the tribunal unless it is shown that the inquiry was unfair and the findings of the inquiry officer are perverse. The court cannot, tribunal cannot interfere with such findings. Further, the High Court in the jurisdiction cannot interfere with the order of the industrial tribunal unless it is shown that the tribunal in passing the order exceeded its jurisdiction or failed to exercise the jurisdiction. The specific case of the petitioner was that the respondent had not charged 5 units of luggage, causing loss of ₹435 to the petitioner, and the respondent had failed to issue luggage ticket to the passenger. The burden of proving the said charge was on the petitioner. As rightly pointed out by the Labour Court, the inquiry officer, instead of placing that burden, called upon the respondent to disprove the case of the petitioner. The defense of the respondent, as already stated, was that whatever luggage was there in the bus, he had weighed and charged that, and he had issued the ticket for the same. Therefore, the petitioner had to show that there was some other luggage left out in the bus, which were, for which ticket was not issued and which was not charged. To establish that, the checking was conducted in Mysore bus stand. According to the management witness himself, without weighing the alleged uncharged luggage, he issued second ticket shown in exhibit M10. According to both parties, 12 bags of footwear were transported in the bus. According to the exhibit M11, M11, according to the management witness, he collected the machine at the checking point. He collected machine ETM, electronic ticket machine. He collected the electronic ticket machine from the respondent. And issued M11 through the said machine. The exhibit M11 shows that for 30 units of the luggage, the respondent had already issued ticket number 4338, 004338, collecting rupees 2,595. Petitioner claims to have issued another ticket under 004339 for another 5 units of luggage, collecting rupees 435 from the passenger by way of penalty. The submission is that the passenger need not be examined. Even if that is accepted, the petitioner had the burden of showing that there was an uncharged luggage weighing 5 units. The bus was not intercepted, but checked in any remote area. It was checked in Mysore bus stand, which has all the facilities of, indisputably all the facilities of weighing the luggage. There was no explanation for such weighing would have proved that there was an uncharged luggage. There was no explanation on the part of the management witness for such lapses. Thus, the other document relied on by the management was exhibit M10, the fine receipt. It is contended that the respondent subscribed his signature on exhibit P10, admitting the weighing of 5 units and collecting the fine. According to respondent, the fine was imposed and his signature was taken under coercion. Question. So it is under such circumstance, at the cost of repetition, it has to be said that the basic fact of weighing of the luggage should have been there being weighing and there being a luggage which weighed 5 units should have been proved by weighing the luggage in the bus stand. The tribunal considering exhibit M11, considering the implications of exhibit M11 and the implications of the acts of the squad, not weighing the luggage, held that the finding of the inquiry officer was perverse.
Affirmative.
There is no scope for under the writ restriction. This court does not find it a fit case to further analyze the evidence and interfere with such order. So far as the back wages, once the charge itself is not held to, the question of considering the past conduct of the respondent does not arise. Therefore, the judgments relied on the said point serve no purpose. The tribunal considering the fact that the respondent had not worked from the date of the dismissal order till his reinstatement pending these proceedings, awarded only 50% of the back wages. The dismissal was on account of dismissal. The petitioner respondent not working during the period not working from the date of dismissal till his reinstatement was not on account of his fault. Therefore, this court does not find any infirmity in the tribunal awarding 50% back wages. There is no grounds to interfere with the order. Therefore, petition dismissed.
I appear for the petitioner in this case.
ಅವರು ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ, ನೀವು ಬರ್ಲಿಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್. ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಇಫ್ ಎನಿ ಅಂತ ಇದೆ, ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿರ್ಲಿಲ್ಲ ಅಲ್ಲ ಮೇಡಮ್ ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್?
ಬಂದಿತ್ತಿಲ್ಲ, ಒಂದು 5-6 ಸಲ.
ನಿಮ್ದೇನಾದ್ರೂ ಇದ್ರೆ ನಾಯಕರ ಆಫೀಸ್ದವರು ಇವತ್ತೇ ಆಗ್ಬೇಕು ಅಂತ ಹೇಳ್ತೀರಿ. ಇದರಲ್ಲಿ ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಗಿದೆಯಾ?
ಅಲ್ಲ, ಇದು this is with regard to the jurisdiction under
correct. This had taking compensation under Workmen's Compensation Act as well as Motor Vehicles Act.
Yes, so he has taken under Motor Vehicles Act already.
ಕೊಡೋದಿಲ್ಲ, ನಮಗೆ ಅರ್ಧ ಹೇರ್ ಮಾಡಿ ಇಟ್ಟಿದ್ದೀನಿ. ಇಲ್ಲ, ನಾಯಕರು ಏನೋ ಇರಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟೇ ಮಾಡಿಲ್ಲ, ಬಂದಿರ್ಲಿಲ್ಲ ಅಲ್ಲ ಅವ್ರು ಕಳಿಸ್ತಾರೆ.
ಬಂದಿಲ್ಲ,
ಅದಕ್ಕೇನೆ ಇಫ್ ಎನಿ ಅಂತ ಇಟ್ಟಿದೀವಿ ನಾವು. ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ ಅನ್ಕೋ ಹೇಳ್ತೀವಿ. ನೀವೇ ಮಾಡಿ, ಪರವಾಗಿಲ್ಲ. ಈಗ ಮಾಡಿದ್ರಲ್ವಾ ಒಂದ್ ಕೇಸಲ್ಲಿ, ಇವತ್ತು 230 ಅಂತೆ.
ಆಯ್ತು ಸ್ವಾಮಿ.
Last time she submitted, he received compensation under Motor Vehicles Act and he received that special allowance.
Yes.
And he filed another application under Workmen's Compensation Act.
No, idea act.
If any amount is paid under the motor vehicle.
And then they have referred to that judgment, but she relied on the Supreme Court judgment.
ಹೌದು ಸ್ವಾಮಿ, ಕೊಟ್ಟಿದ್ದೇನೆ. I have placed it on record, all the judgments, relevant judgments.
Last time Supreme Court judgment is covered by time. She has given a big compilation.
Yes, I have filed on 24th April 2017.
Yes, really, which is on that point about jurisdiction.
Yes, madam.
Not adjudicate dispute. ಈಗ ಬಂದು ನಾಯಕರ ಮಾಡ್ಬೇಕು, ಇಲ್ಲ ನೀವರ ಮಾಡ್ಬೇಕು. ವಿಲ್ ಪ್ರೊಸೀಡ್. ಅಲ್ಲ, ಎಲ್ಲಿ ಕನ್ವೀನಿಯಂಟ್ ಇಲ್ಲ ಅಲ್ಲಿ ಆಮೇಲೆ ಬರ್ತೀವಿ. ಅಲ್ಲ, ಕಳೆ ಸರಿನೂ ನೀವು ಬಂದಿಲ್ಲ ಈ ಕೇಸಲ್ಲಿ. ಈಗ ಇಫ್ ಎನಿ ಅಂತ ಇಟ್ಟಿದೀವಿ, ಅದಕ್ಕೆ 2:30 ಓದ್ಕೊಂಡು ಬಂದ್ ಮಾಡಿ. ಇಲ್ಲ ಇದೆ ನೋಡ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ, ಮಂಡೇ ಬೇಕಾದ್ರೂ ಪರವಾಗಿಲ್ಲ ಸ್ವಾಮಿ. ನಾಯಕ್ ಬರ್ತೀನಿ ಪರ್ಸನಲ್ ಆಗಿ ಅಂದ್ರೆ ನಾನು ಪರ್ಸನಲ್ ಆಗಿ ಬರ್ತೇನೆ. ಅದೇನು
ನಾಳೆ ಬೇಡ, ಮಂಡೇ ಬೇರೆ. ಆಯ್ತು,
ಮಂಡೇ ಸ್ವಾಮಿ.
ರೆಸ್ಪಾನ್ಸ್ ಕೌನ್ಸಿಲ್ as a final sense this time Monday. Yes.
I pay for the respondents.
Still respondents arguments if any ಅಂತ ಆಗಿದೆ. ಯಾಕೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಇವ್ರು ಬಂದಿರ್ಲಿಲ್ವಾ, ಭಂಡಾರಿ ಅವರು?
ಇಲ್ಲ, I am BL Sanjeev, my lord.
Next.
ಇದ್ರಲ್ಲಿ ನೀವಿದ್ದೀರಾ ಅವ್ರಿದಾರ
BL Sanjeev, my lord. We are on record.
ರೆಸ್ಪಾನ್ಸ್ ನೀವು ನಾಟ್ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್.
My lord, I think.
Yes.
My lord, matter is regard to 33C2, my lord. The corporation had filed a 33C2 application on the ground that the order is placed at page 55, my lord. 33C2 came to be allowed, and that has been challenged before my lords. The workman, my lord, was transferred from Davangere Puttur division for administrative reasons. And on 6/3/2015, he was relieved from the Davangere division, my lord. And he failed to report to Puttur division, my lord, and he remained unauthorized absent for duties.
Yes.
My lord, a domestic and disciplinary authority has passed an order on 5/2/2016 dismissing the petitioner herein, my lord.
Yes.
My lord, then a 33(2)B application was filed by the corporation, and the opposite party, there the petitioner appeared, my lord, at page para 3, my lord, at page 3, my lord. May I read that paragraph, my lord?
Word. Order.
Order, my lord, at page 57, my lord.
Page 3. Huh.
This tribunal had issued notices to the opposite party workman, though the opposite party appeared through his counsel, did not file any objections to the serial application. Therefore, objections by the opposite party is taken as per order sheet dated 11/5/2015. The opposite party workman, in spite of having knowledge about the proceedings, and did not contest the case. So 33C2 was not contested, my lord, and on merits, my lord, it was allowed. In the same way, my lord.
They have not raised any dispute also?
No, they had raised the dispute, my lord, but that was also been dismissed. And it was before this honorable court, my lord, and then it was withdrawn on, the dispute was withdrawn on, withdrawn on 27/9/2021, my lord.
What was that ID number?
ID number, what they have stated in the petition at page 14, my lord. Page 14 at para 35. 17116 anta bardidara, but that is not the petition, my lord. 15840 of 21 is the petition which they had filed.
Page 14.
Page 14 at para 35.
30 of 2007.
ID number is 30 of 2017. That was dismissed. And it,
Rejected
that was
on?
rejected. My lord, that was rejected on.
Rejected on?
Lord, I'll just get back with that.
1/5/2018 it seems. Third additional labor code, Bangalore.
Yes, my
Correct,
lord. I don't know, but I'll get that because there's another.
Lecture Z. This is the order copy. Yes.
My lord, then it was being challenged before this honorable court, my lord, in the WP number 15840 of 21, my lord.
Yes.
That was withdrawn by the petitioners herein on 27/9/2021.
Yes. 27/9/2021.
In between, my lord, this was filed on 5/8/2021, my lord.
Yes. Yes.
My lord, the labor court award was on, the tribunal was passed out. The serial application was passed on 27th March 2019.
Yes.
After a lapse of 2 years, my lord, this petitioner has come before this court challenging this order.
liberty to file fresh petition. They had withdrawn it with liberty. So whether any fresh petition is filed?
No, I'm not. I'm aware, madam. Lidaka, I'm not aware of.
Huh?
No, I'm not aware of it, but that was been withdrawn. But they said there's another number, my lord, 17116 of 2020, but that does not show any records in the High Court case status.
They have said so in their petition, huh?
Really, the 17116 of
17,116 of 2020.
Allah, there is no case registered as in that number itself, ma'am.
Huh? ಅದಿರ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ಆರ್ಡರ್ ಏನಾಗಿದೆ ಅಲ್ಲ ಅದು 15,840 ಇದೆ ಅಲ್ಲ ದಟ್ ಇಸ್ 15,840 ನಾಟ್ 17,108 ಎಫ್ಆರ್ ನಂಬರ್ ಮತ್ತೆ ನೀವಲ್ಲಿ ಪಿಟಿಷನ್ ಅಂತಾನೆ ಬರ್ಕೊಂಡಿದ್ದೀರಾ ನಿಮ್ ಈ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಆಯ್ತು ನಾವು there is the award really there. Then how do you maintain this petition? Award ZA na? ZA 69. Of 11th May 2018. No? The petition filed by the first party to set aside the dismissal order is hereby dismissed. Directed to publish the award. Now this award has become final. Correct. You had the order shows that you have withdrawn it with liberty to file the fresh petition. So you have fresh petition akila. So this order became final. ಅಲ್ಲ ಎಲ್ಲ ಅದ್ರಲ್ಲಿ ರೆಸ್ಟ್ ಜುಡಿಕೇಟ್ ಆಯ್ತಲ್ಲ Yes. Nimda. But correct. He order set aside order kuda sir.
There is totally punishment imposed. Is totally shocking the disproportionate to the misconduct. Then he is admitted. ನನ್ನ ತಲೆಗೆ ಸಿವಿಯರ್ ಕ್ಯಾನ್ಸರ್ ಇಂದ ಬರುತ್ತಿದ್ದ ಕಾರಣ ನಾನು ಒಬ್ಬೇ ಮಗ ಇದ್ದ ಕಾರಣ ನನ್ನ ತಂದೆ 12 ವರ್ಷ ತೀರ್ಕೊಂಡ ಕಾರಣ ನನ್ನ ಮಗುವಿಗೆ 3 ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ ಕಾರಣ ನನ್ನ ತಾಯಿ ನೋಡೋ ಆನಂದದ ಕಾರಣಕ್ಕೆ ನಾನು ಗೊತ್ತಿದ್ದೇನೆ ಅದಕ್ಕೆ ದಯಮಾಡಿ ಕ್ಷಮ ಮಾಡಬೇಕು
ಕರೆಕ್ಟ್ ಈಗ ಟೆಕ್ನಿಕಲ್ ಆಸ್ಪೆಕ್ಟ್ ಬರುತ್ತಲ್ಲ ಈಗ you withdrew another petition, you challenged and withdrew that. We cannot circumvent the order of the other bench. See, you challenge now that becomes res judicata. You challenge the main order. It is very application, the approval application. Adu
the same dismissal order.
Yes,
same dismissal order. But the main question is he admitted in this one that the punishment is totally quantum of
like, where is it permissible? Show us if it is permissible. If you challenge the same order in 2 proceedings and permit it to become final in 1 proceeding, then still this court can modify that order and ಏನಾದರೂ ಇದ್ರೆ ತೋರಿಸಿ ಮಾಡ್ತೀವಿ. You have invited this. What do you want to say? Sir. ಅಲ್ಲ ನೀವು ಅಷ್ಟನ್ನಾದ್ರೂ ಕೇಳ್ಬೋದಿತ್ತಲ್ಲ ಅಲ್ಲಿ. ಸಿ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಂತೀರಿ, ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಗಿ ಎಲ್ಲ ಮುಗಿದೋಗಿ ರಿಪಿಟಿಷನ್ ಅಂತ ನಂಬರ್ ಆಗಿತ್ತು ಅದು. Your submission that this was escape for DNP ಯಾಕಾಗುತ್ತೆ? ಅದ್ರಲ್ಲೂ ನೀವೇ ಇದ್ರಲ್ಲ. FR ಅಲ್ಲಿ ಇರ್ಲಿಲ್ವಲ್ಲ, ಅದು ರಿಪಿಟಿಷನ್ ಅಂತ ನಂಬರ್ ಆಗಿತ್ತು. Very difficult to accept this. ಅದಕ್ಕೆ ತೋರಿಸಿದ್ವಿ ನಾವು. We asked you if there is any other legal proposition to that effect, show us.
My lord, there was a memo filed by the petitioner themselves to withdraw the matter. It has been recorded in the orders. In 158 of 22.
840. ನಮ್ದು ಈ ಕೇಸ್ ಕರೆಕ್ಟ್ ಇಲ್ಲ. Yes, anything else? Yes.
Lord, I said this petition has to be dismissed.
ಶಾರಣ ಹೊರಗೆ ಕರೆಕ್ಟ್. ಈಗ ನೀವು ಅದನ್ನ ಇಲ್ಲಾಂದ್ರೆ ರಿವೈವ್ ಮಾಡ್ಕೋಬೇಕು, ಅದನ್ನ ಇಲ್ಲ ಫ್ರೆಶ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಬೇಕು. ಈಗ ಒಂದು ಪಿಟಿಷನ್ ನೀವು ಪರ್ಮಿಟೆಡ್ ದಟ್ ಟು ಬಿಕಮ್ ಫೈನಲ್, ದಟ್ ಆರ್ಡರ್ ಬಿಕಮ್ ಫೈನಲ್. ನೀವು ಒಂದ್ ಊರಿಂದ ಇನ್ನೊಂದು ಊರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರೆ ಹೋಗಿಲ್ಲ. ಈಗ ನೀವೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಈಗ ಹೇಳಿದ್ರೆ ನೋಡಿ. ಅಡ್ವೊಕೇಟ್ ಸರ ಬೇರೆ ಒಂದ್ ಎರಡರಲ್ಲೂ ನೀವೇ ಕಂಡಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ. ಯು ವಿತ್ಡ್ರೂ ದಟ್. ಅದ್ ಹೇಗೆ ಪ್ರಿಸ್ಯೂಮ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ನೀವು? Serial application is only for approval. You have raised an industrial dispute. ಇನ್ ಯಾಕೆ ಟೈಮ್ ಕೊಡ್ಬೇಕು? ನೀವೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಪ್ರೆಸ್ ಮಾಡಿ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಿ ಅವ್ರ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ. ಎಸ್, ಏನ್ ಹೇಳ್ತೀರಾ? ಟೈಮ್.
Lord, if there's anything to produce, ID has been dismissed. ID has been attained finality now.
ಈಗ ಅವ್ರು ಮತ್ತೆ ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಹಾಕೊಳ್ಳೋರು ಅದಕ್ಕಷ್ಟೇ
ಅಲ್ಲ, ಅದಕ್ಕೆ ಹಾಕೊಂಡ್ರೆ ಇಟ್ಸ್ a different cause of 33C2 is only an application.
If you succeed in that, we'll make that observation.
That's a different idral bari 33C2 ಅಷ್ಟೇ. This will not help in any way.
ಹೇಗ್ರಿ ನಾವ್ ಇಂಥದನ್ನ ಕೇಳೋದಕ್ಕೆ ಅಷ್ಟು ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ? ಈಗ ನಿಮ್ಗೆ ಗೊತ್ತಿದ್ದು knowing the effect or consequences of such act, you have withdrawn that. ಒಂದ್ ಪಿಟಿಷನ್ ಹಾಕಿಲ್ಲ. ಈಗ ಇದ್ರಲ್ಲಿ ಅರ್ಧ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ಮೇಲೆ ನಾವು ಕ್ವಶನ್ ಕೇಳಿದ್ರೆ ನಾವ್ ಟೈಮ್ ಕೇಳ್ತೀವಿ. ತಗೊಳ್ಳಿ, ಸರಿ ಬರ್ಕೊಡಿ. ಏನು ಹಂಬಲಿ ಇಲ್ಲ, ಎಂತದೂ ಇಲ್ಲ, ಬರೀ demand the matter. It's it. Q is at page number
55.
The petitioner was serving. The petitioner was appointed in respondent's establishment in Davangere Depot of Respondent's establishment on 23/3/2005. On 5/3/2015, he was transferred from Davangere division to Puttur division, and on the same day he was relieved. he did not report the transferred post till 13/5/2015. Therefore, the respondent issued charge sheet against him as per Annexure D. Contemplating the inquiry against him for the misconduct of unauthorized absence. From 6/3/2015 till the date of 13/5/2015. The respondent, the petitioner filed his defense statement as per Annexure E, admitting his unauthorized absence, contending that his absence was for the reasons beyond his control. That was on the medical ground of his mother. On such admission of the respondent, the inquiry officer submitted the report as per Annexure L, holding that the charge is proved. The inquiry officer further observed that the respondent can consider his request for transfer to a nearby place to his native village. The respondent heard the petitioner on the inquiry report. On such hearing, by order Annexure P, dated 5/2/2016, dismissed him from service. When inquiry ನಡೆದಾಗಲೂ ನೀವು ಹೋಗಿ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ. ಎಷ್ಟು ಜನ ಮಕ್ಕಳಿದ್ದಾರೆ? ಮತ್ತೆ ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ? Now he has to choose. ಅಷ್ಟೇ ಆಗುತ್ತೆ. ತಾಯಿನ ಕರ್ಕೊಂಡು ಹೋಗ್ಬೋದಲ್ಲ, ಇವ್ರಿಗೆ ಫ್ಯಾಮಿಲಿ ಇದೆ ಇಲ್ವಾ? ಇವ್ರಿಗೆ ಫ್ಯಾಮಿಲಿ ಇದೆ ಇಲ್ವಾ? ಇವ್ರಿಗೆ ಫ್ಯಾಮಿಲಿ ಇದೆ ಇಲ್ವಾ? ಇವ್ರಿಗೆ ಹೆಂಡತಿ ಮಕ್ಕಳು ಇದಾರ ಇಲ್ವಾ? ಮತ್ತೆ ಅಲ್ಲಿಗೆ ಕರ್ಕೊಂಡೋದ್ರೆ ಅವ್ರು ನೋಡ್ಕೊಳ್ಳೋದಿಲ್ವಾ? ಆಯ್ತು, ಈಗೇನ್ ಮಾಡೋದು? ನೀವು ಇನ್ನೊಂದನ್ನ ವಿತ್ಡ್ರಾ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಿ. ದಟ್ ಇಸ್ ಅಲ್ಲಿ ನೀವ್ ಯಾಕೆ ಈ ರೀತಿ ಮಾಡಿದ್ರಿ? ಇನ್ನೊಂದು ರಿಪಿಟಿಷನ್ ಟ್ರ್ಯಾಕ್ ಮಾಡಿದ್ರಿ. Since an industrial dispute was pending between the respondent and the union of its workers, respondent filed serial application number 97 of 2016 before the Industrial Tribunal, Bangalore, seeking approval of the section here, under section 33(2)(b) of ID Act, seeking approval of the dismissal order. The petitioner, despite service of notice in the said case, did not choose to contest the said case. The tribunal, when the impugned order annexure dated 27/3/2019, allowed the application. On the ground that the inquiry was fair and proper, and by paying 1 month's salary under annexure A1 in the said petition, the respondent has complied the provisions of section 33. Challenging the said order, the petitioner has referred the above petition. Challenging the order of dismissal, the respondent filed raised a dispute and which was registered in ID number 30 of 2017 before
Third additional labor code, Bangalore.
Third edition, got it. Third additional labor code, Bangalore. The labor code, ಅದರಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ರಿ ತಾನೆ, ಮಾಡಿದಿರಲ್ಲ. AW1 ಮುರಳಿ ಮೋಹನ್, ಅದರಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿರ್ಲಿಲ್ಲ. ಅದರಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ರಿ ಇಲ್ವಾ ನಿಮ್ಮ ಐಡಿಯಲ್ಲಿ? ಏನೋ ನೀವು ಎಡೋಕೆಟ್ಸ್ ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ ಅದಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ. ಐಡಿ ನಂಬರ್ 30 of 2017. Additional labor code Bangalore. ಮಾಡಿದಿರಲ್ಲ. WW1 ಶಂಬನ exhibit. In that case, both the parties attendance. The tribunal, by order dated 21/5/2018, dismissed the claim petition of the petitioner in ID number 30 of 2017. He challenged that order before this court in WP number 15,840 of 2021 into bracket case RTC. Page number 4. Page number 4. I have 30 ಅಲ್ಲ. Page number 4 ಅಲ್ಲಿ ಯಾವ್ದು ಹೇಳ್ತಾ ಇದ್ದೀರಾ? 30 ID 30 of 2017 ಅಲ್ಲ. ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ. ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ ಅದ್ರದ್ದು. 65 ಅಂತದ್ರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಇಲ್ವಲ್ಲ. ಅಲ್ಲಿ ಇಂಟರ್ನಲ್ ಪೇಜ್ ಇರೋದು. ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ 4. Under 16 or mark. ಅಲ್ಲ ನೀವು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಮೇಲೆ ಬೈ ಕನ್ಫ್ರಂಟೇಷನ್ ಹಾಕೊಂಡಿದ್ದೀರಿ ಅಂತ ಕಾಣಿಸುತ್ತೆ ನೋಡಿ. ಶೋಕಾಸ್ ನೋಟಿಸ್ ದಿಸ್ ಇಸ್ ಕರೆಕ್ಟ್. ಈಗ ಅದ್ರದ್ದು ಮೆರಿಟ್ಸ್ ನಾವ್ ಇಲ್ಲಿ ಹೇಗ್ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಬರುತ್ತೆ? ಏನ್ ಮಾಡಿದಾರೆ ಅವ್ರ ಮೇಲೆ ಈಗ ಹೇಳೋದಿಲ್ಲ ಎಷ್ಟು ಅಂತಾರ ಅದು ಎಬ್ಸರ್ಡ್ ಅನ್ಸುತ್ತಲ್ಲ. ಅಲ್ಲ ಕರೆಕ್ಟ್, ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಕನ್ಸಿಡರ್ ಮಾಡ್ಕೋಬೇಕಾಗಿತ್ತು. ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಏನ್ ಅವ್ರು ರೆಡಿ ಇದ್ರೆ ನಾವೇನು ಹೇಳೋದಿಲ್ಲ. ಜಾಯಿಂಟ್ ಮೆಮೊ ಹಾಕಿ ಬೇಕು ಅಂದ್ರೆ ಏನವ್ರು ಬ್ಯಾಕ್ ವೈಸಸ್ ಇದನ್ನ ಏನು ಕೇಳೋದಿಲ್ಲ ನಾವು ಅಂತ ಹೇಳ್ತಾರೆ.
I don't know, my lord. This I don't know. I'll have to ask.
ಏನೋ ಮದರ್ಸ್ ಹೆಲ್ತ್ ಗ್ರೌಂಡ್ ಇತ್ತು, ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಕರೆಕ್ಟ್ ಆಗಿ ಕಂಡಕ್ಟ್ ಮಾಡಿಲ್ಲ ಕೇಸು ಅಂತ ಹೇಳ್ತಾರೆ.
He could have appeared before the 33 CT application.
ಕರೆಕ್ಟ್ ಅಲ್ಲ, ಏನಾದ್ರೂ ಕರೆಕ್ಟ್ ನಿಜವಾದ ಗ್ರೌಂಡ್ಸ್ ಇದ್ದು ಅವ್ರು ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ರು ಬರೀ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಕ್ಕೆ ಹೋಗಿಲ್ಲ ಅಷ್ಟೇ ಅಂತ ಹೇಳಿ.
ಏನಾಗಿದೆ ಈಗ?
ಅಲ್ಲ ಬೇಕು ಅಂದ್ರೆ ಇನ್ನೊಂದ್ ದಿವಸ ಕೊಡ್ತೀವಿ. ನೀವು
now the ID is also withdrawn, my lord. I don't think corporation.
ಅಲ್ಲ ID ವಿತ್ಡ್ರಾ ಮಾಡಿದ್ರು ನೀವು ಸೆಟಲ್ಮೆಂಟ್ ಬರೋದಕ್ಕೆ ಏನು ಇದೇ ಇರೋದಿಲ್ಲ.
Settlement I'll have to ask the management, sir.
ರೆಫರೆನ್ಸ್ ಸೆಟ್ಲ್ ಆಗಿಲ್ವಾ ಅಲ್ಲಿ? ಮತ್ತೆ ಅವ್ರು ಬಂದಿಲ್ವಲ್ಲ ಇವತ್ತು? ನಮ್ದು ಬೇರೆ ಏನೋ ಕೆಲಸ ಇದೆ. ಎಸ್ ಏನು ಒಂದ್ ಚಾನ್ಸ್ ಕೊಟ್ಟು ನೋಡ್ತೀವಿ ಏನ್ ಮಾಡ್ತಾರ. ಹಿ ಇಸ್ ರೆಡಿ ಟು ಗಿವ್ ಅಪ್ ಎವ್ರಿಥಿಂಗ್ ಎಕ್ಸೆಪ್ಟ್ ಫಾರ್ ಸರ್ವಿಸ್ ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್.
Order can be dictated by chance.
ಅಲ್ಲಿ ಈಗ ನಾವು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ವಿ ಕಾಂಟ್ ಡೂ ಇಟ್ ಬಿಕಾಸ್ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಅನ್ನು ಫೈನಲ್ ಆಗಿ ಹೋಗಿದೆ. ಏನು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ my lord,
if you feel that
announcing the order can be kept in abeyance by time. I will also ask the management if they're ready for the settlement, and then if it is not
ಬರೀ ಫ್ಯಾಕ್ಸ್ ಅಷ್ಟೇ ಕೊಟ್ಟಿದೀವಿ. ಕರೆಕ್ಟ್. ಮತ್ತೆ ಅವ್ರ ಹತ್ರ ಹೋಗಿ ಕೇಳ್ಬೇಕು ನೀವು. ನೇಮ್ ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕಾ? ನಿಮ್ಮದು ಇಷ್ಟೊತ್ತನ ಮಾಡೋದಕ್ಕೆ ವಿ ಆರ್ ಸಿಟ್ಟಿಂಗ್ 10 minutes ಬಿಯಾಂಡ್ ಟೈಮ್. ಚೇಂಬರ್ ಅಲ್ಲಿ ಬೇರೆ ಕೆಲಸ ಇರುತ್ತೆ ನಮಗೆ. ಇಷ್ಟೇ ಮಾಡಿದ್ರು ಹಾಕಿದ್ದೀರಿ ಮತ್ತೆ ಒಳ್ಳೆ ಕಂಟಿನ್ಯೂ ಮಾಡೋದು. ಶ್ರೀ ಹರೀಶ್ since the DL Sanjeev has appeared for the response, raised to shall not show the name of Shri Harish Bhandari for the respondent henceforth. Okay. I have also for the petition. That petitioner is ready to give up all other claims except reinstatement in the service. The state proposal response council takes time to take instructions on the state proposal. List on date ಏನು ಎಲ್ಲ ಡಿಸ್ಕಷನ್ ಮಾಡಿ ಟೈಮ್ ಕೊಟ್ಟ ಮೇಲೆ ನೀವು ಇದು ಮಾಡ್ತೀರಲ್ಲ.
May I have a lordship's
yes.
May I make a small request, my lord?
Yes, yes, hey.
16ನೇ ಮ್ಯಾಟರ್ ಒಂದು ಉಂಟು.
ಎಷ್ಟು?
16 ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್.
ಏನಾಗ್ಬೇಕು? ಅದು
ನನಗೂ ಮತ್ತು ಕಸ್ತೂರಿಗೆ ಇಷ್ಟವರೆಗೆ ಅದೇನೋ ಸೆಟಲ್ಮೆಂಟ್ ಅದು ಇದು ಅಂತ ಇತ್ತು. ನೀವು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಒಂದು ಟೈಮ್ ಕೊಟ್ಬಿಡಿ. ಆಗದಿದ್ರೆ my lord, we will get ready and we have to argue this matter. If settlement cannot be, it cannot go through, then it will have to be argued.
ಇಲ್ಲ, ನಾನು ಆಫರ್ ಮಾಡಿದ್ದೀನಿ. ನಮ್ಮ ಸುಬ್ರಾಯ ಸಾಹೇಬರು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ನಾನು ಏನು
ಅವರನ್ನ ಕನ್ವಿನ್ಸ್ ಮಾಡೋದು ಬಹಳ ಕಷ್ಟ. ಪ್ರಯತ್ನ ಮಾಡಿ ಅವ್ರಿಗೆ ಕನ್ವಿನ್ಸ್ ಮಾಡಬೇಕಾಗಿದೆ.
As requested by the petitioners council, list on ಎಷ್ಟು ದಿವಸ ಟೈಮ್ ಬೇಕು ನಿಮಗೆ?
2 ವಾರ.
List after 2 weeks.
ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಅವತ್ತು.
ಮತ್ತೆ 2 ವಾರ
ಅಲ್ಲಲ್ಲ
ನೀವ್ ಹೇಳಿದ್ರೆ ನಾನು ಕನ್ವಿನ್ಸ್
ಕೇಸ್ಗೆ
ಮಾಡಕ್
ಅಲ್ಲ ನಾನು ಹೇಳಿ
16ನೇ ಕೇಸಿಗೆ 16
your
ವರ್ಷ
lordship
ಆಗಿದೆ.
may have it some 14th or some such thing.
19-4.
Yes.
ಅದು ಕೇಸ್ ಆಗೋದು.
ನಿಮ್ಗೆ ಅವ್ರು ಯಾರೋ ಬಂದಿದ್ರು
Mr. Kasturi, then I think some wisdom will dawn on him to settle this matter.
ನನ್ನ wisdom ಎಲ್ಲ
Mr.
ಅವ್ರು
Subramanian
ತಗೊಂಡ್ಬಿಟ್ಟು
thinks that always others have no wisdom.
ಮೈ ಲಾರ್ಡ್ ಇಸ್ ಕರೆಕ್ಟ್. ಸುಬ್ರಾಯರು ಹತ್ರ ಹೇಳ್ಬಿಡ್ತಾರೆ ಹತ್ರ. ಈಸ್ ಓನ್ಲಿ ವೈಸೆಸ್ಟ್ ಮ್ಯಾನ್.
ನೋಡಿ ನಮ್ಮ ಮೈಕ್ನು ಕೂಡ ಗಲಾಟೆ ಮಾಡಕ್ ಶುರು ಆಯ್ತು. ಸೀರಿಯಲ್ ನಂಬರ್ 2. ಶ್ರೀ ಯಾರು ಶ್ರೀ so and so learned SCP accepts notice for the respondent and seeks and list on 29. ಅವ್ರ ಹೆಸರೇ ತೋರಿಸಿ ಮುಂದಿನ ಸರಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 29.
Serial number 23, my lord.
ಒಬ್ಬರ ಸೀರಿಯಲ್ ನಂಬರ್ 18 ಆಗ್ಲೇ ಎಡ್ಜನ್ ಆಗಿದೆ ಅಲ್ಲ.
Serial number 23, my lord.
23.
So kindly after Monday, my lord.
ಮುಖಂಡಪ್ಪ ಅವರ
Yes, my lord. And the petitioner.
requested by the petitioner's counsel. List is the next week. Monday ಇಲ್ಲ next week ಅಂತ ಹೇಳಿ.
ಆಗ್ಬೋದು.
23 was series of matters ಅಲ್ಲ 24
ಅಲ್ಲ,
is this.
Individual.
Okay.
ரெண்டு 1:15 மென்ஷன் பண்ணாங்க. என்ன பண்ணுவோம்? Not correct.
आगे भी बात होने जा रही है, तो आगे बताइए क्या हुआ? तो सूरज जी मैं दूसरे कमरे में गए और सूरज जी ने अपने सर की कहानी की। हुआ था ये कि मीना और हिमालय जी का ब्रेकअप हुआ था। तो जब मैं कहानी सुन रही थी तब काफी इंसिडेंट्स ऐसे थे जहाँ पर मुझे उनकी याद आ रही थी और ये कहानी सुनने और सूरज जी को देखकर उन्हें एहसास हुआ कि मैं वो हर चीज कर सकती हूँ जो वो चाहते या actually it was too fine. I all identify. जो वो बता रहे थे आप रिपीट आ रही बहुत अच्छी लगती है लेकिन उसका बड़ा
Court officer. Court officer. Total 8.
ಹೌದು ಸರ್ ಟೋಟಲ್ 8.
The screen full ಬರ್ತಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ನೋಡ ಕೇಳಿದೆ ಅಷ್ಟೇ.
ಹಾ ಸರ್ ಆನ್ ಆಗುತ್ತೆ ಸರ್.
ಹೌದಾ?
ಸರಿ ಅಲ್ಲಿ ಅವರು ಆನ್ ಮಾಡಿದ್ದಾರೆ
ಹಾಕೊಂಡ್ರೆ ಇನ್ನು ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲ.
ಅಡಿಗೆ ಮನೆ ಬಾಗಿಲು ಹಾಕ್ತಾರೆ. ಮಾಡ್ಬೇಕು ಸರ್. ಇಲ್ಲಿ ಕ್ಲಿಪ್ಬೋರ್ಡ್ ಅನ್ನೋದು ಸೆಟ್ಟಿಂಗ್ ಇಟ್ಕೊಂಡಿದ್ದ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ. ಸೊ ನೀವು ಮಾತಾಡೋದು ಬೇರೆಯವ್ರಿಗೆ ಕೇಳುತ್ತೆ. ಮ್ಯೂಟ್ ಮಾಡ್ಲಾ?
change to this. Party ఏదైనా చాక్లెట్ ఇస్తా. ముందు ఫస్ట్ చాక్లెట్
finally serial number 35 is a part. I heard the petition of counsel and
serial
respondent ಆಗ್ಬೇಕು ಅದೇ ಪಾರ್ಟಿ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಯಾವುದು ಅಲ್ಲ ಆಕ್ಚುಲಿ petitioner counsel
ಬಟ್ ಎಲ್ಲಿದೆ 230 ಅಂತ ಎಲ್ಲಿದೆ
230 ಅಂತ
ಸರಿ ನೋಡೋಣ
ಬಿ ಗ್ರೂಪ್ ಕಂಟಿನ್ಯೂಷನ್
ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
My lords, appearing for respondent.
In which matter?
My lord, serial number 30, my lords.
My lord.
No. Yes.
My lord, password.
Password. Who is
Physically and senior is on the way. This password.
2002.
My lord, I appear, my lord, in this case.
No. Yesterday you said you are going to file a memo.
My lord, may I make a submission, my lord, with your lordships kindly? Now,
Yes.
what has happened is that union, my lord, which filed the writ petition, now, my lord, they were all absorbed in the Karnataka state mineral corporation. Some workmen, my lord, who took VRS, my lord, they have now been implemented. That fact, my lord, which I did not recollect. So there is some mistake. May I request your lordship? I have prepared a memo that requires some. Could your lordship may kindly have it on Monday, my lord? I will file that memo. Please give me time till Monday.
Yes, Mr.
My lord, in this matter, my lord, I think Mr. Subbarao had appeared, my lord.
Yes, I am appeared. I have appeared. I have no doubt about it.
So in fact, it's covered by the division bench judgment of this honorable court also.
No. What I'm saying is, it is correct. But there are some workmen, there was some grievance, which I will, for which, my lord, I have made an application. They have been impleted already. So that fact, my lord, I would like to bring to your lordship's kind notice. Next Monday, my lord, I will bring it to your lordship's notice. I want time till Monday.
No, what is ultimately you are going to withdraw or you are going to?
No. One part of the workmen, they are withdrawing. But there are certain workmen, they are entitled for some reliefs, some monetary reliefs that have to be granted. There
are only two petitioners. One is workman of Mysore Lamp Works Limited. The other one is Mysore Lamp Nivrutta.
Avardiga Mysore Lamps first iddaralla, avardu case mugdide as far as those are concerned, because they have already been absorbed in the mineral corporation. ಇದು ಈ ನಿವೃತ್ತ ಕಾರ್ಮಿಕರಿದ್ದಾರಲ್ಲ ಇಲ್ಲಿ VRS ತಗೊಂಡವರು ಅವರಿಗೆ ಸ್ವಲ್ಪ ಮಾನಿಟರಿ ಬೆನಿಫಿಟ್ಸ್ ಬರ್ಲಿಕ್ಕಿದೆ. Yes.
Please, madam.
We'll first take up this B group matters and come back to this final hearing matters. 2:30. There are some more B group matters left over.
My lords, on 28th, it may be kept at 2:30, my lords. This matter, serial number 30.
2:30. All right. 2:30.
Please.
Number 70, Sheila Krishna. For R2 and R3.
I appear for the respondent in this case.
My lord, with regard to payment of provident fund, my lord, by one company called Kaveri Telecoms. Now, my lord, this was with for the period 2012 to 2015. It's not that they have not paid. There was a delay in payment. Certain delay was there for payment of both the employers and employees' contribution. Now the question here is, my lord, under 7Q they have put interest. Now I have paid the PF in 2016 itself. Whatever was due was paid. On top of it, interest was also calculated, interest was paid. Subsequently, my lord, under 14B, penal damages also has been levied. The only question in this petition is, my lord, the levy of penal damages.
How much is that?
No, my lord, about 14 lakhs. My lord, annexure J. No, K, my lord. K, they calculate both.
3,97,000.
My lord, 90 page 95, annexure K, my lord, is the demand notice. Wherein they say, my lord, penal damages 9,97,642 and interest under section 7Q is 4,81,475. Both amounting to 14,79,117. Now, my lord, the amount which was, there was a delay in payment, my lord, that your lordship may kindly see annexure C. Annexure C is the summary, my lord. Your lordship may kindly take annexure C, page number 62. Page number 62. Your lordship gets it, my lord?
Yes.
From 2012 to December 2015, the amount was 31 lakh 417. And it was paid. That much was paid. Damages is rounded off to 9,97,642. Interest 4,81,475. They say the number of days delay and number. Now, my lord, there was an interim order here, my lord, in this petition, saying that I have to deposit 25% of the claimed amount, which I have deposited.
Damages, 25% of the damages or?
The total amount.
Yes.
25% of the total amount which was deposited, my lord.
When is that interim? They have filed application for vacating interim order.
They have
when the interim order is passed on which date?
Interim order was passed on 11th April 2017.
Was it on hearing both of you? Or?
Yes, my lord.
It was before their appearance.
It was paid, my lord, before their appearance. It was deposited in the court.
25%.
25. Yes, ma'am.
25% of dues, interest plus damage, including everything, 25%.
Yes, my lord. On the 14 lakhs, my lord, the 25% was paid.
Was that a disputed amount?
So, my lord, the only question here, my lord, was during that time, my lord, this they suffered losses and it was taken over by Edelweiss, my lord. Your lordship may kindly get it at page. Your lordship gets it at Annexure D, my lord. Annexure D, my lord, 63. My lord, although, my lord, I understand that mens rea does not, or the intention is not relevant here when there is a question of delay in payment, either the employer's or employee's contribution. There is number of judgments to that effect that mens rea is not relevant. But the question is, there is a proviso under 14B that if it is a sick unit, my lord, then, my lord, that has to be considered to that extent. Now, my lord, this was taken over, my lord, by the Edelweiss Asset Reconstruction Company as per Annexure D.
Yes.
Prativadigalu, Kaveri Telecom products, so and so, my lord. They specifically say, my lord. At least at the last paragraph, my lord, of this, they took the land, everything, my lord. May I read the order, my lord? It is just 1.5 page.
Petition is not being managed on its own. Somebody else is managing it.
Yes, my lord. So this was at that time itself, my lord. They went into a loss, and it was taken over, my lord, on this date.
What is the present position?
29 Adesha is dated 29/2/2016. Therefore, my lord, they could not, there was a delay in payment. Now that they have paid, my lord, in 2016 they have paid, they have cleared the dues. There are no dues. Either the employer's contribution or the employee's contribution, there are no dues. Now, my lord, to make it deterrent, this is a deterrent provision. Now, my lord, whether deterrent is relevant here or not, that is all in this case, in the circumstances of this case, my lord.
No, what is the illegality in this order now?
No, there is no illegality as such, my lord, because the provision, there is a provision 14B that they can levy penal damages. But, my lord,
is it your case that you have paid all of this contribution now by this time?
Yes, 16 itself we paid, my lord. In 2016 itself it was paid.
Both contribution and interest.
Yes, my lord.
Now only damages.
Damages with regard to penal damages is what we are saying.
Reasonable. Only thing is it should be given a reasonable opportunity of being heard.
Now I I was not heard. Of course, my lord, they say that they had issued summons, but I was not heard, my lord. I have not appeared. Your lordship may kindly see. Your lordship may kindly take, my lord, annexure H. Annexure H is the order. This is the H and J both I have impugned here. H, my lord.
You were not heard before this. Shokas notice 15
days, why damages envisaged under section 14B of the Act we not recovered from it. The employer was also given an opportunity to represent the case in person through a lawful agent on 5/5. The case was heard on 5/5. None appeared on behalf of the establishment. The case was adjourned to 19/5. Sri Shashikala, HR executive, and Raju, authorized representative, both are appeared on behalf of the establishment, but failed to give any authorization letter, which is a condition mentioned in notice under section 14B. However, the argument was heard and representation for grant of time was heard. The case was adjourned to 1/6/2016. None appeared on behalf of the establishment. Therefore, the case was finally adjourned to 8/6. Sri Ganesh, authorized representative, appeared on behalf of the establishment and raised no query, doubt, issue, etc. on the content of the notice or any matter consequential or incidental thereof in respect of said notice dated 12/3/2016. Department filed the proof of service of the notice sent to the employer, and thereby the establishment has no objection to the amount. The establishment has opted not to represent the case, meaning thereby the establishment has no objection to the amount communicated by notice dated so and so. In view of the same, the inquiry was concluded. Therefore, my lord, they say under section 14B, they have applied their mind, para 5, to the facts and circumstances of the case, and having perused the records and taking into consideration the defaults committed by the employer and the length of default, the loss of interest suffered by the Employee Provident Fund organization by not being able to invest the amount in time due to delay in remittances and a consequent loss of interest to the beneficiaries, the increased cost of administration, the amount of profit the employer might have earned by investing the amount of contribution and administrative charges elsewhere, and the deterrent element inherent in damages. I proceed to assess the dues and consider to levy an amount of rupees 9,97,647 as detailed below as damages on belated remittances for the months as mentioned in the revised notice period between 2012 to 2015, which will meet the ends of natural justice. So this is the amount they have calculated. And thereafter, my lord, they issue another final notice, my lord, as per Annexure K. It's a demand notice, my lord, saying that if 14 lakhs so and so has to be deposited or it will be recovered from us. And no other inquiry was heard, or we were not heard before this demand notice was where the recovery notice was issued.
Yes.
That is a short question, my lord. I have other than 14B, my lord, they are entitled to levy penal damages. There are several judgments which say penal damages.
Yeah, whether they admit that you are a sick industry?
They do not admit that I am a sick industry. They say it is only BIFR which has to consider whether I am sick or not, and the reconstruction process which the BIFR has to say. But my lord, I have provided the document that Edelweiss Asset Company has taken over all my assets at that time in 2016. Now, my lord, at least let them give me an opportunity to prove before them, my lord, one more opportunity, because I have not been heard fully at all. In case I can show all the records, I produce all the documents, and my lord, if I can convince the PF authority or establishment, my lord, that I was a sick industry at that time, whatever. One more opportunity, nothing will, they will not lose anything, my lord.
This court granted interim order subject to deposit of 25%. No, 25% is it 25% of 14,79,000 and odd?
Yes, my lord.
Yes, madam. Shweta.
With your lordships kindly. My lord, the present writ petition itself is not maintainable because of the provisions. In the statutory provisions, that is, they have to go before the CH-8 seeking an appeal against an order passed under section 7E and 14B. Your lordship may kindly turn to appeals to tribunal 7I. 7I.
Yes.
Mulad 7 appeals to tribunal. Any person aggrieved by a notification issued by the central government or an order passed by the central government or any authority under the proviso of subsection 3 or subsection 4 of section 1 or section 3 or subsection 1 of section 7A or section 7B or section 7C or section 14B may prefer an appeal to a tribunal against such notification or order. This is not maintainable under the petition itself. There are several judgments to that extent. So she has to go, the petitioner has to go.
What I have said in this petition about alternate remedy?
My lord, alternative remedy is a must in the statutory deposit because of the reason that whatever they are stating now.
No, what they have said in the petition about that?
Yes, my lord. Yes, my lord. I have stated. I have taken in my reply statement.
Our petition.
Swami.
Petition whether they have said anything about availability of alternate remedy.
Yeah, they have stated, but 14 idral hakidare Swami. Yellow illa anta heltare. They have not stated anything.
Oh, it was told
does not
that
have any other adequate, alternative and efficacious remedy, which is incorrect statement. At page 6, para 13 of their petition.
Now it was said that CH-8 is also not functional.
My lord, no, it is not functional because the PO is not on. They have not been appointed. But at the time of filing the writ petition and subsequently also, they were functioning. But still, stay order has been already granted by this court. It will be continued till they go before the appellate authority and files a CH-8, an appeal before the CH-8. That much order can be passed in this by this honorable court. Because 14B is a damages and the officer does not have any power for reduction because the statute itself prescribes the damages, quantifies and places it on record. Hence, the officer who has passed 7A and 14B orders is not vested with the jurisdiction either to reduce or to modify the interest or the damages on its own.
No, she was submitting that she comes under this proviso, second proviso. Second proviso to section 14B.
No, my lord, she doesn't come. They have only produced. They have only produced that they have gone before the what happened next, nothing is forthcoming. If at all there is and they come under proviso 2, they have to place it before the board. They cannot come before the honorable court and then say that I have already.
That's why they have not appeared there.
No, not at all. See, not only that, my lord, even 14.2 also, your lordship may kindly say, it says when they can go before the authorities. Only at the time of winding up. It is not that by mere filing an application.
14.2?
Yes. They don't come.
That is regarding, 2 is regarding suspension.
Yes, madam. That is, they don't come under any of this. 14B order is entirely different because levying penal damages for
before passing order under section 14B, the authority can reduce or waive the damages.
No, they don't have any authorities.
Which is under the scheme of rehabilitation. Central board may reduce.
These provisions, when there is a rehabilitation or the winding up proceedings, then only, otherwise they will not have any exceptions.
Correct. They say that they want to reduce evidence on that, so remand it.
Then they have to go before the CH-8. This is not the forum. This is not the court. They have to exercise.
Maintaining this order, you approach the CH-8.
Yes, my lord.
Interim order.
May I make one submission, my lord? May I make one submission, my lord?
Yes, yes.
Kindly take annexure K, my lord. Subsequent to H, they have order is passed under K. I have challenged that. K, my lord.
Correct. You have not appeared before them. You have not done the needful there. You are trying to invoke proviso, second proviso, but you do not go before the authority and submit all these records.
Yes, my lord, I did not have the authorization. Meanwhile, my lord, this was taken over by Edelweiss. There were so many problems at that time, my lord.
Correct. You go and submit all these things before the CH-8.
So, my lord, under
it is
this
agreeable for continuation of this interim order till CH-8 become functional. Let this order be continued.
Let be, yes.
No, my
There is alternate remedy.
Yes.
No, my lord, my only question is, my lord, annexure K, my lord, does not have an appeal.
Correct. See, annexure K is the offshoot, spring of annexure H.
Correct.
If you challenge that,
it is, my lord, it is under section 8, capital B, subclause 2. It is issued under 8, capital B, subclause 2.
annexure K.
Annexure K, my lord.
Where is the reference to that section here?
Here, my lord, 1, 2, 3. 5th line of the order, my lord. Annexure K.
Right officer has sent a certified copy of the said certificate to the undersigned under section 8P2. That is only recovery proceedings.
P2. Yes, my lord. 8.
Right. Yeah, so if the
certificate under subsection 1 not executing the proceedings for
right.
recovery of the arrears by any other mode which have been taken.
This is only consequent to the
recovery. And that is why I had to come before this honorable court and get a stay because, my lord, recovery had already been ordered and there was no appeal provision for recovery. Challenge.
That is only consequent to annexure
Yes,
H.
Yes,
If CJ stage annexure H, then K goes.
Correct. Yes, my lord. But why I have come before this honorable court, my lord? Because already a recovery certificate came to be issued, for which there was no appeal.
Next, madam, what she is agreeable and what we are saying is this interim order can be maintained and we can approach the
Very well,
CJ-8.
Very well.
They can approach. Till that time, till they approach and obtain stay order, this interim order may kindly be continued. And they amount
till they approach antadre
within 30 days. That is 30 days normal course.
Very well, my lord.
Within 30 days, they have to approach.
In a reasonable time.
And then the amount, if at all any deposited before this honorable court, be released in the name of the officer. That is EPFO. Because they are also
that is under dispute alva.
Dispute ಅಷ್ಟೊಂದಿಲ್ಲ ಸ್ವಾಮಿ ಯಾಕೆ ಅವ್ರು ಬೇರೆ ಬೇರೆ ಅಕೌಂಟ್ಗೆಲ್ಲ ಹಾಕಿದ್ದಾರೆ. I will take your lordships whatever they have said.
Damages whether
ಅಲ್ಲ damages ನಾವು ಕಟ್ಟಿದೀವಿ ಅಂತಲ್ಲ ಅದು ನಮ್ಮ ಅಕೌಂಟೇ ಅಲ್ಲ ಅದು ಬೇರೆ ಅಕೌಂಟ್ ತಂದು ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ
ಹೌದು. Your lordship may kindly see annexure G. What my learned friend says, annexure G 1,21,263 pertains to another account, not to my account.
I am not on G, my lord.
No, annexure, whatever they have deposited is not in this account.
The petitioner heard the petitioner is a company covered of employees provident funds and miscellaneous provisions Act 1952 for short Act 1952. Petitioner Issue. With a notice. Nature is the first notice.
And it's well, my lord.
Nature is the first notice.
Yes, my lord. 12/3/2016.
ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದಾರೆ.
Page 66.
As per election, he dated 12/3/2014. Saying that
Lord, one request before.
That, yes.
One request before your lordship. Whatever observations has been made, you should not be, yes.
Yes, only alternate remedy will ಮಾಡ್ತಾ ಇದೀವಿ.
Swami. And whatever observations with regard to the 7-year, 7 on merits should not be there.
The petitioner was issued with notice as per annexure E dated 12/3/2014 under section.
Claiming that it was issued by whom? Employees Provident Fund Organization. Notice was issued by which of the respondents?
Respondent number. Yes.
Respondent?
Recovery officer, respondent number 2.
Respondent 2. Telling that the petitioner is in arrears has failed to remit the EPF contribution in time, therefore liable to pay the damages and interest. The contribution in all amounting to rupees 14,79,170. Ultimately, an inquiry into that matter, the order as per annexure H dated 14/6/2016 was passed.
Respondent number 3. All the orders are passed by respondent number 3.
Ultimately, on holding the inquiry, respondent number 3 passed an order as per annexure H under section 14 Act. The effect that the petitioner is liable to pay is 9,97,642. Has delayed remittances. Damages, that is the damages on the delayed remittances. Consequent to that, annexure K dated 9/11/2016 a recovery notice under section 8B2 is issued for recovery of rupees 14,79,170 as penal damages and interest. The whole petition is filed seeking quashing of annexure H and K. The primary objection is regarding the maintainability of the petition against the order under section 14B of the Act. An appeal lies under section 7I to the Central Government Industrial Tribunal. Federal Counsel for the petition submits that against order annexed H under section 8(2), such appeal is provided under section 7(I). Annexed H is only a consequential order to annexed G. Therefore, annexed H being the main order is required to be challenged before the CC-8. This is an alternate efficacious remedy. It is submitted. That's why it is submitted that because of the vacancy of the presiding officer in the CC-8, the state tribunal is not functional. The circumstances, this petition is disposed of, reserving liberty to the petitioner to 25% deposit. The petitioner has deposited 25% of the admittedly the petitioner has deposited 25% of the claim under annexure K, annexure K, in compliance of the interim order of this court dated 11/4/2017. Under the circumstances, the petition is disposed of, reserving liberty to the petitioner to approach the CC-8 by way of appeal under section 7(I) of the tribunal, 7(I) of the Act. The interim order granted by this court shall, such appeal shall be filed within 30 days from the date of the receipt of the copy of this order. Interim order granted by this court shall operate till the appellant files the appeal and petitioner files the appeal and the CC-8 becomes functional. IA number. That has to be remitted to the ASI. Sorry, ASI. This amount 25% has to be remitted to. You mute ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
Third respondent ಗೆ release ಮಾಡ್ಲಿಕ್ಕೆ sir.
The amount deposited before this court shall be released to the third respondent.
I will take initially first time.
IA number. One of IA note pending. One of its intended is to dispose of.
Much of it.
TCR ಅಂತಾರೆಲ್ಲ ಕೇಳಿದ್ರೆ ಏನು
ಮೇಲೆ ಅದು ವಾಪಸ್ ಕಳ್ಸೋದಕ್ಕೋಸ್ಕರ ಇಟ್ಟಿದ್ದು.
already they have sent it. So not mentioned in the latest as per the registry is not the TCRs sent are defect. Registry is not the TCRs are not proper TCRs are not sent. Therefore, registry shall issue requisition to the court for resubmission of the record after rectifying the defects. List after ಬೆಳಿಗ್ಗೆ ಏನು ಅದರಲ್ಲಿ ಡಿಫೆಕ್ಟ್ಸ್ ಇದೆ ಅಂತ ಹೇಳಿ ಇದು ಮಾಡಿದ್ದಾರೆ. 2 weeks ಆದ್ಮೇಲೆ ಹಾಕೋಣ.
ಏನಾಗಿದೆ ಸ್ವಾಮಿ?
TCRs ನಲ್ಲಿ ಏನೋ ಏನ್ ಹೇಳ್ತಾರೆ M series exhibits are not mentioned in the annexures of the judgment. Check the entire record and entire exhibits. Page initiation not done properly.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಮೊದಲಿದ್ದ ಸಾಹೇಬ್ರು ಎಲ್ಲಾ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಒಂದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಮಾರ್ಕ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸಮಯ ಈಚ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕ್ಲಾಸಿಫೈ ಮಾಡಿಲ್ಲ.
M series exhibits are not mentioned in the annexure of the judgment. Judgment annexure.
ಅದು ಮತ್ತೆ ಎಂಟೈರ್ ರೆಕಾರ್ಡ್ಸ್ ನೆಲ್ಲ ಒಂದೇ ಒಂದು ಅನ್ನೆಕ್ಚರ್ R1 ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸಮಯ ಅಷ್ಟೇ. ಇನ್ಯಾವುದು ಮಾರ್ಕ್ ಮಾಡಿಲ್ಲ ಅವರು.
Annexure R1 is enquiry file. Annexure R2 is history sheet. ಅದನ್ನಾದ್ರೂ ಮಾರ್ಕ್ ಮಾಡಿದಾರಾ?
ಹೌದು ಅಷ್ಟೇ ಎರಡೇ ಮಾರ್ಕ್ ಮಾಡಿರೋದು. ಎಂಟೈರ್ ರೆಕಾರ್ಡ್ಸ್ R1 ಹಿಸ್ಟ್ರಿ ಶೀಟ್ R2 ಎಕ್ಸೆಪ್ಟ್ ಇದು ಬಿಟ್ರೆ ಯಾವುದು ಮಾಡಿಲ್ಲ ಸರ್.
ಅದನ್ನಾದ್ರೂ ಮಾರ್ಕ್ ಮಾಡಿದಾರಾ?
ಮಾಡಿದ್ದಾರೆ ಸರ್.
ಏನು ಇದರಲ್ಲಿ
ಹಿಸ್ಟ್ರಿ ಶೀಟ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ R2 ಅಂತ.
R1 ಇಲಾಖಾ ವಿಚಾರಣಾ ಕಡತ R1 R2 ಹಿಸ್ಟ್ರಿ ಶೀಟ್. ಪೇಜ್ ಇನಿಷಿಯೇಷನ್ ಇಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದೇನಾರ ಆದ್ರೆ ದಿಸ್ ಇಸ್ ಫ್ರಮ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರನಾ? ಈ 2 ವಾರದಲ್ಲಿ ಹೋಗಿ ಬರುತ್ತೆ ಬಿಡಿ. ಅವ್ರು ಕರೆಕ್ಟ್ ಮಾಡಿ ಪೇಜ್ ಇನಿಷಿಯೇಷನ್ ಮಾಡಿ ಕಳಿಸ್ತೀವಿ.
ಸರಿ ಸರ್, ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಸರ್.
2 weeks.
Please.
I'm appearing for the petitioner, my lord, on behalf of AJ Srinivasan. Senior is appearing before Court Hall 6. May I request for a short passover, my lord?
ಬೆಳಿಗ್ಗೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದಾರಂತೆ ಅದರ್ ಸೈಡ್. ಬೆಳಿಗ್ಗೆನೆ ಕೇಳಿದ್ರ ಅವರು? We'll have it on some other as requested.
Please, my lord.
Council list one.
Much obliged.
Number 21, Government Advocate, PS Nag for Respondent.
ನಂದು ಅದೇ 2:30 ಬನ್ನಿ ಅಂತ ಹೇಳಿ ಕಳ್ಸಿದ್ವಲ್ಲ. ಇದಕ್ಕಿಂತ ಮೊದ್ಲಿಂದಿದೆ ಪಾಸ್ ಓವರ್ ಆಗಿದ್ದು. ಯಾವ್ದೋ ಅಂತ ಅಲ್ಲ, ಅವ್ರಿಗೆ ಯಾವ್ದೋ ನೀವು 2:30 ಬನ್ನಿ ಅಂತ ಹೇಳಿದ್ರೆ ಹೋಯ್ತಾ? ಸರಿ, ಇದ್ರಲ್ಲಿ ಏನು
amount which is collected from the students who are paying this. So that amount will be collected and on the dividing system was paid out of that amount to the school. So second respondent, who was the principal of that college, was in charge Our he that actually that is after actually conducted by the students union and their approval taken and the second the president of the committee of the student. The president of the committee here is the second petition. Our principal of the college, they are given a committee like in his capacity as the president of the committee. So she that the first respondent was service was taken for 9 years of work, but there is no any kind of relationship with the state. State government is already someone. When you committee a chairman and out. So court has passed the disposed order. Just now I have read. The discussions will kindly see which will commence from paragraph 10, page 25. And with the pending to the case, awaiting application and the disposal. After pending to the order, other day, approach money, the Korana will after the Bandai. The order
Page number.
Order passed.
Date order dated? In 2017. Petition itself is of 2019. 17B raises again. Which is date of order? IA 1 of 2019. In WP number. First one. Federal Council appearing for state submits that if respondent approaches the concerned official person relating to grievance of the person for payment of 17B wages in terms of statement of objection filed on behalf of the government will be redressed. This submission is placed on record. Accordingly, IA 1 of 2019 by direction stands disposed of directing the response workman to approach the concerned official relating to the payment of 17B wages. Mr. Order. 15/4/2020. Now whether he has approached. Yes, yes, para 10 number.
The evidence of one is defective. He was appointed to the second party about 9 years. And served honestly is also done by the second party. To calculate a very minimum amount of because lesser than minimum wage by order. W number 1 has further report that initial pending family members of the dependent on wages earned by to count discharge by you. It is further evidence of the one that he demanded for payment of wages for the work done, which was for more than 8 hours a day. For which second party received employment from 2015. The act of second party was just taken as part of these all constitutional. As according to the first party the court of March 1 before. In the course of class examination, as I admitted that this is foundation, found place in the two document and he has 5 weeks after before the court mark to read the content written and speech and understood. Character of the class examination. The first party reactor, he joined the subject of the second party about 2 years back, but he did not remember the month and year in which he was appointed. And the rest of the class of he joined the service of the state and he was taking the means party, the evening of the party. It existed by one, and there was no proper advertising advertised in any part that there was any form by a part by executive party with the report of the state. With help of one person, W1 has answered that the angel went to the archive with help of one person and joined them. With W1, and there was no instance of the employment matter produced by the author. It is actually W1. When there was a case in the fall, the author was not done the first meeting. I was about 3 months in India, and during the time when the author was closed on all applications, the policy, there was no work in the office. It is denied by the one that you are not paid with the wages or work salary, but the honorary payment was made. It is admissible to the one that he made a representation to the municipality to pay off the expenses of the office. A previous suggestion was put to the one that you are not here in the term the author and used to attend the work in the front of the and you want to pay together and also use to keep the presence other materials because close participation of the student. Having noticed is not good act on part of one part. The college pays have complained to the paper and the committee of the college pays have reduced service of the W1. Public service to one and answer to the mail. Retracting or that all such applications made administrative where false allegations. Even if design may given official and other and they have cut off the cables of the student unnoticed that illegal activity by anyone. Parties also W1 have denied possession. Denied by W1 and he was working on how many cases in the park. It was not and he was not the one side to define the purpose of the W1 gave stop by sense of the M1 the effect that he was the president of Maharashtra Art College Orchid from 30 July 2016 to May 7. Since he was a teacher for the college, the evidence of the W1, the first party was never appointed by the author of that. Since there was no granted to appoint the book. The evidence of M1 that the expenses of the author are being paid to the who were the image of the author by revised system and subject to the payments of book and certificates were paid by the students there. In the evidence of the M1 is to the effect there was no employment for and the first part was being a harmful who was appointed the leaders of the to prepare to to serve the image of the heart. It is evidence of M1 that the author was run by the director of college education and it was not after run by the board by providing the land to maintain the author thereby it was not just beyond defined purpose. M1 has further report that there was no refusal of certain purpose. At the first time, first party itself has crossed the one in the hospital. Thereby, there was no refusal of plan. It is not entitled for any doctor. In the cross examination, in the course of cross examination, the actor will answer. In none of the records maintained by the hospital, name of the third party is not placed and workman of and it goes to report the first part was not in parallel by the right answer the stop to attain to what work 1 p.m. then back up 1 cook would start working from 2 p.m. to 8 in parallel of the process and the work as coach that there was no wages which the cooking stop. Since they were paid with 125 what we can if they took it by using of the parallel and one another who are writing Srimati Asuya was paid on a future those documents are come to March as a user. It was suggested to M.W.1 that there was a circular issued by the Directorate of College Education in which it was ordered to pay minimum wages to a temporary workman appointed, but M.W.1 has answered that he does not know about it. It was also noted to M.W.1 that as the document should be the total of participation as revenue of they are made entitled to get the minimum wages as it was party also M.W.1 has answered that he is not that the position was put there but there is some legal impact in the college because published in the newspaper that in that connection the Minister of Education was very probably M.W.1 after run by the college is not continued. But after run under the control of the Directorate of College Education, the answer by the M.W.1 and the honor was paid to the system. They are taking the on a and we have no objection for consent. However, meeting held with the party on the advice of the constitution, where the constitution of the second party was to exceed by implying that the third party was no and answer that in the meeting held at eight and nine, and the members of the governing party now disagree to find and to give legally the first party or on the ground that the legal of the party was not respected and they were complained by the government. They were not being pursued. But there will be a effect because they might when you are appointed to the government and you are taking of wages of 15,000 per month and if you use the entire agreement, it is to employment of the first party. Then end of the one united that it is not on basis of the certain cases first party has to include the approval document which is taken by the principal of the state or the student are together. It is certificate the labor conciliation officer other reason that there was a strong validity to the first party results who were the unit of law. Executor just to is a letter and 3 where they thought they are taught of their own honor and use of the name of one party but in the process another those second party in the competition also in the evidence of the have 15 and used the evidence. The first party never applied to the second party and as was applied to the leaders of today who look after the artistry. They accused documents are found with the second party. Also, the evidence of M.W.1. Clearly, what party was not applied to the second party. Alice has served more than 4 years on the date of the two. Then to remove the exception and document by principal of Maran next week. Even also supports the foreign development Director of College Education, Bangalore, has issued a circular located in Karnataka and the results are concerned, who have to pay the minimum wage to the workers who are working in the hospital, the categories of the hospital. Like you would come forward with the people of constitution, like the labor constitution, paying also, they see that the employment of first party, and you can do 5 to 7 after, which are completed by the trial of the first part to the members part, which are done to the third. In IIU, 12 parts for 72 by 8, you are also on the little particular document, we have a way of the months, December 2016, January, March 2017, for the month of January 2016, and the next one for the month of December 2016, the month of 2008, for the month of March 2017. On peripheral of executor 8 and 9 documents, they are in execution. Where they have discussed the issue of the employment of the first party, but was not issued and on the level for W8 and 9 they got to the second party the evidence of MW1 and first party was the 5 days of the author, and they are paying on the amount not whatever is called the second party stage number 2. It was also to the way considered by him to second party. The appointment of the first party was by leader of the state there can be no reason for the 2000% of the market to stay the paper or contrary to the first party. So also to one another thing on IIT 12 party 17 the same document one in March from a W5 sorry pages of the first part so it is to collecting among some the evidence of end of one the effect that there was no bank given by the government after it run under the control of the landscape of policy. There is no conflict. So there was a grant used by the government of Karnataka to run the policy through that fund. He was paid 2 months under the circumstances. The mode of payment of the use may be through other of amount transmitted to them who were the beneficiaries of the first party. But the second party are responsible and therefore direct approval by the second party to agree to show the use of the students have applied to the first party to work as a system. The year long of the first party during the vacation to the college not before to the first party of the student, but the totality of the evidence is that the first party was applied to the second party of students. The work related to by the party of the party. So also overseas the party of the state of the party. It is very important to recognize the second party is not
So ultimately, it was held that you are the workman with wages of 4,450 per month. Duty worker. Records ಬಂದಿದೆಯಾ? ಬಂದಿಲ್ಲ. You got for the records. Records call for modern intermodal. Call for DCRs. Interim order ಇತ್ತಾ ಇದರಲ್ಲಿ interim stay ಆದ್ರೆ interim order ಅಲ್ಲ interim stay as per ಪರವಾಗಿ interim order granted early granted on 6/2019 extended till next year in date. ಅದೇ ನೋಡಿ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇದರ has gone and reported to the duty settlement. Call for TCRs ಅಂತ ಹೇಳಿದ್ರು. Extend. The rule ಅಂತ ಮಾಡಿ.
Appear for the petitioner, Mela. Pray for 2 weeks. I pray for 2 weeks. I pray for 2 weeks time, my lord, in this.
Please be the respondent.
For respondent, my lords.
Respondent. Sir, I am appearing for petitioner in 22.1.
Appear for the petitioner. I pray for 2 weeks time, my lord, in this. To address final argument. Pleadings are complete. Final arguments are to be addressed.
Already arguments have been addressed for 4 days in this matter before another judge.
Respondent number 2 in 22.1, my lords.
He is seeking adjournment.
My lords, can I make one submission on behalf of the workmen, my lord? In fact, we have filed one application seeking vacation of the interim order, my lord. Lordship may consider that application at least, my lord.
I will argue. I am
no, in the first matter, I am appearing.
Then what remains? If the application is decided,
matter,
what remains? Nothing remains.
Where is the proof? Basaraj, Sabrad. As requested by the petitioner's counsel. One matter is 2014, other matter is 2019. Why?
My lord, connected matter has no relevance for the first case, my lord. It is unnecessarily, my lord, connected. It is my instructions. It has nothing to do with, my lord, the first
point
case.
is this. The point is this, my lord. Whether 17P wages is exigible for provident fund contribution. Our submission is 17B wages paid is a compensation pending disposal of the writ petition. Therefore, no contribution can be paid on the provident fund, because suppose this court decides no back wages, then the question of contribution doesn't arise. Therefore, the question is that my case is linked with along with the other petition.
In our case also 17B is involved. For 4 years we had paid 17B wages.
Yes,
in which the
17B is
contribution
involved.
Two weeks.
I appear for the respondent.
11/4.
Connected matter.
11/4.
My lord, date, my lord.
11/4.
Madam, my lord, 7th, other than 7th floor, my lord, 7th is
11/4.
Hannandu.
Oblige.
Number 23 adjourned. Still number 24. P. Prasanna Kumar, K. Srinivas.
24/1/8. You represent petitioner. Whom do you represent? Petitioner? There are two. One of 2021 is also to bring LRs. Five of 2022 is also to bring LRs. One second, we'll see. One of 2021 is filed by representatives of the respondent. One of 2021. 5 of 2022. ಎರಡರಲ್ಲೂ ಡಿಲೇ ಕಂಡೀಷನ್. Respondent on the whose respondent is dead. Sole respondent is no? Dated 2019. He died. These petitions are of the year. You're the 2020. No. Correct. He died on 8/8/2019. Before you filed the petition. Petition is filed in which date? October 30th October 2019. But he died on 8/8/2019. So you have to include the LRs, not bringing the LRs on record. When the tribunal's award was passed, 33/2019. So he died after award, before you filed the petition. So this is filed, this I-8 of 2021 of 2021 is filed by the LRs themselves. Orders and number. Lekin delay condonation question baradilla. The petition should have been filed directly against the LRs. 24.18. The petition is filed. The award is at page number. Award dated 30/3/2019 in ID number 20 of 2017, passed by the Municipal District and Session Judge Kolar. ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದ ಐಡಿ ಯಾವುದು? there were common orders ಇಲ್ಲ. Respondent Ravi M was the claimant of the said petition. After passing the award, he died on 8/8/2019. This petition is filed on 30/10/2019. He is a dead person. I-1 of 2021 is filed by the LRs of the respondent to come on record as a wife and children of the respondent come on record his as his LRs. I of 2022 is filed by the petitioner to bring the same persons as LRs on the record. Since the death itself was reported after the petition was filed, there is no dispute with regard to relationship. Petitioner is permitted to bring the LRs on record. Delay of any abatement question baradilla. Since there is no question of abatement of the petition or abatement of the petition. The applications for condonation of delay and abatement of setting aside the abatement are redundant. and disposed of redundant. IA 1 of 2021. One of 2021 ಇನ್ನೊಂದು ಅಲ್ಲ one of 2022, 2 of 3 of 2022. ಅಂದ್ರೆ ನೀವೆಲ್ಲ ನೀವು ಕೂಡ ಸೆಟ್ಟಿಂಗ್ ಅಸೈಡ್ ಅಬೇಟ್ಮೆಂಟ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಹಾಕೊಂಡ್ರ ಅಲ್ಲ IA 1 of 2021 ಅಲ್ಲೇ ಹಾಕಿದ್ದೀರಿ. ಆಮೇಲೆ ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಅಬೇಟ್ಮೆಂಟ್ 2022 ದಲ್ಲಿ ಹಾಕಿದ್ದೀರಿ. Therefore, IA 1 of 2021, IA 1 of 2022, and IA 1 to 3, 1 to 5 of 2022 are disposed of accordingly. The petitioner shall amend the short title of the petition and furnish the amended petition copy. In the case, okay, what is the other challenge here? Industrial district order dismissal. Order of dismissal.
Termination of employment or calendar before the effect.
Termination of employment on what ground?
On the ground that there is no the continuity of work. They contented that there was no work.
Layoff. As a district list on Ella matter. Date. ಇಂಟ್ರಿಮಾಡ್ ಇದ್ರಲ್ಲಿ ಇದೆಯಾ ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಅಲ್ಲಿ ತಗೊಂಡು ಫಸ್ಟ್ ಒಂದಲ್ಲಿ ತಗೊಂಡು ಈಗ ಇದು ಫಸ್ಟ್ ಇಂಟ್ರಿಮಾಡ್ ಇದೆ entry model granted earlier is extended to next year.
Number 25.
I appear for the petitioner's counsel, my lord.
Connected petitioner, my lord.
Yes. Now, my lord, I have filed the petition. I have given a synopsis also, my lord.
Sir, we have not received a copy, sir.
The synopsis is the same what we have filed in the writ petition.
Okay.
You are referring to the same synopsis?
It is the same, my lord. May I now proceed, my lord?
Yes.
Now the petitioner, my lord, was an engineer who has got a degree, my lord, from the University of Pennsylvania.
My lord, sorry to interrupt, learned senior counsel, only one submission. After he finishes his submission, my lord, because I've got my citations, because I knew he's appearing on video, I may be permitted to appear physically and file the citations also. After he finishes his one.
Of course, you are entitled to after I finish the arguments.
No,
I have no issue with that.
I'm just telling my lord, not you.
No, that is why I am also only replying to you.
You should learn from Mr. Subbarao how to fight.
My lord, he is my biggest hero. I always tell him that at his age, if I can be 50% of him, I have achieved something in life.
My lord, I think I have, for having become the lawyer, I think now I should say I have achieved something from all this.
You should
My
say
lord,
that you have many fans like Mr. Ajesh Kumar.
My lord,
And
we
if
go
both
to
of you
the,
come to the court, courts are scared.
my lord, he comes from the hospital directly to argue a case.
That is the spirit.
No.
Mr.
Kasturi is referring to some other spirit, my lord. I will not agree with that.
Yes, others are asking how much time you may require.
It will require, my lord. It will take the whole day.
Whole day.
ಇನ್ನಿರೋದೇ 1 ಗಂಟೆ. ಇನ್ನಿರೋದೇ 1 ಗಂಟೆ ತಾನೆ.
ರಿಲೀವ್ ಮಾಡ್ತೀವಿ, ಅದಕ್ಕೆ ಬೇರೆಯವ್ರನ್ನ ರಿಲೀವ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ಪಾಪ
ಅವ್ರನ್ನ ರಿಲೀವ್ ಮಾಡಬಹುದು ಸ್ವಾಮಿ. ಅವ್ರನ್ನ ರಿಲೀವ್ ಮಾಡಬಹುದು ಕೋರ್ಟ್.
ನಿಮ್ದು ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡಿ ಅವ್ರದ್ದು ಇನ್ನೊಂದು ದಿವಸ ತಗೋಬೇಕಾಗುತ್ತೆ.
ಇಲ್ಲ ಅವ್ರನ್ನೆಲ್ಲ ಕಳಿಸ್ಬಿಡಿ, ನಮ್ದು ಕೇಸ್ ತಗೊಂಡ್ಬಿಡಿ.
ಅಲ್ಲಲ್ಲ ಅದಲ್ಲ ಅವ್ರಿಗೆ ಇನ್ನೊಬ್ರ ಅಲ್ಲ, ಅವರು ಹವಾಲ್ದಾರ್ ಅವರು ಹಿಂದೆ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ರು. ಅವ್ರುನು ಅವ್ರಿಗೆ ಪಾಠ ಅಲ್ವಾ ಅಲ್ಲ ಹಿಂದೆ. ಸೊ ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ಮೇ ನಾಟ್ ರೀಚ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ಸ್.
My lord, serial number 37.
ಒಂದೊಂದಾಗಿ ಕರೆದು ಬಿಡ್ತೀವಿ ರೀ ಅವ್ರದ್ದು ಬಿಟ್ಟು. ಈಗ ಯಾರು ಇದು ದಿಸ್ ಇಸ್ ಸೀರಿಯಲ್ ನಂಬರ್ 25 ಅಲ್ಲ 28 ಮಧುಕರ್ ದೇಶಪಾಂಡೆ 28 requested list in the next week. 29 NC Baswaraju SP Shrikant list in the next. Is there any urgency? 2020 date given matter. Origva Baswaraju no representation for the petitioner. List after 2 weeks. 2 weeks agtide ಮತ್ತೆ vacation ಬಂದ್ಬಿಡುತ್ತೆ. Yes, 30 31 adjourned. Number 32 next.
Lord, I appear for the respondent in this matter.
Urgency 2010 ನಮಗೆ urgency ಅಷ್ಟೇ. 2010
This matter was heard, my lord, because nobody appeared for the petitioner side. This matter was kept.
You are for respondent. Petitioner counsel is there.
Last time must.
List. Then before vacation ಆಗುತ್ತಾ? As requested list on ಆಯ್ತು ಒಂದು second week of 12/4.
Much over.
Number 33 VS Naik K Mohan Kumar for respondent.
In this case, I am appealing for the respondent, my lord. Senior is appealing through video.
Lord, we already filed our written submissions.
33 leave ಇದೆ ಕಸ್ತೂರಿ ಅವರು.
I am appearing for Mr. Mohan Kumar, for the petitioner in the connected matter. Ours is the earlier matter. We have filed our written submissions.
Okay.
I said he will file his submissions. Avaru mail ಮಾಡಿಲ್ಲ.
ಅವರು ಇನ್ನೂ ಮಾಡಿಲ್ವಾ? ನೀವು ಫೈಲ್ ಮಾಡಿ ಮುಂದಿನ ವಾರದಲ್ಲಿ ತಗೊಳ್ತೀವಿ ಇಬ್ರು.
ಆಯ್ತು, ನಂದು ರೆಡಿ ಇದೆ, ಆಲ್ರೆಡಿ ಫೈಲ್ಡ್ ಲಾಂಗ್ ಬ್ಯಾಕ್.
ರೆಸ್ಪಾನ್ಸ್ ಕೌನ್ಸಿಲ್
ವೆರಿ ವೆಲ್.
ಎಸ್, ನೀವು ಹಾಕ್ಬಿಡಿ ನಿಮ್ದು ಸಿನಾಪ್ಸಿಸ್ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸಿನಾಪ್ಸಿಸ್. ಎಷ್ಟು ಡೇಟ್? 33
ಮಚ್ ಒಬ್ಲೇಜ್.
Number 35 Kyarana Nagaraj Reddy.
ಈಗ ಪಾರ್ಟರ್ ಮ್ಯಾಟ್ರ್ ಇದೆ ಒಂದು ನಮ್ದು. ಈಗ ಅವರು ಬಂದು ಸುಬ್ಬರಾವ್ ಅವರು ಇದನ್ನ ಕೇಳ್ತಾ ಇದಾರಲ್ಲ ಪ್ರೆಸಿಡೆನ್ಸ್. ಪಾರ್ಟೆಡ್ ಇದ್ದೇ ಅಲ್ಲ, ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ. ಯಾಕಂದ್ರೆ ಪಾರ್ಟೆಡ್ ಅಂತ ಬಂದಿಲ್ಲ, ಅದಕ್ಕೆ ಹಾಗಾಗಿಲ್ಲ. ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಲಿಸ್ಟ್ ಆನ್ 28 20 ಸೀರಿಯಲ್ ನಂಬರ್ 31 ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ ಮೊದಲೇ HR ಅವರೇನೋ ಏನು ಸಮ್ ಡಿಫಿಕಲ್ಟಿ ಏನೋ ಹೇಳಿದ್ರು. ಫೈನಲ್ ಇಯರಿಂಗ್ ಡೇಟ್ ಏನಾರ ಕೊಟ್ಟಿದ್ವಿ 29 ಅಲ್ಲ, ಅದು ಸೈನ್ ಆಗ್ಬಿಟ್ಟಿರುತ್ತೆ. ನೀವು ಇನ್ನೊಂದು ಮತ್ತೆ ಅವತ್ತಿನ ದಿವಸ ಕೇಳ್ಕೊಂಡು ಅಥವಾ ಯಾರಿಗಾರ.
I appear for the petitioner.
Consideration of interim prayer. ಏನು ಚಾನ್ಸ್ ತಗೊಳ್ತೀರಾ ಹವಾಲ್ದಾರ್ ಅವರೇ? ಅವರೇನೋ ಸುಬ್ಬರಾವ್ ಅವ್ರ ನಿಮ್ಗಿಂತ ಹಳೆ ಮ್ಯಾಟ್ರು.
Kindly put it in the second week of April, my lord.
Second week of April. 12/4.
Much obliged, my lord.
Yes, Serial number is
55. Serial number 25. Maitri Krishnan, Adesh Kumar S.
Yes.
Synopsis when did you submit the synopsis?
It is there, my lord. It is, I think, almost on the, when we filed the writ petition itself, we have filed it.
Yeah. Along with writ petition, there is one synopsis. Have you filed any?
ಅದು ಒಂದು ಇನ್ನೊಂದಿದೆ ಏನು ಅಂತ ಹೇಳಿದ್ರೆ I will put the case in a very brief manner, my lord, first at your lordship. ಆಮೇಲೆ ಡೀಟೇಲ್ ಆಗಿ ಒಂದೊಂದೇ ಹೇಳ್ತೇನೆ.
Yes, yes.
The petitioner before your lordship, my lord, in 874 of 20 was, my lord, an engineering graduate who got a postgraduate from UPenn, that is from a well-known university in the United States, was employed by the second party, my lord, in 2010.
Yes.
I'm sorry, it is 2011. On 23/3/2011. Then, my lord, on 13/8, they put, there was, I am putting it in brief, my lord, the earlier history and all that time, if necessary, I will go to. In 2012, in August, my lord, on the 2nd of August, 2012, the management asked him to put his papers, asked him to sign and quit the job. My client, this is a multinational company, my lord, having it's a $1 billion company. I think also came in Forbes. These multinationals, my lord, they want their names to be.
We have to decide the question of law based on the facts. Or status ನಮಗೆ ಏನಾಗಬೇಕಾಗಿದೆ?
ಅದು status ಬೇಕು, because that is how they treat the workman here. One of my argument is this multinational they treat our Indian officers, my lord, as if you can come and you can throw. I have got a great.
First you come to the facts.
Yes, that I will come. I will come to their lordship. Then he refused. Since he refused, my lord, then he filed a suit in OS number 5885 of 2012, asking for a permanent injunction restraining the respondent from terminating his service. Then, my lord, they filed an application. They filed an application, my lord, saying that the suit is not maintainable and it should be rejected, the management. During the course of the proceedings, that is, my lord, in the civil court, that is, my lord, the management paid me the dues which I was entitled to, and I took that amount without prejudice to my right to challenge the termination. Then ultimately, my lord, the IA filed by the management saying that the suit was not maintainable was accepted and the plaint was rejected. Your lordship may kindly see. Plaint was rejected, saying that I have got a remedy under the Industrial Disputes Act. Then, my lord, I filed a claim petition before the Second, I have labor court. No? Before the labor court, my lord. Before the second labor court.
Additional labor code.
Yes. Second additional labor code. In the second additional labor court, my lord, they filed a petition saying that he is not entitled to raise a dispute. And ultimately, my lord, 3 issues were framed. That is, I will take your lordship those issues if necessary. However, the labor court, my lord, rejected my reference or the claim filed by me on the ground that there was a settlement between the parties. That is, he has paid me the amounts and that payment, my lord, amounts to a settlement under the Civil Procedure Code. So I am not entitled to raise a dispute, my lord, under section 10(4)(a). So he rejected the reference. Then, my lord, I approached this court. Your lordship may kindly see in WP number 62,442 of 2016. Your lordship may kindly see. And this honorable court set aside that order of the labor court and remanded the matter, my lord, for fresh adjudication. Now, in the fresh adjudication, my lord, the labor court on merits held me, my lord, there were 3 issues. Your lordship may kindly, the 3 issues were, please get me the 3 issues. My lord, just, may I request your lordship, page 31.
Yes.
Whether the first party proves that he is a workman within the meaning of section 2(s) of the ID Act. That is the first issue. The second issue is whether the second party is justified in terminating the first party from the service in pursuance of the impugned order dated 2/8/2012 is justified. Whether the first party is entitled to relief, which he has claimed. Now, my lord, the labor court holds, my lord, on both the issues in my favor. Labor court holds that I am a workman within the meaning of section 2(s). The labor court also holds that my termination is unjustified. But the labor court holds I am not entitled for any relief. So I have approached this court, my lord, for denying me the relief, my lord, after holding on the main issues in my favor. Now, my lord, the reasons given by the labor court for holding that I am not entitled for relief is, I have not stated anywhere that my services have been terminated. So I am not entitled for any relief. I don't know, very strangely, the reasons which the labor court has given after holding on issues, main issues in my favor, my lord, that your lordship gets it at page 55. I'll just read that portion and then I'll take your lordship where the management again and again said my services have been terminated. Issue number 3, the cardinal principle is the person who approaches the court should come with clean hands. I do not know where does he get If the termination is unjustified also, I must have my clean hands. Initially, there was only one prayer in the claim statement dated 18/1/13 filed by the first party, which reads as follows. Wherefore, the first party workman most respectfully prays that this honorable court be pleased to pass an award granting reinstatement with the full back wages and continuity of service from the date of termination in the post of staff software engineer in the second party company for his illegal termination, and additionally award suitable exemplary costs, compensation, suitable compensation against the second party company for illegalities committed by them against the first party workman under several labor laws, under the provision of the Industrial Disputes Act, in the interests of justice and equity. After filing of counter statement by the second party, the first party filed IA number 3 on 1/10/2013 under Order 6 under Order 6 Rule 17 of CPC to amend the claim statement and to insert one more prayer in prayer column of the claim statement, as could be seen from the order dated 11/3/2014. On submission of the advocate for the second party, IA3 was allowed and the first party has carried out the amendment in the prayer column of the claim statement. Hence, amended prayer reads as follows. To pass an award holding that the second party has violated the provisions of section 25 so and so, and that the claimant is not gainfully employed from the date of termination and is entitled to reinstatement and for full back wages with all consequential benefits. As second party company employs more than 100 workmen and the provision of section chapter 5B and section 25 and other provisions of the Industrial Disputes Act being applicable. As per section 25 the second party company has not obtained prior permission of the appropriate government and has not given 3 months notice or 3 months wages in lieu of notice. Therefore, the second party has controverted and chapter 5B of this so and so. Then, my lord, in this case, the first party has produced 12 documents. Exhibit W1 is an email which was prior to raising the dispute. Exhibit W2 is also a memo filed on behalf of the plaintiff. Exhibit W3 is the performance bonus given to the second party by the first party for financial year. Exhibit W4 is the technical appreciation for the work done by the first party. Exhibit W4, said document is dated 2/5/2012, which is prior to the dispute. Exhibit W5 is email correspondence between the first party and the second party, which are prior to raising the dispute. W6 is parking fine receipt. Exhibit W7 is a response from ACP Traffic, Bangalore RTI Act, dated 23/12/2013, given to the first party. Exhibit W8 is the governance complaint dated, given by the first party to the second party, which is also prior to the present dispute. Exhibit W9 is email dated 4/4/2012 between the employees of the second party and the first party. W10A is also the email request by the first party to the second party to obtain purported evaluations, and copy of the order dated passed in writ petition number by dismissing the writ petition filed by the second party, which was challenged in the order dated passed by the court in IA number 1. In W12 is the operating values of the second party, so and so. W1 to W2, there is no termination order. Which order is challenged in this dispute by the first party is not known. The prayer of the first party is nothing but vague. At the first instance, the first party sought to pass a reward granting reinstatement with back wages and continuity of service. In fact, alleged termination letter is not produced. Without setting aside any alleged termination, how he is entitled to the order of reinstatement is not known. First party is not seeking set aside of the termination order. In the additional prayer, the first party is sought to hold the second party has violated 25, 25F and 25N and of the Industrial Disputes Act, and that the first party is not gainfully employed from the date of termination and is entitled to reinstatement. The first party is not sure as to when the second party has terminated it. In paragraph 11 of the affidavit, has deposed his illegal termination by the second party company is stigmatizing to him, and it has crippled his ability to get alternative suitable employment in the light of the second party falsely stigmatizing his performance and character and reputation, and second party has refused to give him relieving letter, certificate of good conduct and performance at the close of all the possibilities of future employment, due to which he is unemployed even till today. Nowhere the affidavit has stated as to in which companies which he has made an attempt to get the job. Following the affidavit of the evidence of the first party of the is lacks bona fides. As could be seen from this statement, his address was mentioned in the cost title, HSR Layout, Bangalore, but in the affidavit evidence in the case, cost title, first party furnished Alipur Township, Pappalagudda, Telangana. This fact clearly shows that at the time of raising the dispute, the first party was staying in Bangalore, and subsequently it appears that he shifted his residence to Telangana, erstwhile Andhra Pradesh. Even in the cost title of the writ petition, the first party has given his Hyderabad address as mentioned in the cost title of the affidavits. First party has failed to prove that he is not gainfully employed. In view of the above discussion, it is needless to mention he is not entitled for any relief. Learned counsel for the first party has relied upon the following decisions. Then, my lord, all these are decisions. Second party has relied upon all these decisions. Then, my lord, lastly, I have perused the decisions. The principles and the ratio of the above decision are adopted to the facts and circumstances. Accordingly, I answer so and so negative. The claim petition is rejected. I have never read, my lord, we have said reinstatement. Now please see, my lord, at several places, he has, it is the management's contention, my lord, that they have terminated my service. And my remedy is under the Industrial Disputes Act. I had gone to the civil court. Now please see, my lord, that order. Then I'll take your lordship the other things. You don't take it. You say, original, where is this thing? Give me this. Lord, please see the order of the civil court where I had gone. 183, isn't it? Is it great? Page. Now, my lord, now please turn to 1 minute. ಯಾವುದು ಪೇಜು just 1 minute, my lord. Suit to dismiss ಮಾಡಿದ್ವಿ ಅದು. ಇದರಲ್ಲೇ ನೋಡಿ, ಇದರಲ್ಲೇ 1 minute, my lord. Your lordship may give that pagination ಇಲ್ಲಿ ಸ್ವಲ್ಪ ಹೆಚ್ಚಿಗೆ ಆಗಿದೆ. Exhibit to produce ಮಾಡಿಲ್ಲ. ಏನ್ರಿ ವಾಟರ್ ಅಸಿಸ್ಟೆನ್ಸ್ you give us? ಹೌದೌದು ಅಲ್ಲ, ಸಿವಿಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ಪೇಜ್ ಕಾಪಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಯೂಸ್ ಮಾಡಿಲ್ಲ. M1 to M7.
So which order are you looking for, sir? I'll raise.
That is a civil court's order.
I'll give you, sir. Give me 1 minute.
I'm just trying to.
Yes, yes. I will assist.
Writ petition annexures, it is not there.
Allah, civil court nalle, your lordship may kindly see.
There was an admitted fact, Allah. He's.
Allah, admitted fact nalle.
That civil court has no jurisdiction.
ಅದು ಇಂಪಾರ್ಟೆಂಟ್ ನನಗೆ, ಬಿಕಾಸ್ ಅದರಲ್ಲಿ ಟರ್ಮಿನೇಷನ್ ಆದ್ರೆ ಮಾತ್ರ ಇದು ನಾನು ಸಿವಿಲ್ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕು ಅಂತ. ಅದೇ ಎಷ್ಟು ಪೇಜು? ಪೇಜ್ ಮೈ ಲಾರ್ಡ್ 126.
126 of writ petition.
ಅಲ್ಲ ಅದು ಅವರ ಇದರಲ್ಲಿ ಅವರದು ರಿಟ್ ಪಿಟಿಷನ್ ಇದೆ, ಅದರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ನಾನು ಹಾಕಿದ್ದೀನಿ, ನನಗೆ ಪಕ್ಕ ಸಿಕ್ಲಿಲ್ಲ ಅದು.
ಇಲ್ಲ, ಇದರಲ್ಲಿ ನಿಮ್ಮ ರಿಟ್ ಪಿಟಿಷನ್ ಅನ್ನೆಕ್ಸರ್ಸ್ ಅಲ್ಲಿ ಕಾಣ್ತಿಲ್ಲ.
M5 ಮಿಲೋಡ್, M5 ನೋಡಿ.
126.
Okay, got that order. OS 5885/2012. Here, ಯಾವ ಪೇಜ್?
ಸಾರಿ
ರಾಮಚಂದ್ರಯ್ಯ, ಇವರು ರಾಮಚಂದ್ರನ?
ಹೌದೌದು, ಇವರು ರಾಮಚಂದ್ರಯ್ಯ, ಅವರು ರಾಮಚಂದ್ರಯ್ಯನೇ. ರಾಮರಾಮನೇ.
ಇವರು ರಾಮಚಂದ್ರ, ಅವರು ರಾಮಚಂದ್ರಯ್ಯ.
ರಾಮಚಂದ್ರಯ್ಯ. My lord, it is there. Ma'am, could your lordship may kindly take his writ petition, my lord? In that it is election.
We are holding that. We got that.
Your lordship got it, my lord? Yes. Now please see, my lord. Yes. That is, my lord, I am sorry. In our paper book, it is 183.
Mr. Subbarao, in your petition, it is 183.
183. I got it.
183.
Yes, yes. My lord, the only point the lordship got in 183, my lord.
159 to 262, K1 to K27 ಅಂತಿದೆ, ಅದರಲ್ಲಿ ಬರುತ್ತೆ ಅದು.
ಹೌದೌದು.
The annexure, the description annexure was not found.
They put it together as a bunch, so that's why it's causing little difficulty to pull out the document.
ಅಲ್ಲಲ್ಲ, ಅದು ಏನಾಯ್ತು ಅಂತ ಹೇಳಿದ್ರೆ, ಇದು ಕೇಸು ಹಿಯರಿಂಗ್ ಬರುವಾಗ ಸುಮಾರು ದಿವಸ ಆಯ್ತು. ಹಿಂದೆ ಎಲ್ಲ ಪೇಜ್ಗಳೆಲ್ಲ ಸರಿಯಾಗಿ ಇತ್ತು ಹಾಗೆ. I am sorry, my lord, I made your lordship wait. Now please see at 184, my lord. In support of this application, this is application by the management. In support of the application, head of so and so, In paragraph 8 of the plaintiff claims that he is a workman as per section 2S of the Industrial Disputes Act. According to him, he cannot be terminated by the defendant company without due process of inter alia by issuing a show cause notice in view of the specific contention of the plaintiff that he is a workman and his employment is controlled by the statutory provisions of the Industrial Disputes Act. Plaintiff cannot maintain the present plaint. Plaintiff has claimed his status of employment with the defendant company under a letter of appointment dated 1/3/2011 and employment agreement dated 23/3/2011, as the status of the plaintiff would be based on foregoing documents. The relief to grant permanent injunction cannot be granted by this court. The contract of personal service not specifically enforceable under the specific act. Further, plaintiff has sought for a mere injunction without consequential reliefs. Plaintiff has filed objections. Next, my lord, you will take it. Now, my lord, the reasons. The reasons is this, my lord. In this case, it is contended that the suit is barred by law, and the plaintiff being a workman under the Industrial Disputes Act, he cannot maintain the present plaint. Plaintiff has sought for the relief of permanent injunction restraining the defendants from terminating his services as software engineer in the defendant company, and also restraining the defendants, their legal representatives, or any person claiming under or through them foregoing plaintiff to tender resignation. As could be seen from the pleadings, plaintiff has admitted that he is entitled to approach the labor court when the termination is deemed to be complete and valid. The defendants keep on submitting that the plaintiff is terminated with effect from 2/8/2012, which is not true according to the plaintiff. Please mark, my lord, the words there. His services are terminated according to the defendant from 2/8. That is their assertion, defendants. Learned counsel appearing for the defendant as vehemently contend contract of employment for personal service could not be specifically enforced. The relief sought for in this case by the plaintiff is nothing but the relief of reinstatement and back wages only under the Industrial Disputes Act. In Karnataka, Bank versus Gopal Krishna Rao, that is the authority, my lord, on which Relevance is placed. Of course, I argued that matter also, my lord, incidentally. If the plaintiff averments are read, the plaintiff clearly discloses that if the relief sought for by the plaintiff is granted, it amounts to imposing the plaintiff on the defendant. Please mark, which relief cannot be granted. If the relief is granted, would indirectly mean the court is assisting the plaintiff on continuing in with his employment with the defendant company, which is nothing but enforcing the contract of personal service. Thus, none of the relief sought in the plaintiff can be granted in the plaintiff under the law by the court. Under these circumstances, the suit filed by him by order dated so and so, under these circumstances, I am of the considered opinion that the application deserves to be allowed. Accordingly, the plaintiff so and so. There, my lord, the consideration is that he has been terminated. His relief, my lord, is under the Industrial Disputes Act. Thereafter, my lord, I go to the labor court. In the labor court, first, my lord, they contend that that is a settlement. Then the matter is remanded. And after remand, the court holds it is terminated, is unjustified. Now I will take your lordship. Please see the pages. Now, my lord, please see at page 80. Please see the paper book. This is my claim statement, my lord, which I filed, which was filed. I'm sorry.
Page 80 is the counter.
That is the counter. They themselves say. Will you please see, my lord, at paragraph 6, at page 80, counter. It is submitted that the first party is employment being terminated as per the terms of contract of employment, and that being a termination simpliciter, the first party is bound to sign certain deeds and documents sufficiently collecting his settlement dues. Now please see paragraph 8. Paragraph 8. It is submitted that similarly, upon termination of employment of the first party, as per clause 11 of the letter of appointment, he is restrained from solicit to assist, otherwise take any customers or suppliers so and so. The specific case, my lord, is I am terminated. And the learned judge says, my lord, there is no order of termination. There can be oral termination. There can be neck me out. I can also, my lord, your lordship may kindly see in the industrial law, non-employment. Please see, my lord, section 2K. Employment, non-employment, terms of employment, conditions of service. Section 2.
Yes.
The language, my lord, is so wide. Section 2K, industrial dispute means any dispute or difference between employers and employers, between employers and workmen, and between workman and workman, which is connected with employment, non-employment, or terms of employment, or with the conditions of labor. It is so comprehensive. Every kind of industrial dispute, my lord, can be adjudicated by a labor court. Now, please see, my lord, the fallacy of the reasoning of the learned judge. He says, of course, one of the issue that was raised was that I am not a workman. He holds that I am a workman. Then the issue is whether the termination is justified. Now, I think I read to your lordship that those issues also, I mean,
yes.
Yes. Issue would be done. What
is there issues?
Issue nalle ide. Second issue nalle, ನನಗೆ ಇದು ಆಶ್ಚರ್ಯ ಏನು ಅಂತ ಹೇಳಿದ್ರೆ, whether the second party is justified in terminating the first party ಅಂತ ಹೇಳಿದ್ರೆ, ಇನ್ನು ಇದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಯಾವ. You have not questioned, my lord, the employment. The management says, I have terminated you. What is the reason, my lord, ultimately? Whether the second party is justified in terminating the first party from service in pursuance of the impugned order dated. Impugned order. Termination is 2/8. The issue is that. The issue is held in my favor. They themselves say, my lord, you are not a workman after 2/8. Please see. Please see, my lord, at the end of page 54. Last, if the submission of the learned counsel, I mean last 54ನೇ page. If the submission of the learned counsel to the first party is taken into consideration, then there will be no evidence on the side of the second party. Since the learned counsel for the second party in his arguments submitted on 2/8 is not the date of termination, and there is no cause of action further to file this dispute. Clearly goes to show that the second party has not proved issue number 2. Accordingly, it is answered. So, termination is unjustified. Management says, I have terminated you. Now issue number 3 is after all that. There is only one paragraph, my lord. Is only 43, paragraph 43 is the reasoning. That is at page 59.
You read that already?
How? Page 59. So my submission to your lordship is this. I need, since the other issues have been held in my favor, I need not trouble your lordship. I have given a list of authorities where, my lord, termination is held to be bad. I am entitled to for reinstatement and other ದಪ್ಪದಲ್ಲಿ ಹೋಯ್ತು ಒಂದು 20 ಅಥಾರಿಟೀಸ್ ಇದ್ದಲ್ಲಿ ಕೋರ್ಟ್ಗೆ ಕೊಟ್ಟದ್ದು ಯಾವುದಿದಲ್ವಾ. I have given a list of authorities, my lord. On 12/3/21.
Yes. Yes.
The authority, my lord, is, your lordship will kindly see, termination being found, termination. Please see, my lord, the authorities serial number 16 at page 131. You know,
33.
Paragraph 5.
Paragraph 33.
So page 152. I am sorry, 131. 131 page. My lord, paragraph 33, my lord. At page 152. In the case of wrongful terminations, 153ನೇ page, top.
Yes.
Yes, sir. The Supreme Court judgment. In the case of wrongful termination of service, reinstatement with continuity of service and back wages is the normal rule. The aforesaid rule is subject to the rider, and while deciding the issue of back wages, the adjudicating authority or court may take into consideration the length of service of the employees, workman, the nature of misconduct, if any, found, proved against the workman, the financial condition of the employer, and similar other factors. Now, in this case, my lord, they have not pleaded, they do not have the capacity to pay the back wages, nor have they said, my lord, I am gainfully employed. No proof has been given. Now, 3, ordinarily an employee workman whose services are terminated and who is desirous of getting back wages is required either to plead or at least make a statement before the adjudicating authority or the court of the first instance that he was not gainfully employed or was employed in lesser wages. If the employer wants to avoid payment of full back wages, then it has to plead and also lead cogent evidence to prove that the employee, the workman, was gainfully employed and was getting wages equal to the wages he was drawing prior to the termination of the service. This is also because it is the settled law that the burden of proof of the existence of a particular fact lies on the person who makes a positive averment about its existence. It is always easier to prove a positive fact than to prove a negative fact. Therefore, once the employee shows that he was not employed, the onus lies on the employer to specifically plead and prove that the employee was gainfully employed and was getting the same substantially similar emoluments. The cases in which the labor court, then my lord, I do not want to trouble the other, then the other case is, your lordship gets it in 17, that is Harjinder Singh, page 156, my lord. Yesterday, your lordship may kindly remember, yesterday I said I forgot to cite that decision. Your lordship may kindly see. That's the case. Harjinder Singh versus Punjab State Warehousing Corporation. I think afterwards, my lord, I sent that decision also to your lordship in yesterday. Now please turn to page, that is, my lord, 156, the case commences.
1 second. Yes, 156. Huh?
156.
Yes.
Now, 173. Para number. Yes. Para number 30, my lord. Of late, may I read, my lord?
Oh, yes.
30, paragraph 30 and 31. Paragraph 30. Of late, there has been a visible shift in the court's approach in dealing with the cases involving the interpretation of social welfare legislation. The attractive mantras of globalization and liberalization are that becoming the reasoned atre of judicial process, and an impression has been created that the constitutional courts are no longer sympathetic towards the plight of the industrial and unorganized workers. In large number of cases like the present one, relief has been denied to the employees falling in the category of workmen who are illegally retrenched from service by creating bylanes and side lanes in the jurisprudence developed by this court in 3 industrial decades. The stock plea raised by the public employer in such cases is that the initial employment and engagement of the workman, of the employee was contrary to some of the other statutes, and in that reinstatement of the workman will put unbearable burden on the financial health of the establishment. The courts have really accepted such unmindful of the accountability of the wrongdoer and indirectly punished the tiny beneficiary of the wrong, ignoring the fact that he may have continued in employment for years together and micro wages earned by him that he only source of livelihood. It need not be emphasized that if a man is deprived of his livelihood, he is deprived of his fundamental constitutional rights, and for him and goal of social and economic justice, equity of status and opportunity, there and freedoms enshrined in the Constitution remain illusory. Therefore, approach of the courts must be compatible with the constitutional philosophy, with the constitutional of which the directive principles of the state policy are an integral part, and justice due to the workman should not be denied by entertaining the specious and untenable ground put forward by the employers of public so and so. In the result, so and so. Of course, the other paragraphs also, my lord, I do not want to read, of Justice Ganguly's decision, which he has added, is a very interesting. I do not want to waste the time of the court, but Justice Ganguly, who has added to Justice Simha's judgment, my lord, gives us an idea. Sometimes, my lord, the basic structure of the Constitution, where a common man also has, my lord, some rights. Sometimes, my lord, every one of us forget. He says, he has reminded us that we cannot, common man also is equally important. He also contributes, my lord. As a matter of fact, it is he who contributes to the production of the wealth of this country. Now, my lord, subject to the argument of the other side on all the other issues, my lord, I conclude my case of his writ petition and other things.
Can
He has also filed a
request for Monday, my lord? Because tomorrow, day after, we have a part heard matter, my lord, before Court Hall 6 and Dharwad, my lord.
We have listed several matters. And we have an election.
I think I do not know whether it's a Saturday is a working day, my lord.
No, it's not a working day.
ನಮ್ಗೆ ಒಂದು ವರ್ಕಿಂಗ್ ಡೇ ಅಂತ ಯಾರೋ ಹೇಳ್ತಾ ಇದ್ರು, ಅದಕ್ಕೆ ಕೇಳ್ತಾ.
ಅವರು ನಿಮ್ಮ ಆಫೀಸಿಗೆ ಇರ್ಬೇಕು.
I'm sorry, my lord.
Date heard the petitioner's counsel as requested by response counsel. List on fourth.
Obliged, man.
Fourth, my lord.
But I should say one thing, my lord, on a lighter vein.
Yes.
The petitioner for whom learned senior counsel argued has only created to the wealth of adding cases, not to the wealth of the nation.
Oh, good. I thought that you are right. You are taking away the wealth of the nation. You are right. Multinationals take away the wealth.
Petitions 14294/2013, 8th February 8th February. I have given a proposal for a monetary settlement. Mr. Withdrawal study, Mr. Muralidhar Krishna. Here I took a consent. Unfortunately, I'm not blaming anybody. It has not been listed. So there is a free possibility of a matter being settled.
Correct. You want it to be listed. ನೀವು ಇದು ಮಾಡ್ಕೊಂಡು ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡು ಬಂದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡ್ತೀವಿ.
I agree. ಆ ಟರ್ಮ್ಸ್ ಅವರು ಏನು ಅಂತಂದ್ರೆ ಮುರಳೀಧರ್ ಏನು ಹೇಳಿದ್ರು, ಸರ್ ಕೋರ್ಟ್ ಲಿಸ್ಟ್ ಆದ್ರೆ ಅವ್ರ ಮಕ್ಕಳನ್ನೆಲ್ಲ ಬರ್ತಾರೆ,
ಅದ್ಯಾವ ನಂಬರ್ ಬರ್ತಾರೆ
ಮ್ಯಾನೇಜ್ಮೆಂಟ್
ಅಲ್ಲ, ಅದು ಅಲ್ಲ ಮಂಡೇ ಬಿಟ್ಟು ಇನ್ನೊಂದು ಸರ್ ಅಲ್ಲ, ಅದು ಹಿಯರಿಂಗ್ ಆಗೋದಿಲ್ಲ ಅವತ್ತು, ಅವ್ರಿಗೆ ಅದು ಲಿಸ್ಟ್ ಆಗ್ಬೇಕು ಅಷ್ಟೇನೆ. ಟ್ಯೂಸ್ಡೇ ಹಾಕೊಳ್ಳೋಣ, ಯಾಕಂದ್ರೆ ಮಂಡೇ ಎಲೆಕ್ಷನ್. You want only a caveat to your client and their clients. You want only a caveat to your client and their clients by listing. ಗೊತ್ತಾಯ್ತು. ಏನೋ ಬಂದಿಲ್ಲ ಅಂತ ಲಿಸ್ಟ್ ಮಾಡೋದಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿದ್ದೆ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 1 week ಅಂತ ಆಗಿದೆ. ಯಾವ ಇಯರ್ ಇದ್ದದು? 2013. ಅಂದ್ರೆ ಈ ವಾರ ನಾವು ಎಂಗೇಜ್ಡ್ ಇನ್ ಸಮ್ ಅಂದ್ರೆ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ವರ್ಕ್, ಅದಕ್ಕೆ ನಾವು ಓಲ್ಡ್ ಬಿಟ್ಟು ಬೇರೆ ಲಿಸ್ಟ್ ಡೇಟ್ಗೆ ಬಂದ್ಬಿಟ್ಟು ಬೇರೆ ಹಾಕ್ಬೇಡಿ. ಪ್ರಾಬಬ್ಲಿ ದಟ್ ಮೇ ಬಿ
all these matters ಸುಮಾರು 6-7 ವರ್ಷದಿಂದ
ಕರೆಕ್ಟ್. ನೀವೆಲ್ಲ ಬ್ರೀಫ್ ಆಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಕಡೆಗೆ ಒಂದು ಮೊದಲು ಸಿನಾಪ್ಸಿಸ್ ಕೊಟ್ಟು ಮಾಡಿದ್ರೆ ಆಗುತ್ತೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಬೇರೆ ಏನು ಕೇಸ್ ಆಗೋದಿಲ್ಲ, ಡಿಸ್ಪೋಸಲ್ ಆಗೋದಿಲ್ಲ. ಹೇಳಿದ್ವಲ್ಲ, ಈ 1 week ಅಲ್ಲಿ we were also tied up with some administrative work.